Good morning, good morning, good morning. Or should I say, hear ye, hear ye, hear ye. I'm back from the normal studio, back off the road after a very long travel day, but it's time to begin week 8. It's Monday, June 9th. It is day 29. 29 of the Karen Reed retrial. And the question looming large is this the last week of trial? It very well may be. Are we going to see the jury get this case for deliberation? They were told 8 weeks, and then they're told, well, we can't tell you how long deliberations will take, but 8 weeks for us to give the case to you. Is that going to be sometime this week? Because we know the defense only have a few witnesses left that we anticipate them calling. So it very well may go to the jury on Friday. One of the things that has stuck out to me from last week's testimony from Dr. Wolfe, who will resume the stand this morning after they're done with arguments, whenever they're done with arguments, after they're done with all of that, was about the gasketing of the taillight. I'm still stuck here. The gasketing of the taillight was so interesting to me that we have finally heard definitively where the bumpy clear plastic came from, which is the interior pieces of the taillight. I was like, what? I was shook. 2 trials, 8 weeks, and we finally hear that the inside portion of the taillight is what that plastic came from, and that 2 layers of taillight have to be broken to get there. It's not just the outer red layer of plastic that was broken, or a polycarbonate or acrylic or whatever he called it. Wild, wild stuff. So we're going to get to court. You're watching and or listening to live trials with me, Emily D. Baker, the lawyer that's breaking it down for all of you. Thank you, by the way, for making this the #1 place to watch live trials. And I think yesterday we were like the third most popular show on YouTube in the US. So let's go, law nerds. Let's go. Y'all are just ready. Y'all are just ready. I'm ready too. So we're going to go to court. We've left ourselves Zoom room. I'm sure we're going to need it. I've got breakfast. I've got a homemade cappuccino with a new mug. And when I saw this, I saw it at the same time as my youngest, and he went, "You don't need another mug." I was like, touche. I 100% need another mug. And he's like, "Why?" And I'm like, "This one's 16 ounces. My other one's 14 ounces. And Griffin just looked at me and he was like, "That's not a reason." I'm like, "Right, it's not. It's because I want it, and it's pretty." But we will talk about family travels another time, because it was a busy weekend, but it was good to see everybody and celebrate my dad's birthday and all the things. So hello, family. It's good to see you. It was good to see you in person, and we have arrived home. At some point, there was a minimal amount of sleep. It's fine. It's all fine. Who needs sleep? Nobody needs sleep. It's like I'm in trial myself. I am just as tired as if I was doing it myself at this point. But I get to wear my Metallic Couture shirt and sit in my office instead of being in a sweltering hot courtroom, which we should go to now. Let's go, law nerds. Good to see you. Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time, so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. Also, we will probably talk about more things, but hold on, Your Honor. As a housekeeping note, I'm supposed to have all of the weathers today. If I disappear, I'll be back. We have a generator. But if there are glitches, it's probably on my end. You know, we're supposed to have all the weathers today. It will be fine. It will be fine. It will be fine. Sammy said, "I'm right on time." Yes, you are, Sammy. You are right on time. It is perfectly divine timing. They are going to do motions. So hang in there. We're going to be doing motions this morning. I'm sure the jury's thrilled.
Hi, good morning.
That's not your internet. That's the court feed. I don't know what's going on. The court fee was stuttering all morning.
So I just saw
from what I saw.
A transcript that was placed here on
Okay, that's a lot
maybe
to read in the
reference
morning.
this morning, and there's a motion to limit Dr. Rentschler that I just got that I'm not prepared for. So that will do.
I'm not prepared for it either. Dr. Rentschler was limited last time, then the rules changed. No limit. No limits, no breaks. Just here, how about this? Your Honor, I've got you. We've been watching this whole trial. I mean, I'm not a judge. I'm not licensed in Massachusetts, but just denied. Just deny the motion to limit Dr. Rentschler. Emily, where's your gavel? Right here. Just, that's it, denied. Let's keep going.
Do later today, okay?
Oh, right. Goody. We'll deal with that later today. Yay for us. Yay for us to limit Dr.
So the
Rentschler's
Commonwealth's
testimony.
motion to
He'll be after
call
Dr.
witnesses
Wolfe.
in rebuttal.
They're allowed to
I've
do
read
that.
everything.
Yeah, that's going to
Ms.
happen.
Little, I appreciate you getting your opposition to me. I think I had it by Saturday morning, so I appreciate it. I read all the cases on it. Does the defense want to be heard any further on
Yeah,
this?
this is going to be allowed to happen. Yeah. We get to hear from Ms. Little this morning, though, so that's a delight for all of
Okay.
us.
With regard to Dr. Crosby and
Also, for all of you that just went, of course, Miss Little. Of course, Miss Little got this handled. Yes. Yes, of course she did. Mm-hmm. Mm-hmm.
Speak into a microphone. Speak into a microphone.
Good morning, Miss Little. It's good to see you.
the Commonwealth has been on notice that the defendant
Love the Manny.
intends to present a defense regarding the arm injuries, that this was caused by a dog bite. They have been on notice of that, not just for months, but for years.
Also, I can never rock a bang. I'm loving like the curtain bang on the side. I'm here for all of it.
That was presented at the first trial. The Commonwealth does not have a right to rebut information that they have been on notice of from the start of the case. So their decision to wait for rebuttal to call these two witnesses is improper, and we're asking the court to exclude.
If it doesn't come up until you guys bring it up, though.
As it relates to Dr. Welcher,
That's not
the scope of his testimony,
just all.
our request is that that be limited to very specific information, specifically responding to the new testing that ARCCA
Totally
has
agree.
done.
Totally
As
agree.
the court knows, the Commonwealth has proposed a number of new testing ideas as well as information that is greatly outside the scope of what ARCCA intends to testify to. And so we're asking that the court limit their testimony from engaging
the
in
court
new
already
testing that
has.
has nothing to do with what ARCCA has testified about at this trial. With regard to Dr. Welcher's testimony, the court has made very, very strong rulings that
Yes.
Dr. Wolfe, as well as Dr. Rentschler, are not allowed to speak to the credibility of Dr. Welcher himself.
Oh, we just
and so
binged.
some of the
Thanks,
information that
guys.
the Commonwealth proposes is to directly attack the testimony of Dr. Wolfe and Dr. Rentschler. And under the court's rulings, we're asking that the court limit that scope as well.
And I told you I would.
Yeah.
Thank you.
All right.
Yeah.
That's all,
Brett,
Your Honor.
thank
The beginning of that was, hey, there are limits to what Dr. Welcher can testify to. He already testified. And the court said yes. And I told you I would. Yes, I would. Yes, I would. I told you I would. Yes, I would. And so I hope that that's what we will see. Because there's times the court has said, I'm going to do this. And then I'm sitting here going, WTF, that's not what we thought was happening. So, you know, asterisks. But yeah, Dr. Welcher, the Commonwealth's expert who testified during the case in chief and then in rebuttal, should only be limited to talking about new ARCCA stuff. However, there's a lot of new ARCCA stuff. So,
Thank you. Mr.
you
Brennan,
know,
do you want to be heard?
and the court reiterated, and I will.
Regarding DNA evidence, evidence cannot be rebutted until it is introduced because the defense has a number of potential ideas of areas of testimony. It does not compel the Commonwealth to try to anticipate or deflect attacks, especially if they're meritless. And so the issue of dogs and dog DNA does not become relevant until the defense calls a so-called dog expert. They raise the issue, it's proper grounds for rebuttal. there are three witnesses, Ms. Hartnett, UC Davis, and Dr. Crosby. If Dr. Laposata is precluded from testifying about dog bites, we would not call Dr. Crosby as a witness. However, regardless of what Dr. Laposata says, we would ask to call Ms. Hartnett and to call the witness from UC Davis. It is an issue that directly affects the assessment of Dr. Russell.
Who brought it up?
The expert they chose to call in the case in chief, and so we can now, from my perspective, properly.
He's saying that the defense brought it up. All of you are like, you're the first one who said yes. He's saying the reason that his argument is the defense brought it up because they called Dr. Russell, even though he's the one that asked about the DNA, but Dr. Russell is whom the defense called.
Rebut it. The second issue regarding Dr. Welcher, limited to the new information you will see from the testimony or have heard. Most of the testimony is new, but we understand it's limited. We don't expect Dr. Welcher to have a direct comment on the credibility of any witnesses, but he will address the tests, how he believes would be the proper procedure, and there'll be a number of issues that have been raised on direct examination, but he will not in any way have a comment on the credibility of the defense experts.
Also, when all of you say, how do the witnesses know when the Commonwealth is objecting? How do they see them? The witness stand is right there next to the court reporter where you see that binder. So when Brennan stands up, even if he just says objection quietly, he's like eye level with the judge when he stands up. So the witnesses can see him pretty easily, which is why we don't always hear the objections. I think this is helpful to the layout. It's a weird layout of a courtroom for me, but he's just like right there.
All right. So the case law supports me allowing this motion. I'm allowing the Commonwealth's motion.
The Commonwealth's allowed to have rebuttal witnesses, period. That's not shocking. Some of the testimony can be limited to what came up in the defense case in chief, but the Commonwealth's allowed to bring rebuttal witnesses, period. Just period. That's what the case law is. That's what the case law is almost everywhere. I can't imagine a place that it's not. So yes, they have the burden. They're allowed to do that. Civil cases, different. Criminal cases, yes.
So the motion for rebuttal witnesses is allowed. Mr. Brennan has said he will not call Dr. Crosby, depending on the testimony that comes in. So, all right, Jim, I'm just going to give you this.
So Crosby might not be called. And no, Laura asked, can the defense
All right,
rebut
so the motion
rebuttal?
regarding
No.
the testimony of Dr. Laposata.
Tina said, is this the last week of trial? Most likely. Yeah, most likely. Michelle, sir, rebuttal is what happens after a night of drinking.
The Commonwealth is moving.
I'm teasing. It was a Vanderpump Rules joke and probably not a very good one. I'm incredibly tired and my coffee has not kicked in yet. Sir, rebuttal is the rebuttal that you would get after a rebuttal. It's much more common in civil cases, not very common in criminal cases. I don't think I've ever seen a criminal case where the defense has gotten a sir rebuttal because it's just not appropriate. It's to address newly raised issues, and the defense doesn't have to raise any issues at all. So the Commonwealth can put on their case in chief, the defense can put on no witnesses, and then you're done. But if the defense puts on witnesses, the Commonwealth is allowed to rebut those witnesses. They have the burden of proof.
Moving specifically to exclude, there's a motion to exclude irrelevant photographs. We'll deal with that after the main motion to exclude certain testimony. So if we start on page 7 of the report, that's where you want me to start, Mr. Brennan?
Your Honor?
Okay.
It's your
page
motion,
7 of your
Brennan.
report.
Where are we?
I have some questions. So, Mr. Jackson, Dr. Laposata cannot opine about the investigation of the case, the law enforcement investigation. She does that throughout her report. So she can't
Okay.
opine to that. But when we get to page 7, what do you say is out, Mr. Brennan? I mean, I've gone through it. I know what I think, but it's the Commonwealth's motion.
I think that her opinion about
Chat, not Doctor Who. Dr. Laposata is a defense expert.
no object being present cause of pattern injury is appropriate.
And where are you, on page 7, the first paragraph?
Yes, photographs and descriptions of the site. It is the,
All right, I might have a different page 7. So my page 7.
That
okay.
was earned. I might have a different page 7. Can we all be on the same page, please? Brennan?
top paragraph.
Okay, yep.
Dr. Laposata's proposed opinion that photographs and description of the site where Mr. O'Keefe's body was found show no object capable of producing a pattern injury, I think is appropriate. His body was found on flat, grassy ground, probably frozen and covered with a minimal amount of snow. I agree is appropriate. It is the next paragraph where it begins in the middle of the sentence. It is logical to conclude that Mr. O'Keefe was injured elsewhere and his body was moved to the front line. There is no basis in fact for that. It's an improper opinion.
Yeah.
We left the argument.
So I told you that on Friday, Mr. Jackson.
We're not seeking that.
Great, okay, so that's out.
So everyone agrees.
And Mr.
It's
Jackson,
not the proper basis for opinion based on that. It's not the proper basis for opinion based on that, which is why you heard Alan Jackson say, we're not offering that. Right.
again, the medical examiner erred in her diagnosis of hypothermia. Again, that's the improper critiquing of the expert. She can say that it wasn't
can disagree.
hypothermia, obviously.
Correct.
Okay, so same with,
She can't, and these are kind of finer point issues. The defense expert can't say, well, your expert's wrong. The defense expert can say, the conclusion I came to is this because of this. I do not find that there is hypothermia because of this, this, this. They can point out why it's wrong, but they can't say you're wrong because. They can say, my opinion is this because. It's a different point.
the first sentence of the next paragraph, the Wisniewski spots were misidentified. Great, all right, so we can probably do this much.
So they're going through the Commonwealth's motion, and the defense has now said 2 or 3 times, Jackson has said, we're not seeking that either. So they're going through and narrowing down the opinions that are proper for testimony.
Quicker then. All right.
Okay.
All right, so page 8 is fine. So now we go to page 10.
Lovely, no. Lovely said, Emmy opinion's not proper, but blue paint human volunteer is allowed. No. The defense expert's not allowed to say that the medical examiner is improper. The defense expert's allowed to say, my conclusion differs, why their decision differs, but they can't say, but this expert is improper because. It has to be framed in the affirmative. My opinion is this, not this, because. That's all.
So this is the dog bites. So if you want to pick it up at, what does the Commonwealth say about this?
At this point, there's no basis provided that she has the training, expertise, methodology to provide an opinion regarding a dog bite.
What's the offer of proof on this, Mr. Jackson?
It will be more extensive when I establish the foundation testimony, but basically she's not only done autopsies involving dog bites, the wound pattern recognition related to the source of those dog bites. She's also taught classes on wound pattern recognition, source of coming up with diagnoses concerning the source of.
I have got to try to gain this up a little bit because everybody's away from the microphone this morning and it is painful. So give me one moment. Let's see if that will help. But the defense is saying that their medical examiner or the person they are calling to testify with regard to cause of death and kind of second opinion on that, they are saying has enough background to testify or confirm that those are dog bites. But even if that gets narrowed down, it doesn't change the fact that that information's in with another expert. She can say, I reviewed the other expert and I would have done these things.
Specific pattern wounds. She has a methodology that she uses.
There we go.
medical school classes, if I didn't mention, the courses.
What does she teach? Is this in her CV? Because I didn't see it.
It will be in her foundation that I will lay in front of the jury.
All right.
I won't seek any opinions unless and until the foundation is properly laid, but she has extensive experience, not only with, specifically with autopsies that she's conducted herself, but supervising autopsies of others that deal with pattern recognition, the methodology involved with pattern recognition.
How about dog bites?
Dog bites specifically, 5 autopsies. I believe she will indicate that she's done 5 autopsies as they relate to dog bites.
Okay.
A medical school class specifically on the issue of wound pattern recognition, which that
They'll just
class
approach
includes
to
dog
see
bite,
if the
dog bite.
foundation's been laid.
All right, so we'll need a short voir dire of her on this before she
Oh,
testifies.
or that.
Because the court doesn't believe that I can lay the foundation in front of the jury and just forego a voir dire. I won't ask any ultimate question until we go to sidebar, but I think we can short circuit that.
Well, she's very specific about the dog bites here. So if she's seen 5 autopsies with dog bites, I'm not inclined to give it to you. Okay? Seen only 5 in her 40 years or whatever.
It's not that she's only seen 5, she's performed 5 autopsies.
Okay, so that's why we need a voir dire. So we need a very short voir dire.
She's also been qualified on the issue of dog bite wound pattern recognition in federal court as well.
Okay.
So she has a plethora of foundations.
Has that been provided to the Commonwealth in advance of today?
I don't know.
None of it has. So here's the difficulty, whether it's a voir dire or it's in front of the jury, I have absolutely no ability to research and cross-examine her on dog bites. She can say she had 1 case or 50 cases, that she testified in state or federal court, or she took a class. I can't verify it, I can't contradict it. I have no ability to prepare for this witness about her basis, methodology, and experience in dog bites. What I have is her showing a couple pictures that she pulled from a book, and then she has some Google or Shutterstock research in her report. And
What?
So the idea that she has a history or basis is going to be uncontested because there's nothing I can do to contest it. And that's,
Well, if that wasn't turned over,
I should be able to.
that's gonna be a
research,
problem.
get transcripts, vet, and be able to approach the witness on whether or not she actually has the reliability and education and experience. I can't do that if we call her an access or a voir dire.
But that's where, if we want to compare apples to apples, Dr. Wolfe, ASIC Wolfe, was allowed to testify, to specifically testify to the wound pattern, or his interpretation of wound pattern recognition back then. That was nowhere in his report. That was objected to by the defense.
Do you see Alessi nodding vigorously?
Sidebar,
Well.
strenuously objected, said this is nowhere in the reports, we didn't have any notice of this, and the court said, overruled, he's allowed to testify to the pattern of recognition.
Well, consistency
His
is
mind,
real.
cross-examine. There is no requirement that the
Should be.
Commonwealth have every single case that Dr. Laposata has ever dealt with dealing with.
No, we had an expert on dog bites who I allowed to testify as to dog
As to
bites
that.
based on, we had a whole, as you know, it was Mr. Lessie, I think 3 days with Dr. Russell on the voir dire. This is new to me. I'm going to have a short voir dire on to what she can testify to.
I'm actually surprised.
So-
I'm actually surprised that the judge is giving a voir dire instead of just saying no. Because if it's not in the documents, most judges would just say, it's not in what I have. No. The answer is no. The fact that she's giving a voir dire is actually pretty good for the defense to just allow it. So wild to me that she's not just saying no. She's like, no, I want to hear it on a voir dire, which means they have the opportunity to bring that in. So yeah, I'm surprised. I'm surprised she didn't just say no.
All right, so let's go on to page 17.
That's not a change really for the court. On a lot of the big rulings, she'll complain about it, but oftentimes the bigger rulings go to the defense. So, all right, let's continue on.
Commonwealth has an objection to the third line, Mr. O'Keefe's pattern injuries on his right arm do not correspond to injuries that could have been produced by irregular fractured plastic pieces impacting his arm. She is not qualified as a reconstructionist or biomechanical engineer. She has tried in other courts and been rejected. She does not have the experience, the background, or the ability to do that.
What do you say, Mr. Jackson?
Your Honor, I believe she does, as a medical examiner, have the experience, and it's the qualification, it's the specific job of, and the qualification of a medical examiner to opine on pattern injuries. If the foundation is laid, especially as it relates to motor vehicle accidents, now we're not talking about dog bites, which are a more defined subset of her overall experience. Now we're talking about motor vehicle incidents and accidents that she has specifically seen thousands of.
Okay.
Multiple thousands.
So,
If she does have the qualifications,
I think that's an easier
if
question.
the proper foundation is laid, that the wound pattern that I see on
It's a
Mr.
much
Reed's
easier
arm
question.
is inconsistent with anything that I've seen in terms of a motor vehicle accident.
so let's just find out how many motor vehicle accident autopsies she's done during that voir dire. What I have a question about is taillights are typically made of durable polycarbonate or acrylic plastic. I would keep that out. I'd be inclined to allow in the injuries on his right arm do not correspond to injuries that could have been produced by plastic pieces impacting his arm. But let's hear about
That's
that.
appropriate. I wouldn't ask about polycarbonate. I have no intention of asking about it.
Right.
And
That's,
also,
that's fair. And the defense is saying, I'm not going to ask this expert about it. The expert can't testify about the materials of the tail light as an expert, but they can say, I've seen these types of injuries and these types of accidents. And that's what Dr. Laposata is going to testify to for the defense as a coroner, right? So that's where we're at.
the last sentence, I think it's okay, and we'll see with voir dire. Neither did his skin show any array of irregular, unpredictable, randomly scattered cuts and scrapes, assuming she has experience with
Anyone who's a coroner
autopsies
is
of
going to
motor
have
vehicle accidents.
anyone who's a
But I
coroner
would
is going to have
keep
that.
out the part as would be expected from pieces of shattered tail light. Was there more on that?
I object to that because this is now yet another witness that's coming in under the guise of
She's like, I'm allowing it in. And Brendan's like, no. The court's like, too bad.
some type of
Too bad.
specialty, but really for accident reconstruction.
All right, so let's see
not
what she
accident.
says on voir dire.
That's not accident reconstruction as a coroner. There are things that are typical to motor vehicle accidents. Coroners understand that.
Regarding her experience
Okay.
with accident victims. I think she gets more into
Yeah,
the
Brennan's
accident
not going to win
reconstruction
that one.
on the next page that I don't think is proper.
Which I am not seeking to achieve.
All right, so that whole first paragraph on the next page, you're not seeking to introduce? Yeah.
Yeah, Brennan's not going to win that one.
At least the first, we're starting with the first sentence, yes, we would be seeking to introduce that. Pedestrian injuries produced by contact with motor vehicle include a component of tissue crushing force as the car profile protrusions connect. That's basic. I believe that she does have the qualifications to opine about that. That's pretty standard, and that should be admitted.
She has absolutely no experience in accident reconstruction or the injuries. She is not a biomechanical.
Oh my God. They're not asking her about accident reconstruction. Brennan, stop conflating the issue. I agree with the judge on this. Brennan, that is not what the defense is asking. She is a coroner. She has seen humans struck by cars. Good Lord. It's not accident reconstruction. I am sighing into the microphone as well on that argument. The court's already said that she's going to allow the defense to get into that area. It's going to happen. That's it. Oh, the judge was sighing, and then I was also sighing. It's all of it.
He's going to testify to it.
Yeah, I have that as out, Mr. Jackson.
The reason that I believe that it's appropriate is because you don't have to be a biomechanical engineer to understand when you see, for instance, a known pedestrian accident, what are the results, especially if you've seen hundreds or maybe even thousands,
Yep.
what are the results that you typically see in the wound patterns, for instance, crushing forces,
Yep.
broken bones, fractured bones, crushed
Yep.
soft tissue, things of that nature, internal bleeding. That's the province of medical exam.
Okay.
That's what they are trained
And they asked their coroner about it.
to identify and to opine on.
Okay?
Agreed.
So,
Get into
I agree.
Things like, for instance, what she doesn't have the experience to do is say, when a car is involved in a rollover collision, these are the mechanical forces that are exerted on the body during a
Agreed.
rollover, and the G forces that are subject, that the body is subject to in a rollover, things of that nature. When a car is impacted head-on by another car, there are a number of G forces that are put upon the body, etc. Those are biomechanical issues.
Yeah, agreed.
Have nothing to do with her expertise, and I wouldn't be seeking anything like that. But once the body is removed from the car, and then it's on the autopsy table, that's where her expertise begins to fly. if you
Okay.
will.
Yeah,
She
agreed.
can talk about, and I believe she has the experience and the qualifications to talk about
What you see
the
typically.
body suffers
Yeah,
at
what you
the
see
hands
typically.
of a vehicle, pedestrian incident or
Yeah,
accident.
I don't
Okay,
disagree.
so the first two sentences are out. The third sentence, she can testify that Mr. O'Keefe had no bruising on his arms or torso. And she can testify,
Yep, those are facts.
and she cannot say that would have resulted from the impact with the SUV rear profile. She can say Mr. O'Keefe did
That's
not
also
have
fair.
bruises on his legs. She cannot say from bumper contact, but she can say as shown by dissection
She can talk about the injuries to the body, and she can talk about what she would expect.
of leg tissue and muscle at autopsy. And she can't testify to anything else in that paragraph.
Okay.
Your Honor, is the court ruling that she cannot say anything about the human body contacting a motor vehicle? That sounds like what the court's saying.
No.
She can
I
talk
think
about
that's too
she
clear
can
of a
talk about
rule.
what she would
It
expect to
is.
see.
You can put this in, what I said you could put in, can come in, and the rest cannot. We
For
could,
instance, and just for point of clarification, if I ask her, would you expect, I'm just gonna make it a hypothetical, would you expect if his legs were contacted by a moving vehicle, would you expect to see a bruise or contusion?
I think
what do you
that's
say about that?
I object, one, it's leading.
Well, I'm not asking the question.
Secondly, this is asking
all right. Touche,
to have
Brennan.
Dr. Laposata do accident reconstruction. She's not assessing a wound. I'd ask you to consider the case of Commonwealth versus Tompkins, appeals court. I think we provided at 105 Mass Ave 1124, 2025 case. And a similar attempt was made to try to use Dr. Laposata as a biomechanical accident reconstructionist. The trial judge did not credit her proffer and found that she failed to meet the requisite criteria pursuant to Daubert Lanigan. And so recently it's been found by at least another
And yes,
court
y'all,
that she's
Brennan
not
knows the leading
competent
question
because
very
the
well.
medical examiner does not allow her to come in and start endorsing or vouching for the ARCCA witnesses. They already have witnesses to do that. And so not only on page 18, going back to page 17, about the pattern injuries don't correspond to injuries to a light, she would only know that if she had the training
Where,
experience.
I'm sorry, where,
You said on page 17 you would allow Mr. O'Keefe's pattern injuries on
A number of you were asking, what are they reading from? The expert report. They're reading from the expert report that they're talking about. This is a defense expert that they expect to testify in short order, like tomorrow, I would imagine.
right arm do not correspond to injuries that could have been
If not
by
end of
regular
today, but I think end of
fracture
today is optimistic.
back in his arm. That's not her role as a medical examiner. That is the role of a reconstruction or a biomechanical engineer. And she clearly is not competent, at least as cited by the appeals court, to have that type of opinion. And so there's one thing to assess wounds, is another to try to correlate or draw a distinction between the wounds in a car collision. It is essentially giving an opinion to the jury, he didn't get hit by a car. That is the core fundamental theory of the defense. This is simply trying to bootstrap another witness to give that opinion. That's improper.
all right, sure.
The witness can say that the injuries are not what they would expect and it's not
That
consistent.
dealt with a situation in which the witness was called.
They're arguing over
and she
case
was
law.
asked by the lawyers, specifically in that case, the people that called her, the lawyers that called her, to opine about blood-stain pattern recognition, blood spatter evidence on the driver's seat versus the passenger seat, and what her opinion was about who actually was driving the vehicle. It was a rollover collision in which people were ejected from the car. She was then asked to opine about bloodstain patterns in the driver's seat and whether that was more or less consistent with the blood, the originator of the blood, one particular individual, was he more likely in the driver's seat or the passenger seat at the time of the pleading.
Yeah, that goes
and
beyond the
before or
bounds.
after the roll-up. Very, very different set of facts. And of course, that is a biomechanical engineer's province. And the court was correct in saying, I'm not going to credit her testimony on that issue, but that's what she was asked. She opined on it, and the court said, I'm not going to credit her testimony.
All right, so
To do this type of analysis and move pattern recognition, which is what she's being asked to do.
so let's see with her voir dire this morning.
Okay.
She actually was allowed to testify about blood spatter. It is the reconstruction testimony that she was not allowed to testify about.
I read the Superior Court judge's decision. I have not read the appeals court rescript, so I need to do that. I'd like to get going, but there are photographs of inside the garage. You intend to put this in through Dr. Laposata?
No, not through.
Through whom?
If I could just have.
Yeah, can I get with regard to these photos, well, ultimately.
Yannetti talking now.
The Laposata will be shown them, correct, that they'll be introduced through our investigator who took the photos. We intend to call that investigator after Dr. Wolfe testifies.
Okay.
And what will that investigator say? These are
I took
photographs.
the photos, apparently.
So, he will testify to two subject areas. One would be he took measurements from the street to the various entrances to 34 Fairview. We just have to testify about what those measurements were. And then where he took several photographs, we have pared them down to, I think, 3 or 4. Just of one establishing shot showing the garage from the street, and then a couple of photos showing the side entrance to the garage, the pedestrian entrance to the garage, which also shows the interior of the garage, including a step and a
For what purpose? How are they relevant?
I'm sorry?
How are they relevant?
So the defense is presenting a Bowden defense in this case.
Yep.
We are alleging that the police did not do a thorough investigation. They did not really investigate anyone other than Karen Reed. The Commonwealth's own evidence, including the testimony of Ian Griffin, is consistent with John O'Keefe after what they claim to be the trigger event in Dr. Welch's initial report. John O'Keefe walking in a westerly direction, which would be from Fairview Road to the house, taking.
I don't agree that's exactly how that evidence came in, but it's argument.
A distance of 25.4 meters, which is approximately 84 feet. That is consistent with.
I do
him
agree with the
entering
belt tie
house.
combo,
It's
though.
consistent with him entering the garage. The police did not take photos of the garage. They didn't investigate, is there a hard surface in the garage? Is there a ridge-like surface in the garage? And these are, photos are introduced on that Bowden issue to say that there was evidence in the house. If the police only went in there, they would have seen that. And that may have sent them in a different direction. So it's relevant for that purpose.
Do you want to weigh in on this?
These are not only relevant and not material, it's misleading. They are not seeking to have measurements from the flagpole to the door. They're trying to seek measurements from the driveway to the door. There is no evidence whatsoever John O'Keefe was ever on
It's not a
near
bad argument
or
from
anywhere
Brennan.
by the driveway. The evidence is that he was at the flagpole. While the data showed there was a turn westward, it didn't show movement westward. It did not. There was a measurement from the flagpole to the garage door. That is something that I think would be appropriate. From the driveway, totally irrelevant. There's no evidence, no witness, no substantive
Not a bad
evidence in
argument.
this case that John O'Keefe went in the house, went near the house, was dropped off. They're relying simply on the fact that there were 37 steps. They have no idea what direction or where. What they want to do to argue this is to show inside the garage and then posit a theory that somehow John O'Keefe was killed in the garage, it was colder than it was in the regular house, that would account for the temperature on the battery. They have no evidence to support that. You can't use Bowden as a panacea. You can't just say Bowden, they should have done
Bowden's
what
not a
we
cure-all,
want.
is what he's
What
saying.
reasonable. The police went into the house. They spoke to the occupants of the house. There was no evidence that Mr. O'Keefe went into the garage. You might as well take a photograph of anybody else's garage in America and put it up in front of the jury.
Well,
This
that's
is going to
hyperbolic.
A mistaken, baseless argument that this evidence somehow shows that Mr. O'Keefe was A, in the garage, and B, he was injured in the garage. That's why they want to show it to Dr. Laposata. Couldn't some of these angles have caused the injury? Total speculation. no relevance at all, and it is just prone for an opportunity to mislead this jury. This should not come in.
Nora, the police did go into the house. Nora said the police went into the house. The police did go into the house. The police went into the house. Did they do a thorough investigation? No. But yes, they did go into the house and speak to parties in the house. 3 officers, I believe, went into the house. But that's beside the point. But yes, they did go into the house. That's not what I was trying to do.
First of all, Mr. Brennan just informed this court that there was no evidence of movement of the phone. I'd like to quote his own witness.
The phone did move. The phone 100% moved. But the timing of the steps is delayed, and that's part of the problem.
25:30, the device's bearing shifts to a westerly direction, as location records also show the device moving west from the roadside toward the house. So that was false. Secondly, with regard to, we should be measuring from the flagpole, our theory is not that he entered the house from the area of the flagpole. Our theory is that he was placed at that flagpole, and as Mr. Brennan correctly points out, there's no evidence that they introduced as to where he was on the road prior to walking into the house in that westerly direction. Our theory is as good as his. He cannot prove anything to contradict our theory. The third thing is that Ryan Nagel and Heather Maxey saw Karen Reed in her vehicle alone. The passenger seat was illuminated and empty. John O'Keefe was nowhere in the area of that vehicle. He was not in that vehicle. There's only one other place that he could be, and that is in the house. So finally, the fourth point, Your Honor, this court has continually always done, as the court should, a 403 analysis. The probative value we have established through their own witnesses. They called all these witnesses, and they established the foundation for the admission of these photos. There is no unfair prejudice. I would argue that any time there's exculpatory evidence or a case that advances the defense theory, that's by definition going to prejudice the Commonwealth's case. This is not unfair prejudice. He is allowed, Mr. Brennan is allowed to cross-examine this witness and to make whatever arguments he wants to make about the likelihood of the garage being involved or not. But he does not and should not get the benefit of the fact that his investigation, the police investigation, didn't do what we just did.
Well, he's mad that he's stuck with it, I think, Yannetti.
The argument is purely rhetorical. There's not one fact he offers. The witnesses that saw the car saw it in front of them. Nobody ever got out. A light on doesn't mean that he wasn't near the car, because they didn't see him in the front seat. So there is no evidence that Mr. O'Keefe went anywhere near the house, on the breezeway, in the door. It is speculative, it is baseless. They want to take that baseless argument and then bootstrap it to Dr. Laposata to further speculate that something in the garage that could have caused the injury.
Well, Dr. Laposata is not going to be allowed to do
That is
that.
not a due process right. That's not 403. It's empty. It's no factual predicate whatsoever.
Okay, so,
It's real early on a Monday for this.
The location data circles.
Why didn't this all come up in 403s?
Again, Mr. Brennan's own evidence, he introduced it, puts John O'Keefe in the house as well.
all right, so I'm going to allow you to do the measurements. These photos will mark for identification. The photos are not admissible. So, all right, Chrissy, can you just mark those, please?
So
All
measurements,
right,
yes.
let's bring the
Photos,
jury
no.
over. We will do, Mr. Jackson, how long will you be with Dr. Wolfe?
Probably 20 minutes.
All right, and depending
Yes.
on that. All right, so during the morning recess, we'll do the voir dire of Dr. Laposata. All right, bring him on over, please.
Okay. Well. We are having the jury brought, the court's having the jury brought down, so it is time to literally,
Bring the jury.
and then we will get back into Dr. Wolfe testifying on the stand. For all of you asking, or just coming in, good morning. The court was hearing argument on a number of motions as the case wraps up. I'm not surprised that we're seeing a number of more motions about the remaining witnesses in the defense case. The court reserved some rulings, made a very few rulings, And we are going to see a voir dire of Dr. Laposata, which means to me, they're anticipating that witness to be testifying soon. And we're going to see that at the morning recess. So we will get there then. Let's get to
Good morning again.
the jury
counsel.
coming in and Dr. Wolfe taking the
Good morning,
stand.
jurors.
I didn't hear any hear ye's this morning. I'm sure they did them at some point, but I wanted to jump right into the morning the morning hearings. So hear ye, hear ye. Court is now in session. Jury is present. Dr. Wolfe is getting on the stand. I'm out of coffee already.
We appreciate your
Shit.
patience. We were in here trying to streamline things, so we got a lot of work.
You
done
were
this
not
morning,
trying to
so thank you.
streamline things. You were
I
just
do have
ruling
to
on
ask you those
motions.
same 3 questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we left here on Friday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation?
All
into
right, the
this
jury's
case?
in.
Everyone said yes or nodded affirmatively.
We're gonna resume with Dr.
Did anyone
Wolfe.
happen to see, hear, or read anything about this case since we left here on Friday?
In redirect.
Everyone said no or shook their heads. Okay, thank you. We have Dr. Wolfe, please.
Week 8. Let's go. Anna's Banana said EDB needs a coffee maker in her office. I mean, right? We do. We do. We definitely do. But that's all right. So, Miss Slack said, Emily, my kid is at 3-day MB camp for color guard. She's sore but loving it. How is your kiddo doing? Well, he got his stitches out, so that's good after whapping
good
himself
morning.
in the face with a flagpole. And he's sore, but loving it. Tired, but loving it, and ready to go on tour later this month. So he's excited. All right. Good morning, Dr. Wolfe. Defense witness number 8.
All right, Mr. Jackson, whenever you're ready.
Thank you, Your Honor. Dr. Wolfe, thank you for joining us again this morning. I'd like to draw your attention to a picture.
I make no promises about whether the chat will refrain or not. Dr. Wolfe, with all due respect, Dr. Dimples is not meant to, it's just meant to differentiate you between yourself and your colleague, Dr. Rentschler. That's all. Also, the sound in court today is total and absolute shit. I have no idea why. So I've got it gained up. The microphones in court have it gained up. I can hear in the background the court reporter. And I think it's the first time this trial where I've actually heard the court reporter. It's a whole situation. We're just doing our best. Everything is having a Monday.
May I approach, Your Honor?
Yes.
Dr. Wolfe, the chat would like you to just take your hand and just run it back through your hair before they die.
Yes,
You were shown this photograph last week, is that right?
correct,
By Mr. Brennan, correct?
correct.
Do you recognize the photo as the same photo that you were shown last week?
Yes,
Under questioning by Mr. Brennan?
yes.
And what does that appear to be a photo of, just generally?
It appears to be a photo from of the test dummy from the 29 mile per hour impact test.
Does that appear to be a true and accurate photograph of the condition of the dummy following that 29 mile an hour crash test?
Yes,
With the court's permission, I'd like to enter this as next in order, please. If you could hand that to the court order.
All right, these are photos. Again, it is so loud in court.
218, exhibit 218.
It's just, it is, we're not, there's so much background noise with those fans. I'm going to see if we can hear
Permission
him
to
well enough
present
without it
that, Your Honor?
being
Yes.
overclocked.
Is this the photograph?
yes,
Yeah, we saw that last week. Okay. And what are we waiting for? Excuse me? What are we doing?
Dr. Ward, first of all, what caused the damage Well, let's start with the most basics. Which arm is this? Left or right?
I know, not Randy.
This is the left arm.
What position was, you called this dummy Rescue Randy, is that right?
Correct,
What
yes.
position generally
Yeah, we all have questions about Randy Jackson. We well remember.
was Rescue Randy in upon impact during this test?
He was oriented such that the right side of his body and his right arm would be contacted by the vehicle.
What caused the defects in the and the damage to the sweatshirt as we see it here?
The road.
That was due to the interaction from the Rescue Randy sliding on the pavement surface to his position of final rest.
The
Is
friction.
that sometimes called road rash?
Yes.
The friction.
Did you see any road rash in any other place on Rescue Randy
Yeah, we
in this
heard-
photograph?
Chat, yes, we heard about it on Friday, but the defense is going to overlap a bit of what they talked about Friday just to bring the jury back up to speed to the things they want to highlight. So yes, you heard this on Friday. Yes, we're hearing it again. It's been a weekend and the defense wants to highlight this.
Doesn't appear so in this photograph, no.
Can we highlight the face?
I can see the face. His chin and nose is all
What about there?
Sorry, I thought you were
Road
talking
rashed.
specific to the clothing. Yes, the as I mentioned on Friday, there were signs of road rash to the body of the dummy itself on the face and on the torso and arms.
Can we zoom in on the sleeve a little bit? Do you see any staining on the sleeve as well as the defects, the holes and the tears?
Yes.
What is that staining from?
Again, just from that sliding contact with the pavement, so it's just likely debris and kind of a film from the pavement surface being deposited onto the
dirt.
material.
With regard to John O'Keefe's sweatshirt that you reviewed photographs of, did you see any other defects other than the right arm and the fact that it was cut off of him medically?
No.
Any other indication or any indication whatsoever of anything that you see consistent with road rash?
No.
Okay, let's go back to the full frame. The second image I'd like you to take a look at. If we can have the lights for just a second. Do you recognize what's depicted in that photograph?
Yes.
How do you recognize it?
It is the backside of the test dummy from the 29 mile per hour full-on impact test.
Which arm is featured in that photograph?
That would be the right arm.
the full-on
Move that
impact
for-
test. y'all.
Move that
the
into
full-on
evidence as
impact
next in
test.
order, Your Honor, with the court's permission.
Exhibit 219.
Permission to display.
Yes.
Does that appear to be the right arm of Rescue Randy as he's face down?
Yes.
Is that following the impact?
Yes.
Do you see any? Were you shown this photograph by Mr. Brennan on cross-examination?
No, I was not.
Can we highlight the right sleeve just a little bit, please? Do you see that defect in the sleeve?
Yes.
Do you also see some artifacts above that defect, above and to the left?
Yes.
Can you tell what those are?
They appear to be fragments from the back window of the test vehicle when it shattered.
Does there appear to be any additional, let's go back to the full frame. Does there appear to be any additional defects on that
I
particular
mean,
sleeve?
he did talk about Randy being all jacked.
There appears to be some material transfer likely from the pavement and also some road rash.
Does that appear to be transfer from the pavement?
I think that might be a shard of glass from the back window.
What was the condition of the back window after this test?
Shattered.
It was completely shattered.
The defect that we're looking at, that large gash,
Emily, are you just yelling things? Yes.
was that from road rash sliding on the pavement?
Yes.
We can go back to the full frame, please. I'd like to show you an additional photograph.
Okay.
Do you recognize what's depicted in that photograph?
Yes.
What is it?
It is the front side of the test dummy from the 29 mile per hour full-on impact test.
Does that appear to be a true and accurate depiction of the condition of Rescue Randy in that sweatshirt after that 29 mile an hour impact?
Yes.
Move for the admission of that photograph, Your Honor, is next in order.
Okay.
Which is fair.
Exhibit 220.
Permission to display?
Yes.
Tasha Nitz in the chat asked, EDB, did you have a
Can you
to
describe
estimate
what
how
we're
long
looking at in this
questions would run?
photograph?
I would have a rough time. I was terrible at it. I have complete time blindness. I was not good at estimating how long questions would run. I did my best, but I was not good at estimating how long questions would run because sometimes it depends on the answer. Like, I don't know. I estimate I've got about this many questions left, but if they say something that lands us down a rabbit hole, one never knows.
This is mainly showing the upper body of the test dummy from the 29 mile an hour impact test,
And then those
showing
straps
the
are from the
road rash to the front side of
Randy
the body.
being held
Were you
on
shown
the
this photograph
harness.
on cross-examination?
No.
Right, because the prosecutor only showed the picture of the arm. The prosecutor didn't show the rest of the damage done to the hoodie.
What caused the holes in the bodice of the shirt? In other words, the part that covers the chest and the torso.
After the impact,
That
the
looks like
dummy
road
was
rash.
was projected and sliding on the pavement surface. So again, this
Oh yes,
is
he went flying.
consistent with the front side of the body sliding, making sliding contact with the pavement, creating those abrasions and holes. And again, that asphalt material transfer that you see on the front.
Can you go out back to the full frame, please? Do you see additional road rash? Take a look at his right arm. You see additional road rash on Rescue Randy?
Yes,
On both the fabric and the arm itself?
correct.
Go back to full
Well,
frame.
and on the torso,
And can you see his face as well?
he's
in
got
this
road
photograph?
rash on his abdomen.
Yes,
Are those the chin and nose defects that you saw?
yes.
Right. Rescue Randy got
Are the defects in the shirt
Correct.
that you see here consistent with the condition of the shirt of John O'Keefe as you saw it in the photographs?
It is inconsistent.
May I approach, Your Honor?
Yes.
Your Honor, we have more pictures of Randy. The prosecution wanted to bring this in, so here we go. Again, the prosecutor just trying to highlight one portion of a thing without showing the rest of the picture is not a strategy a jury is going to like. A jury expects the full picture from the prosecutor. That's not too much to ask. They should show you the full picture. They're asking the jury to convict someone. They should show you the whole picture and then let you decide, you, the jury. So to show one section of a thing and then have the defense go step back and say, but here's the whole picture, isn't going to sit well.
Do you recognize what's depicted in that photograph?
Yes.
What is that? We can take this down.
It is the rest position of the test dummy after the 29 mile per hour impact test.
Were you shown this on Friday?
No.
Is that a true and accurate depiction of the condition of Rescue Randy just from a different angle after that 29 mile an hour impact?
Yes.
Move for the admission of that photograph.
Okay. Exhibit 221.
The thing is, the prosecution would have had these photos,
Permission to
so
display
they
that
knew
photograph.
this
Your
is where this was going to go. It's just it's an odd choice.
Is this an
for
overview
me?
of the entire body of Rescue Randy after that impact?
Yes.
Take a look at his torso.
Still has his shoes
the
on.
Exposed portion of his torso.
However,
You see road rash.
Randy's feet don't flex, I would imagine, the way that human feet do, but still has his shoes on, which is a question. And Lisa G said, EDB, is that allowed? Is the Commonwealth allowed to cherry pick information to present like that? They're not presenting it for this witness. They were cross-examining this witness. So they're allowed to present on cross-examination. They can cross-examine about almost anything they want. It has to be proper evidence, but they can cross-examine on how they want. The response to how they cross-examine is the redirect, which is what we're seeing now, because this is the defense's witness. So yes, the prosecution can do that on cross-examination, but then on redirect, when it's like, we'll zoom out and look at the whole picture, that's what the defense is doing now. So then the jury gets to decide if they've seen the full picture or not. But yes, they can do that. And then the defense can do this and say, okay, well, if we're going to talk about it, we might as well mention it all. Oh, I'm back at my home soundboard. Hold on.
Mention it all. Mention it all.
Right.
On his exposed torso?
Right.
Yes.
Do you also see that the road rash that you earlier described on the bodice of the shirt, the front of the shirt?
Yes.
And what about, let's go back to the full frame. Is there also road rash on his jeans?
Yes.
If we could go back to full frame.
Yeah, it looks like he was yeeted across
Have you ever
a
heard
road
a phrase,
surface.
knocked out of your shoes?
Yes.
Where are the dummy shoes?
They're still on his feet.
Excuse me? Alan Jackson. That's Randy.
And this is at an impact of 29 miles per
Mr.
hour,
Rescue
correct?
Randy to you.
Watch the form of the question.
Sure.
Jackson.
What was the,
Misleading.
tell us one more time, what was the speed of this impact?
This was a full-on 29 mile per hour impact.
We can take that down.
The full-on impact is sending me.
Yes.
And again, we're going to see more about this because Dr. Rentschler is going to testify again about these tests.
Yes.
What is that?
It is the back of the test Lexus after the 29 mile per hour impact test.
Is that a true and accurate depiction of the condition of that Lexus,
Yeah, the Lexus
following
was
that
also
29
pretty
mile an
fucked.
hour impact?
Yes, and I should be more specific. It's post the 29 mile per hour impact with the test dummy, not just the arm.
Understood. Thank you. The collision that caused the damage to Rescue Randy that we've just been looking at.
Correct, yes.
Okay. Move for the admission of that photograph, Your Honor.
Okay.
And we saw the videos of these on Friday. Those will be timestamped if any of you didn't catch it on Friday. I'm sure some of them are in the case brief, which I hadn't had a chance to watch yet because travel. But the videos there of this 29 mile an hour test. Remember, the Commonwealth has argued this case that at the time that 10-second event stopped recording, the Lexus got up to 24 miles an hour. The accelerator was still at 75% or 75%, 74% throttle. The accelerator was still quite depressed. And so they said that the car was still going backwards and speeding up. So we've got tests from ARCCA at different speeds because the Commonwealth theory is not that the Lexus stopped at the end of that 10-second. It's that it was accelerating and it kept going. So that's why the different speeds.
Permission to display that?
Yes.
And then the jury has an answer. Well, what would happen if it was going faster? It could have been going faster. Well, here's what
The photograph that
happens.
we were just talking about?
This is what happens if it's going
Yes.
faster.
And this is the condition of the vehicle after that rearward impact with Rescue Randy, correct?
Correct.
Did the subject vehicle photographs that you looked at, were those consistent or inconsistent with this photograph?
Those photographs were inconsistent compared to the test.
Right.
Was there anything consistent about the shirt that you were shown on Friday, the left sleeve that you were shown on Friday with John O'Keefe's actual sweatshirt?
Was any of that consistent with?
Correct. Was that consistent or inconsistent, now that you've seen all the photographs, with the condition of the shirt that John O'Keefe was wearing on January 29th?
The test clothing was inconsistent compared to that of Mr. John O'Keefe's.
Thank
And the
you.
jury knows that, right? The jury has seen these photos now numerous times.
You were asked on cross-examination several times about the weight of the hybrid 3 arm. Do you recall that series of questions?
Yes.
You were asked how much lighter the hybrid 3 arm was than the static estimate arm, correct?
Correct.
I want to make sure we're clear about this. The hybrid 3 arm is the physical arm that you attached to the ATD and did testing with, correct?
Correct.
The statistical estimate arm is something in the ether, right? It doesn't exist.
Sustained.
How would you describe a statistical estimate arm?
It's probably from taking a sample of the population and getting an average and a high and a low.
Okay,
Right.
is that a physical?
Is that a thing? They're talking about how much does John O'Keefe's arm weigh, because there was lots of conversation and cross-examination about whether John O'Keefe's arm weighed 11 point whatever pounds, and if using the 9-pound arm instead of the 12-pound arm was an issue.
Arm? You touch and feel?
So that's why
No.
we're there.
Do you have any information based on everything that you've reviewed at all about the actual weight of John O'Keefe's right arm?
Nothing in terms of a weighed measurement of the arm, no.
Okay. What was the percentage that Mr. Brennan gave you in terms of how much lighter the hybrid 3 arm was than the statistical estimate arm that he gave you?
From what I recall, I think the percentage was 26%.
Did you calculate that yourself, or did you take Mr. Brennan's word for it?
I believe I took his word for
Are
it.
you going to calculate it, Jackson? Is that what? Are we mathing again?
Do you recall what the weight of the hybrid 3 arm was exactly?
9.38 pounds.
What is the difference, if you can calculate, what is the difference between what was the statistical estimate arm, the number that Mr. Brennan gave you?
I think I heard him say 11.8, but I also think he said at one point 11.6. So I'm
probably
not sure of the
accurate.
kind of the final number he landed on.
That's probably accurate.
Sustained is ask the question to stop striking the end.
Does 11.86 sound right?
Yes,
Okay. Let's use 11.86. Do you have a calculator with you?
I do.
With the court's permission, could Dr. Wolfe use a calculator if he needs to?
Yes.
Thank you. What's the difference between 11.86 and 9.38? Just in raw numbers.
Math. You can't, Jackson, excuse me.
You're looking.
If we get to full on raw and full throatedly, this Monday is going to go off the rails really fast, sir. Work with us here. We're on week 8. We're on week 8. I need you to just work with us, please.
Looking at just the difference between those two.
Subtract
Okay.
9.38.
Yep. 2.48.
He said subtract.
Does that mean there's a 2.48 pound differential between the statistical estimate arm, the heavier arm, and the 9.38?
We're going to get back to whether using the 9.38 arm was appropriate and whether it would have less of an impact or the same amount of impact or more of an impact or a deep impact or whatever. And Wolfe kept trying to explain, look, the thing that's hit by the car is going to come up to the speed of the vehicle. So for Wolfe's calculations, it didn't matter that there was a 2-pound difference between a theoretical estimate and the arm that they used.
Arm that from the hybrid 3.
Because that all goes
Yes, that's
to
the difference in
Rentschler.
pounds.
All right. How would you calculate how much lighter? What's the proper way to calculate how much lighter in terms of percentage the 9.38 arm is?
You would want to do a percent difference calculation.
Divide 2.48 by 11.86?
Sustained. Watch the form, Mr. Jackson.
How would you, tell the jurors how you would calculate that percentage difference?
You would subtract the 11.86 minus the 9.38, and then you would divide by the sum of those two and divide by 2, the average of them.
It's
Can you
just
do that
paying attention.
calculation?
I'm good.
Yes.
Emily, can you explain whatever he said? Just whatever he said. It's fine.
Okay.
And what's the number?
23%.
Not 26%?
Objection.
Sustained.
Is 23% smaller or no, or larger than 26%?
Okay.
Sustained. Let's move on from that, Mr. Jackson.
The thing speaks for itself. The jury's aware. Is
What is
anyone
the number
shocked that
that you
Brennan got the
get?
math wrong?
If you were to divide 2.48 by 11.86.
0.21.
In percentages.
21%.
Thank you. Was the hybrid 3-arm 21% lighter by that calculation than the 11.86 estimate arm?
Yes.
Emily, your eyes have glazed over. Yes. I know
On
that it feels
cross-examination, Mr.
important to
Brennan asked you
them.
several questions related to kinetic energy formula.
That's what's
correct?
more important.
Correct.
You referenced that. Did you reference that formula in some of your answers?
Yes.
May I approach?
Yes.
The kinetic energy is more important. Thank you. I saw that Melissa mathed and got it. It was too many numbers. Google was like, why are we numbering so many numbers? Oh, we're approaching to talk about kinetic energy. The chat has their own form of kinetic energy this morning. We are zooming right past this sidebar to get back to testimony. As we hopefully get beyond, it is time for the practical questions of, does it matter? All anybody cares about at this point is, does it matter? Does it matter that the arm was different? That's all. That's what everybody wants to know. Just, does it matter? And why? Or why not?
May I inquire?
Yes.
You're looking at something that's been identified, a document that's been identified as 3 X's, XXX. Do you recognize that?
Not the triple X.
Oh, you're not looking at it.
Not yet.
You see it now.
Yes.
Do you recognize what that is?
It is the formula for kinetic energy.
With that, Your Honor, may we display the formula? We don't have to cut the lights. I think it'll be very
Your Honor,
obvious.
may we display the
Yes.
formula? Sure.
Can we bring the lights back up and see if that's visible?
Emily's going to start singing X, going to give it to you in a minute.
Can you still see that, Dr. Wolfe?
Yes.
Your Honor, is that okay?
Yes.
Great.
Chat, does that work for you? Sure.
You said this is the formula for kinetic energy, correct?
Correct.
Oh, it's color coded. Well, we're not mad at that.
You were asked a series of questions about whether the weight differential in the hybrid 3-arm would make a significant or material difference in your
thank
testing
God.
as it pertains to the velocity of the vehicle that you were testing. You remember those questions?
So watch the form again. Ask it differently.
Just foundationally, were you asked about weight differential of the hybrid 3-arm?
Yes.
Yes.
Were you also asked about whether it would make a material difference to the testing if you didn't adjust for the velocity?
Does it matter?
Sustained.
What were you asked in terms of, what was the question that was posed to you about
I don't think
the
that was
weight of
leading.
the
I think that was
hybrid
foundational.
3-arm versus
I think the
the
court should allow
velocity
it.
of the testing?
That there would somehow be an influence on I think, wanting to make a reduction to the velocity of the vehicle.
Does that make mathematical sense to you?
Sustained is to that point.
Why?
Would that have a material difference? With the weight of the
It's
arm,
found-
2.48 pounds, would that have a material difference in the testing that you undertook?
No.
Why is that?
Well, to start, that's one of the reasons why we went above and beyond the 24 miles per hour to impart significantly more kinetic energy to the arm. So if you look at that equation, it's a quadratic equation because you're squaring the velocity. So if you double the velocity, you quadruple the amount of kinetic energy. So you get a significant increase in small changes in speed because of that speed differential.
Did you do a test with just the hybrid arm contacting the taillight at 24 miles per hour?
Yes.
Did you also do a test with that hybrid 3-arm contacting the vehicle at 29 miles per hour?
Yes.
I'd like to talk about those two tests. Okay? Can you explain to the jurors what they're looking at? I want to start with going from left to right. What does the E sub K mean in that formula?
So that stands for kinetic energy,
jurors
which
don't
is
care.
the amount of energy that an object has.
All the attorneys care very much. The jurors don't care. You know what the jurors want to see? They want to see the high-speed video again. They don't care about any of this. They want to see the high-speed video again. But the defense is doing redirect. The prosecution asked a lot of questions like, oh, you used the wrong equation. The defense doesn't get to bring these witnesses back after the prosecution brings in their rebuttal witness. So they're trying to close all those potential loops before that witness testifies. Jury doesn't care. They want to see the videos again.
When it's in motion and has a velocity to it.
What is the 1/2 on the other side of the equal sign?
Just a constant.
And what does the M, as in Mary, stand for?
So that would be the mass, in this case, the mass of the arm.
And what's the V, as in Victor?
That would be the velocity of the arm as it's accelerated.
Why is there an exponent at the top of the V?
Because you're squaring that. So you're basically multiplying the velocity times itself. So it would be velocity times velocity.
We don't need to teach the
Is
jury
this
physics.
a formula that's
They want to see
traditionally
the videos.
used in accident reconstruction?
Yes, it's very common.
Is it sort of one of the foundational formulas? When did you learn this formula?
He's like, when I was 3,
Probably back in high school physics.
I'm going to ask.
he's like, I've been calculating for velocity since I was, learned to ride a bike. Good. The jury, some of the jury might care, like if they are particularly interested. Other jurors are like, can you just show me the video again? What happened?
Ask you if you wouldn't mind to
But
walk the
the
jurors
prosecution
through
has pulled them
a
down this
calculation
rabbit hole to
dealing
try
with
to close
the
those loops.
24-mile-an-hour test using the 11.86 pound statistical arm as an assumption of the weight of the arm.
Okay.
You understand?
may I have a pen and paper to write?
May I approach you, Your Honor? Yes.
Your Honor, can I I need the math. I want to do the maths.
I have a pad here too, if whatever's easiest.
Okay. Whatever's easiest.
It's fair. Val in the chat said, I'm a math
you
person. If I were on the jury, I
assume
would
the
want to know this
mass
information. It's
of
fair.
11.86.
And that's the thing. There may be some jurors that really want to close this loop. And the defense feels like a loop was opened by the prosecution. When Jackson feels like the prosecution has made a dumb point, you see him stand up and go, did you have a birthday 2 years ago? Do you remember exactly what day it's on? No? Okay. The defense feels like they need to close these loops. And they are working on closing those loops. I think the majority of the jury, and again, they can see the jury, we can't. I think the majority of the jury is just like, we saw the videos. Does this matter? That was me. I was trying to unpause. And we jumped forward from, hold on. I know all of you have now had a Brennan jump scare. We've got to back up to the math. We are doing math on the witness stand. It was completely inadvertent on my behalf that we jumped.
Applying the
All
velocity.
right, hold on. We're talking about squaring the velocity. There we go.
You
Back to doing
assume
math.
the mass of 11.86. That's the statistical arm weight. And you assume the V for velocity is 24 in miles per hour. I don't care about the units, doctor. Just assume 11.86 and 24. Can you calculate this quadratic equation?
Yes.
What do you get? I want to do it step by step. What's the result of squaring 24?
So again, you're not concerned about the units.
I do not
but
want to talk about units.
Just okay.
If you mention the word joules, my head will explode.
That's I didn't know if you wanted Newton meters, foot pounds. Okay.
Stop it.
So
Okay, I will allow for the nerdy adorableness. I will. Remember, Jackson was also in the Air Force. Okay, we'll allow for all the nerding.
that's
Of squaring.
And the thing is, there are times when Jackson can make quips that are much more endearing. There is time where I think he's way too heavy-handed. He has not been that heavy-handed this trial, not nearly as heavy-handed as last trial when I'm like, oh my God, this is way too much. Brennan does not have the same level of relatability in his quips. He has not earned them. It just comes across really heavy-handed. I rewound that because it was adorable.
so again, you're not concerned about the units.
I do not want to talk about units.
Just okay.
If you mention the word joules, my head will explode.
That's I didn't know if you wanted Newton meters, foot pounds. Okay.
Stop it.
So
Immediately.
just 24 squared
Correct.
is 576.
Notice there was no objecting there. There was no objecting there. Objection, Your Honor. Counsel's being charming. Make him stop. People giggled. It was probably the jury, but it's a really good way to break the tension in court when going through sloggy testimony, when you have a moment to be like, no, stop it. Stop it. Don't talk physics to me.
Do you always, in this calculation, do you always use the exponent first? Do you always do the square first?
Sustain.
What's the first thing that you do in solving for this equation?
Yeah, it was adorable. It was fun.
You would want to square the velocity, but it's ultimately all going to be multiplied. But yes, you would square the velocity, multiply by itself.
What's the next step after you get 576?
Again, assuming we're not concerned about units, you would multiply by the 11.86.
Can you do that for me and tell me the answer?
How many decimal places do you want? Just nearest whole number?
2.
Okay. 6,831.36.
This is literally
What's the
my
next
worst
step
nightmare.
once you get that number?
You would multiply by 1/2 or 0.5.
Emily, what's your worst
Can you do
nightmare?
that for
Well,
us,
somebody
please?
might ask me to like publicly do physics.
That'd be 3,415.68.
What does that represent in terms of the energy into the taillight? I realize that we're not dealing with the proper units, but does that represent anything as it relates to the energy that's imparted on the taillight?
That would be the energy to the arm
Okay,
that's being transferred.
understood. 3,415.68, is that right?
Correct.
And that was at what mile per hour?
24.
Let's move to a different equation.
Great.
Now I'd like you to presume different numbers.
I don't know what the question is.
Brennan objected and the court said, I don't know what the question is. Because he said, we're moving on. I'd like you to assume different numbers. And he hasn't finished asking the question.
Can you do the same calculation using the 9.38 pound arm that you actually used in your testing for the mass?
Yes.
And can you use the velocity of the actual test you did of
gonna have to
29 miles per hour?
Page Dr. B and see if he can make me another coffee.
Okay. And same thing, not worried about units?
Correct.
Okay.
The
What's the
chat's
first thing
worried
you
about
do
units, but
in solving that
they mostly have to
equation?
do with measurements
So
of
if you
wingspan at this
square the
point.
29 miles per hour, you will get 841.
What's the next thing you do?
You multiply by 9.38,
What's the number?
Request more coffee is the next thing I do.
7,888.58.
And what's the next thing you do in the equation?
You multiply by 1/2 or 0.5,
And what's that final number?
3,944.29.
That would be the number or the amount of energy imparted on the arm at 29. Is that right? 29 miles per hour?
So ask it differently.
Sure. What is that 3,944.29 number? What does that mean in terms of the kinetic energy?
That would be the kinetic energy that the arm has if it were moving at 29 miles per hour and weighed 9.38 pounds.
One final calculation. What is the percentage difference between 39, 44, 29 and the other test that we just did, or the other calculation, 34, 15, 68?
He is mathing. He's still mathing. I like the pen he's using, though.
So in terms of a percent difference, again, when you're subtracting the two and then dividing by the sum divided by 2, so that's basically the average of the sum, it is 14% difference.
Which of the two tests, the two energy equations that you just
They're
did,
doing physics. I need
which
more.
represents the higher kinetic energy imparted to the arm?
you.
The 24 mile an hour test, that's the hypothetical, or the actual test at 29 miles an hour? Which one?
The 29 mile per hour speed with the arm weight of 9.38.
What does that mean, Dr. Wolfe, in terms
Help!
of the testing
Coffee!
that you did with the lighter arm, 9.38 pound arm, at the 29 mile an hour test, as it compares to the hypothetical
Dr.
24
Bisas.
mile an hour test?
It would be more force and more energy in the 29 mile per hour.
I deeply suspect that the popping noise that everybody keeps talking about in court is either a water bottle or binder clips. I can't figure out which one. It's either a water bottle or binder clips. And Hannah said, I recognize this smile Emily just gave Dr. B. Yes, it was the please. Yes, Dr. B is grabbing some more coffee because it's needed. So it's either binder clips or like a water bottle. I think it's binder clips in court.
Impact test.
Even though you used a lighter arm? Objection.
Sustained.
And what was your opinion and conclusion as it pertained to the subject taillight using
ask if
the
the lighter arm
29 mile an hour
mattered.
test? What was your opinion and conclusion as it pertains to the subject taillight?
China Dalton in the chat, thank you.
Inconsistent with the damage that you saw on the 29 mile an hour test.
It was inconsistent.
And that's the point, right? Does it matter?
Thank you, Your Honor. That's all I have.
I really wanted to get to the ultimate, did it matter to you? I think we saw that it doesn't, right? But does it matter? And we are on recross. Lisa G. Brennan did make a big deal out of it because Brennan keeps trying to confuse the issues on cross. Just keeps using that binder clip. Thanks, Dr. B. Oh, wait, you gotta
May I,
wave
Your
hi to
Honor?
the chat.
Yes.
You can't come in and not wave hi to the chat. Dr. B says good morning.
Morning, doctor.
Good morning.
Oh, Brennan said hi to you. He said, good morning, doctor. I'm teasing. He was talking to Dr. Wolfe, but we're going to take it anyway.
Doctor, did you have a chance to speak to anybody from the defense this weekend?
Not over the weekend, no.
After you left here Friday?
On Friday, I let them know that I was returning back home, and then I let them know last night that I had arrived, yes.
I have arrived. And that is completely appropriate. It is scheduling. But he wants to know, did anyone tell you to ask for your transcripts? Did anyone tell you to do this? Does anyone tell you to do that? Talking about scheduling is fine. He's like, I'm going home for the weekend. Fine. I'm back. Fine.
Did you receive any new information or have any conversation before you came in today?
No.
Now, when we asked you about weight last week, you did not go into any calculations about the difference between the standard arm, 11.86, and the 9.38, did you?
I don't believe we did, no.
That coffee is
In fact, when you testified last week, at the end of the day, you were asked questions by Attorney Jackson about the weight of that arm, correct?
Yes.
And when you were asked about the weight of the arm, Attorney Jackson asked you if you were asked a lot of questions about the difference in the weight of the arm, about 11.8 pounds statistically as it relates to Mr. O'Keefe versus 9.4 pounds. Do you remember him asking you about that?
Yes.
And you were asked whether you were aware whether anybody had measured the weight of John O'Keefe's right arm. And you responded, I'm not aware of that, no. Do you remember that testimony?
Yes.
And then you were asked, when you asked questions about whether or not his arm was 11.8 pounds, are you aware of anybody ever just weighing just his arm? And you said no.
Correct.
That's what he said.
And finally, you were asked, what is that based on, 11.8? Where did that come from? Remember what you said?
Yes.
He said he
I
thought
don't know.
it was statistics, I think.
Remember you answered Attorney Jackson and you said, I don't know where that came from.
He said, I think it's a I'll just let it go.
Right, referring to, I don't know what source you pulled that 11.8 from.
He said, I think it
And
was.
so you were suggesting that that is just a number pulled out of thin air, right?
He didn't suggest that.
Was that a surprising estimate, 11.8 to you?
I don't know that it was surprising. I don't know what your source is for it.
Well, when you engage in accident reconstruction, you never just take somebody's limb and sever it and throw it on a scale, do you?
Well, it's early,
I'm not
Brennan.
usually doing that part of the analysis, no.
So when you're relying on body weight and different parts of the body, there is strong statistical studies that give you a guide, isn't there?
I would agree with that, yes.
Well, the numbers just aren't in thin air. If you're doing a study and you have to figure out damage to an arm or a foot or a leg, and you have to come to an estimated value or weight, you have to get that information from somewhere, don't you?
I would agree, yes.
So you just make it up out of thin air. You have to find a resource, a reliable,
Oh, my goodness.
vetted resource.
No one is intimating it's being
I would agree.
And that's
made
what
up
you
out
do.
of thin air, sir.
In some instances, yes.
Well, in this case, you chose an arm that was 9.38 pounds. Where did you get the support that the 216-pound, 6'1" man would have an arm that weighs 9.38 pounds? Where did you get that from?
Well, it's conservative from the standpoint, if you think about one of the equations we talked about last week, force is equal to mass times acceleration. So if we take the acceleration data from our test and we multiply it by a lighter mass, the 9.38 pounds, it's less force to the arm. So now if you want to increase the mass of the arm, you're now talking about a greater net force to the arm. So it's conservative from a force perspective.
You started
Put
it.
aside your story about the force perspective. My specific question is,
So it's sustained, ask the question differently.
I'll ask you again, Doctor.
Jackson's just like.
Where you got the 9.38 pound value from when considering a 6'1", 216 pound man.
That's not what he said at all. The 9.38 value is the weight of the arm that you were saying, no, you keep trying to increase it a little bit. It's not 10. It came from your questions. Oh my God, stop
Get
it.
that from so you could be statistically accurate.
It is the mass of the hybrid 3-arm. We saw the photograph that depicted the weight. Again, how you account for that when you're doing the force calculations is you would utilize the acceleration data that we measured, and then you would apply a different mass, in this case, a heavier arm. And I will note, it's the same thing that Dr. Welcher did in his drop test with the hybrid 3 head. He ultimately measured the acceleration of the head, and then to calculate the force, he adjusted the mass of according to Mr. John O'Keefe's mass of his head.
So for the third time, I'm going to ask you just a very simple question. Dumb it down for me if you can, okay, doctor? Where did you get the source?
The sarcasm is off-putting.
To legitimize using a 9.38 pound arm for a person that's 6'1",
That's a fair question.
116 pounds.
It just gets so lost in the snark. The whole preceding snark just turns off my brain to listen to what follow-up is a very good question, which is, are there any studies that support using this size test arm for this size human? That's a good question. It gets lost in the for the fifth time.
Where is your source to say that arm is validated to use for that size man? Where is that?
Again, it's the weight of the ATD arm. That is what the 50th percentile arm weighs. As I mentioned, in our field, it's accepted to utilize the acceleration data, and then you adjust the force based upon an increase in mass.
Did you do that? That's fair. Did you adjust the force?
Yes.
Mr. O'Keefe's body weight and size does not put him in the 50th percentile like the 9.38 arm. He's closer to the 95 percentile. Isn't that fair to say?
Correct.
And there is, in fact, a 95 percentile crash test dummy.
That's
isn't there?
fair question.
There is, yes.
Yeah. You chose the 50th.
So John O'Keefe is closer to the 95th percentile, not the 50th percentile. Why did you choose it? Those are good questions. Fair questions. Again,
50th percentile, which is shorter, yes?
Correct.
Weighs less, yes?
Correct.
And the arm weighs less. True?
Correct.
The truth is, you have absolutely no
questions.
study, no paper, no article that supports using a 9.38 arm for a 216-pound man who's 6'1". You have not one reference or study you can offer us right now, do you?
I don't agree with that because, again, if you look how Dr. Welcher did it, he used the 50th percentile in his drop test with the head, and to calculate the force, he adjusted for Mr. John O'Keefe's mass of the head. Same thing is done in this instance with the lighter arm. We adjust for that in the calculations.
You have one paper.
Brennan, your expert used the 50th percentile head. We used the 50th percentile arm. Same. It's a good answer. It's good questions, but it's a good answer. This is an interesting line of questioning to go down if your expert also uses the 50th percentile testing dummies. Yeah, Welcher did the same thing. Do any studies support that that's okay? Well, yes, where the ADTs or ATDs or whatever they're called are allowed to be used. Sure, okay.
One study. I know the answer to this, so let me ask. You have one paper,
That's too simple.
one study to support that it is appropriate to use the 50th percentile 9.38 arm for a person who is 6'1", 216
No, there's no
pounds.
studies directly
I won't
on
ask
that
you again,
point.
but if you can answer this once for me. Do you have one paper, one study?
Objection, Your Honor. It's compound as fuck. He's now asked 7 questions, made 3 comments, and what? And there was the objection.
I'll take out the commentary. Can you answer that question?
He's like, I don't even know what the question was.
Sorry, can you repeat the question?
You have one paper.
What?
Give me a name, an author, one paper, one study that supports using a 9.38 arm, 50th percentile, when you're doing a crash test for somebody who's in the 95th percentile who weighs 216 pounds and they're 6'1". One paper, sir.
I don't have a paper because Dr. Rentschler is addressing the forces and the injuries to the arm.
You talked about, however, would you come up with the number 11.8? Like it was something that is...
Dr. Wolf's like, remember, we're here to test what Dr. Welcher did, so we're just responding to what Welcher did. That's all. We're responding to what Welcher did. So they use 50th percentile, we use 50th percentile. Fair.
curious or foreign
Fair
to you,
answer.
right?
Objection.
Sustained.
Are you confused how the number 11.8 would come up?
Objection.
I'm going to allow that.
I'm not confused. I don't know your source for it.
When
I'm not
you
confused, but what?
do studies, would you agree that the head has a similar weight to the arm and that the weight of an arm would be about 5.48% of a person's body weight?
I'm sure that there's various studies out there that talk about that. Could be one particular study.
Well, let's talk about one study. What do you think? You're the engineer, you're the expert. When you're weighing an arm by percent, what is the percent of the arm of the total body weight?
I don't know as I sit here today off the top of my head, no.
I'm sorry?
I don't know as I sit here today off the top of my head.
Well, if you don't know the percent of body weight of the arm compared to the whole body, how would you ever come up with a number for the arm?
Well, from the work that I've done with Dr. Rentschler in this case, dating back to last year, it's my understanding that his calculation for the arm was approximately 11 pounds.
So you're relying on somebody else's study? You're doing an independent assessment.
Hank, my second coffee hasn't kicked in, but he's here to evaluate your expert.
Of the evidence, and
Okay.
you're relying on other people's math? Is that what you're telling us?
No.
I don't agree with that because, as I've mentioned
Not what he
numerous
said.
times, Dr. Rentschler and I worked as a team on this case. You can't separate the reconstruction part from the biomechanical part. It's an integral part that works together on it.
Would you agree that the arm is about statistically vetted, that it's 5.48% of the total body weight? Would you agree with that?
It sounds about right, but again, I
Okay.
don't have the percentage off
So
the
if
top
you
of my
take
head.
5.48% of a 171-pound man, which is the crash test dummy you were using, the 50 percentile, what do you get?
You said 5.48%?
Yeah.
What?
Just over 9 pounds,
Okay. Close to 9.38?
9.37.
Okay, now when you have 216 pounds, 5.48%,
11.8.
11.8. Sound about right, doctor?
By that calculation, yes.
Okay. Now, you said you had some confusion where I'd get that number from, this 11.8. Do you remember that?
Yes.
Okay.
And when I threw out that number, is that the first time you heard of that number?
The 11.8?
Yeah.
Yes.
Or 11, is that the first time you heard of it from anybody?
Well,
11
now
pounds?
you're just trying to adjust
Is that
down,
a new number
Brennan.
for you?
I don't understand your question.
Well, you're saying that.
It wasn't a
when
question,
Attorney
that's
Jackson
why.
asked you, where did Brennan get those numbers from? You said, I don't know. Remember
exactly
that?
what he said.
On
Correct.
Friday? Do you know where I got the number 11 pounds from?
11.8
Yeah.
or 11?
11.
I don't think you did.
As I just mentioned, last year, I believe I testified in a previous proceeding that it was about 11 pounds.
Yes. Your testimony, 11 pounds. Your prior testimony, right? You
Yes,
testified before under oath in this case, didn't you?
correct.
And when you testified under oath and you were giving a general estimate about the pounds of Mr. O'Keefe's arm, based on your experience and your training, you said it was around 11 pounds. Those are your words, right?
Correct, yes.
Under oath.
Yes.
Right. You can't delete something that's under oath, right?
What?
And so when you feigned confusion on Friday about this 11 pounds,
Sustained.
so when you answered questions last Friday about wherever this 11.8 pounds came from,
The changing of the mark is incredibly frustrating because it's if a witness is being disingenuous, if a witness is playing word games with you, if a witness is doing all of the weaselly nonsense that we have seen some witnesses do, the most effective way to prove that to the jury is to ask simple, short questions. But when you keep moving around the goalpost, the witness isn't the one that looks evasive for me. So if Brennan genuinely thinks that Dr. Wolfe is being evasive, short, simple questions. And you'll see it through the witness action. Not saying, oh, you don't like that question? You don't need to do that. Your job is to show the jury what the testimony is through your questioning. Again, I think what rubs me so much the wrong way with Brennan's questioning is that he questions very much like a defense attorney in the role of the prosecutor. And so it's a disconnect for me, the way that he cross-examines the witnesses by trying to create confusion instead of saying, well, you did all of this to say that you just picked whatever you wanted to do. That's what he's trying to get at. But also, Brennan went through the questioning saying, so the arm you used was smaller, lighter weight, and all of these other things. Okay, I mean, wouldn't that indicate that it might do less damage? Because imagine the questioning on the other side. Oh, you used the heavier arm. It's bigger than John O'Keefe's arm. Isn't that going to do more damage? You wanted this to look worse. So it's a lose-lose for the witness. But does it seem like a serve saying you used something that is lighter weight and might be smaller in your testing? Because everything we heard from the Commonwealth witnesses is I was trying to give the conservative estimate. Okay.
You weren't so confused about that because you've used 11 pounds before yourself, haven't you?
Yes, but again,
know where
I
you
don't
were
know where
getting
you
the
got that
number.
11.8 from. So,
Well, we just did the math, didn't we?
yes,
Okay. And you used a calculator to help you, didn't you?
I did.
The
Yes.
calculator works?
Yes.
Okay. You said you wouldn't calculate the difference, but you did. And so what you just went through this exercise is you divided
Can someone get Brennan a
difference.
Snickers? It's too early
that
for this.
2.48 pound difference, right?
Correct.
And then you divided it by 11.86. Divide 2.48 by from the 9.38.
Brennan,
Okay.
What percentage do you get?
26.
Would you agree with this statement about whether the arm and body weight,
Brennan, I have
comparing
to
the
feed
weight
my
of the
Snorlax.
head to the
Like,
arm, would you agree
Can we just?
that the head and
Can we
arm
not?
are actually almost identical because your arm, just one of your arms, including the hand, forearm, and upper arm, is about 5% of your total body weight? So for someone who weighs 216 pounds, that's about 10.8 pounds. Would you agree with that?
I didn't do that calculation, so I,
Didn't ask you. I'm asking if you would agree with that.
can you repeat the question, please?
So ask the question.
Does the arm weight weigh the same as the head? Or the arm does weigh the same as the head, almost identical because your arm, just one of the arms, including the hand, forearm, and upper arm, is about 5% of your total body weight. So for someone who weighs 216 pounds, that comes out to about 10.8 pounds.
What?
Would you agree with that?
I haven't done the calculation.
I thought we were at 11.8. Why are we now at 10.8? What?
But if the math checks, then yes.
Okay. Would you agree with this statement? The heavier the object, if it gets hit center mass, that's going to be even greater force because that is more mass than just 11 pounds. So the acceleration is the same for each body part. It just depends on the weight of the body part and how heavy it is to determine the force that's actually exerted on the body. Do you agree with that?
Objection.
I'm going to allow the question.
Do you agree with that?
I didn't hear the rest of what
Yes,
Jackson
and I think I
said.
described that a little bit earlier. Is you would increase the mass, you multiply it by the acceleration. That's going to increase your force. Force is equal to mass times acceleration.
Right. So mass has a direct correlation to force. You agree?
Correct.
So therefore, the heavier the object, if it's colliding at the same speed, will create more force than a lighter object. You'd agree with that, wouldn't you?
Correct. More force on the arm. Yes.
Right. So weight matters, doesn't it, sir?
Oh, we're back to the
Yes.
exact same questions.
Force is mass times acceleration. So if the arm weighs the same as the head, you're still going to get the same force. And so inevitably, you change the mass, you change.
Isn't that what he's been saying since Friday? My sky is very growly. Isn't that what he's been saying?
The weight, same speed, it changes the amount of force.
Correct, yes.
Yeah, okay. When you did calculations in this case, you never took the estimate of 11 pounds, although it didn't exactly calculate the 5.48. You never took that 11 pounds and determined the percentage difference between the mass in that arm and the mass in a 9.38 pound arm, did you?
No, I did not.
You didn't include it in any of your PowerPoints.
No.
You didn't explain it to the jury that there's a difference in weight matters.
Again, that's something that Dr. Rentschler is going to discuss.
I'm asking you because you testified, you gave opinions, you got a PowerPoint. Did you explain to the jury about the difference in force when there's a change in weight? When you did all your PowerPoint and calculations, did you break it down for them?
Well, I think it was certainly stated. I mean, I know that we went over Newton's second law, force is equal to mass times acceleration, right? So if you increase that mass number, it will increase the force.
When you were putting up your PowerPoints with the...
Use the force, Emily. It's Monday. It's very early. It's very early for this.
speeds, did you explain to us that there's a difference when you change the mass so that if you used a lighter arm, there would be a difference in force? Did you explain that to us in any of your slides?
I don't know that I explicitly stated it, but again, that's why we went up to 29 miles per hour to account for that difference in weight.
Were you trying to inflate the force?
Which they didn't explain before the cross-examination, and now said, okay, but that's why we did these multiple tests. Oh, okay. Okay. And everyone in the chat, I see you. I've seen so many comments of y'all going, you know what? You're making me miss Lally. I see you, chat. Look, defense attorneys and prosecutors have very different jobs. Very different jobs. And so it sits differently when you are in the different role. And that's, I think, where Brennan runs afoul on some of these. It is snark that is not earned.
Force for the speed of test, so it looked like the collision had to happen at a faster speed to cause a certain amount of damage. Were you doing that intentionally?
No.
You didn't overstate the mass. You didn't use an arm that was 14 pounds that would have created the opposite illusion, right? You used a weight that was lighter.
It would have made
than
it
Mr. O'Keefe's estimated arm.
true.
Right, because again, it goes both ways. If you increase the mass of the arm, you increase the force on the arm. So there's going to be more force acting on the arm.
Let's talk about your studies with Mr. O'Keefe's sweatshirt and his arm, and you gave some opinions about what you would expect for damage to his arm.
That's not exactly what he said.
When I asked you on Friday whether you
also
had
compound.
any support, any vetted journals, learned treatise, any support whatsoever about
Learned
whether you should
treatise?
use a crash test dummy arm for these types of studies, you didn't have any support on Friday. Do you have any today that you can refer to?
No.
He's like, no, I was at a soccer game. I'm being hyperbolic.
Putting aside the fact that you
I
have
think soccer season's over.
absolutely no professional studies or journals to support that you should be using a crash test dummy's arm for these type of tests. Are you aware of the expert literature in this case that the opposite, you specifically should not use crash test dummies when you're trying to do this type of analysis on clothing and a person's body? Are you aware whether that exists?
I'm not aware of those studies, no.
As a inquisitive engineer, wouldn't you want to know if there was legitimate studies in your world, in your profession, that suggests or states that you should not be using crash test dummies to determine injury to the arm?
You know what evaluation this witness is not doing? Right. The evaluation of injury to the arm. Right. Because that's not his part of it. So again, he's cross-examining this witness on the other witness's testing to try to undermine it. Undermine it.
As far as lacerations.
He's going to say, that's what Dr. Rentschler did. I didn't do that.
I think, again, you're getting confused between my role and Dr. Rentschler. Can I finish, please?
No.
So,
Can I finish? No.
comment, Mr. Brennan, answer the question, please.
I wasn't addressing the lacerations or
I
the
wasn't
abrasions to
addressing
the arm,
injury.
sir.
You had photographs and you were opining that you would have expected or you would not expect there to be abrasions or cuts on that clothing in your test A and B, didn't you?
There were no
He didn't say
holes
what he would
or
expect.
cuts in the material, no.
I understand, but you offered opinions. Didn't you offer to the jury an opinion that the abrasions on Mr. O'Keefe's arm were inconsistent with your tests in A and B?
Conceivable.
The cuts and the holes are inconsistent.
Sir, when you are assessing cuts and holes on clothing, you need to make sure the predicate as a basis that you're using the right properties, right?
Agreed. I agree with that.
I would agree with that.
It's a good question.
And so if you've been...
It's just lost in the sauce at this
If there was
point.
literature directing that you should not use a crash test dummy to assess injury on an arm, would you follow that instruction or would you do it anyways?
Wouldn't you want to know that? He's like, I don't know. I don't assess injury. So I don't know.
Again, you keep saying injury to the arm. I was looking at what happens to the material when it makes contact with the tail light.
A crash test dummy's arm is harder than a human arm, isn't it?
Yes.
You push a human arm, it's like an indent. You can push in, can't you?
That's a better question. That's a much better line of questioning. Humans are squishier than the crash test dummy. So wouldn't the crash test dummy injury or damage to clothing potentially show more damage to clothing because it's more rigid? That's fine. It's firmer. Great. That's a decent line of questioning. However, it's so buried under everything else, I think the point is probably lost. But maybe it's not.
Yes.
And that property of pushing
That's a fair
in,
point.
if a cloth is on it, it is easier for a cloth to tear pushing in than if it's hard. Isn't it?
I don't know that I agree with that.
Well, you did.
This makes using the lighter weight arm really even more important.
Do you disagree with that?
Well, the hybrid arm is of vinyl flesh, so it's not rigid.
Do you disagree with what I just said?
He said
Can you
flesh.
repeat your question?
Sure. Human arm, softer than the hybrid, yes?
Yes.
When you push it, you can push in, much different than the hybrid arm, which is stiffer.
Humans
yes?
are squishier.
I don't know what you mean by much different, but there will be a difference, yes.
Well, is it a noticeable difference to you if you push a hybrid arm as opposed to a human?
Are people squishier? How much squishier are people on average? What is the average squish factor?
Human arm?
Yes.
When you push a human arm, it indents, yes?
Correct.
And so if you push with cloth on, the cloth indents, yes?
Correct.
Which creates an easier, tear in the fabric with less force if you can push in as opposed to a hard arm. Would you agree or disagree with that?
I would agree with that.
So when you're replicating studies and giving opinions about a person's arm, a real person's arm, using a hybrid arm doesn't seem to be an appropriate...
Brennan, my guy, the jury is going to be happier to see some type of testing done with instrumentation vis-a-vis paint. I think they're happy to have the two to compare and contrast. But also, this point, if it was made at the beginning, would have been much more helpful, I think. Because at the beginning, it would have been, so if the arm is squishier, wouldn't you expect it to have less damage? Sure. I think the bigger problem for Brennan in this is that the damage to John O'Keefe's hoodie, it's not that it's less, it is less, but less isn't the biggest issue. It's that it's a different type of damage entirely. I think that's the bigger issue. But also, if the Commonwealth's theory is that he was hit and then fell onto the grass, and the theory seems to be that the damage was caused by the pieces of taillight, then why the fuck are we arguing over road rash? If you're not saying there's road rash here, then why are you fighting with him on this? That's not what you're saying happened either.
Standard, does it?
I don't agree with that because, again, when the taillight breaks in the test, the arm is now moving with that taillight. So it's, again, like we talked about on Friday, you'd somehow have to have those fragments accelerate.
Why does your watch look like a Nintendo? I'm just distracted now.
Accelerating at a greater velocity to penetrate that.
We're going to get to that, but I'm talking about the stiffness. Let's get back to the appropriateness of using a crash test dummy. Now conceding that a human
if he says rigid, it's going to be
different
bingo.
than a crash test dummy, would you agree that a crash test dummy is not an appropriate tool to use when determining
He's not gonna
tears
agree
in
to that.
clothing on somebody's arm? Would you agree?
No,
I don't think I would agree with that, no.
When you used the crash test dummy in test A and B, that was the 5'9" dummy?
Thank you, Angela.
Yes.
When you considered tears to clothing, you bought a new sweatshirt that was similar to Mr. O'Keefe's, an extra large sweatshirt?
Don't know if I recall the exact size, but I think one of them might have been an extra large.
And then you bought a second one that was medium. So
It's
when
fair.
you used the smaller dummy, you weren't actually
why we
using
have an
Mr. O'Keefe's size of extra large. You used a medium sweatshirt, yes?
Yes.
Because it was a smaller dummy than the size of Mr. O'Keefe. That's why you needed a smaller
That's a good question.
sweatshirt, yes?
I think it was more or less just what we could get our hands on.
Well, you had an extra large and a medium. You didn't put the extra large on in test A and B, did you?
That's a good
I
question.
don't recall off the top of my head what sizes were on each test.
Okay, could we show a picture of A to remind Dr. Wolfe?
But again, those are fair questions, because if there's jurors being like, oh, so are you trying to make the damage look worse, so you use the tighter hoodie on the tighter arm? Those are fair questions. Again, it just gets lost.
And while she's pulling that up, is there a difference between, so see that's how that's blue? You see that's medium?
Yes,
So the blue ones that you use for test A and B, correct?
correct.
The smaller crash test dummy than Mr. O'Keefe, the 5'9" crash test dummy, yes?
Correct.
And then when you used Randy and brought him into the scene, you used the extra large, the gray one.
Correct.
Right, so you used a different one because
No, I
it
think
was a
the
smaller
size, some of you are saying the
anatomical
size
doll.
doesn't matter. Emily, you're going to sit here and say size matters. I think the point the prosecutor is trying to make is a fair point. He's trying to make the point that it's smaller, it's tighter, it might not shift over the arm as much. It's going to hold on to the arm, and then you might have more road rash. Again, I think the other option I would take is, okay, but you're not saying there's any road rash to John O'Keefe's hoodie, right? Right. But Brennan's the one who brought this line of questioning up. So, but he's trying to say, look, the arm was smaller, the hoodie was smaller, so you're going to see more damage. I think it, again, of all the lines of questioning, this is a fair line of questioning to point out the differences. But he could have just gone, well, but there's no road rash here. But I get where he's
Than the
going
size
with
of
that.
Mr. O'Keefe, yes?
We used different sizes. The material blend was the same.
This was new.
Correct.
The extra large you put on Randy was new.
Correct.
Did you consider the wear and tear on Mr. O'Keefe's sweatshirt, the extra large sweatshirt he was wearing that night?
The wear and tear?
Yes, the wear and tear.
Well, like how many
No.
times had
Did you
been
ever
washed?
consider the differences between a brand new sweatshirt and one that had been worn?
No.
Had you ever had clothing, sweatshirt you used repeatedly, maybe put in the dryer, wears it down? Sometimes you can get holes more easily. Have you?
Nope.
Did you do any type of analysis on that whatsoever?
No, I'm gonna allow that.
Any type of analysis whatsoever on the age or whether it's stretched the same, anything like that?
No.
No variables whatsoever on the sweater, did you?
No.
Did you run into yourself with a car? No? Okay. Sure.
Does it matter whether or not the sweatshirt is tighter or looser or how it fits the body?
That
Is
was
that
a
any
good
part of your
question.
consideration?
No.
Have you ever done testing like this before for clothing?
In terms of impacting a taillight?
Yes.
No.
So this is the first time ever that you've done this type of analysis and offered an opinion in front of a jury on this?
Specific to impact.
Yes, because often when people are hit by cars, it's fairly obvious that they're hit by cars from other factors, so you don't have to do this kind of testing.
An arm with a taillight, yes.
Before you decided to come in and give an opinion, did you take any study or look at any journals on fabrics?
No.
Did you consider any of the variables
Was
that
it a
one would
double
want to
loop stitch
consider
on the
regarding
top
fabrics
hem?
before you came in and gave this opinion?
No.
Did it concern you when you were coming in to give a professional opinion about something you've never done before, whether or not you were studied in the area before you did it?
Well, I think I relayed my observations from the test, right? I certainly explained how we set up the arm, how the arm was closed. You all obviously saw the
I really wish that Dr. Wolfe at some point would say, well, we came in to evaluate the testing that Dr. Welcher did. And it's because that type of testing had not been done before either. So we were trying to evaluate in a more scientific way than using paint. What happened here? I wish you would keep pointing it back to Welcher. Also, where there was a great Legally Blonde quote, but there's almost 50,000 of you in here and it jumped. So to everyone who also quoted Legally Blonde in the chat, thank you.
impact testing to the arm. So I'm relaying my observations from the test that we did.
Did it concern you that you were coming in to give an opinion on something you have never done before and that you did absolutely no study on fabrics or any of other people's analysis on fabrics in cutting? Did that concern you?
No.
So you were comfortable just coming in with no experience in this whatsoever, without even studying or doing any research? You were comfortable to come in and just throw out an opinion?
That's
No,
not
again,
what happened.
and Dr. Rentschler is going to address part of this. We worked as a team, so there's a synergy between the two of us.
Well, putting aside the synergy, you're the one on the stand under oath, yep?
Correct.
You're the one testifying, giving opinions to this jury, yes?
At this moment.
Yes.
You're the one asking them to rely on your experience and training, true?
Correct.
You're the one asking them to rely on your judgment and your effort to be accurate, yes?
Yes.
So when you give the opinion, you have a personal responsibility to support that opinion, putting aside Dr.
Well, he just
Welcher or Dr. Rentschler. You
showed
have
his work.
responsibility for your opinion, don't you?
I would generally agree with that, yes.
Generally?
Yes.
When wouldn't you? When would not be general? Don't you have an obligation every single time you take the
Objection,
stand and give an opinion
compound.
to be supported, valued, vetted?
Yes,
single time?
and again, Dr. Rentschler is addressing those abrasions and lacerations, which certainly correspond to the material.
Right. But you didn't wait for Dr. Rentschler. You offered a number of opinions to this jury. You personally, under your name, you came in and presented yourself as an expert in this subject. You, didn't you?
Correct.
So putting aside Dr. Rentschler, his opinions,
Excuse me. You have a PhD though, right? Okay.
you
Just
stand behind your opinions.
sorry.
Yes.
Hallucinated for a moment.
And you do that despite the fact you've done no study, no research, haven't vetted, and have no authority whatsoever.
Oh, that's
Yes.
compound.
You wrote a report back on February 12, 2024.
After everything we've seen, I
Correct.
just don't see it as well taken. For all of you saying, isn't this badgering the witness? No. Is it a rude cross-examination? Yes. His tone is incredibly rude and dismissive. But his tone, he's trying to indicate to the jury that they should also dismiss this witness. And you never know. You never know what a jury is going to do. They are in court. They have to watch the jury and determine whether the jury likes this witness or not. There will be jurors that like this witness. He was easy to follow, and he brought in video. Look, 8 weeks into a trial, can somebody show us something? Can you show me what you're talking about? Great. So it is interesting to see the different styles of cross-examination, but no, it's not badgering. Is it rude? Yes. But is it for the court to shut down? No. If the jury finds it to be incredibly rude, they will stop listening. They will just want. If the jury doesn't like the witness, they'll sit there and go get him. I'm not suggesting that's happening with this witness, but if you have watched witnesses that you don't like, and then they get into them on cross, you're like, get it. Yeah, ask them that. It's not earned here. It's just, that was user error. Apologies. We've inappropriately moused, and then we ended up with the screen yeeting itself. So we'll continue on. But it really depends on the jury.
In February 12, 2024, do you remember talking about
Some of these are asked and answered, though.
injuries to the arm and damage to the taillight?
Generally, yes.
Okay, that's fair.
Specifically, no.
Do you remember writing in a report, it is significant to note that the injuries have been classified as abrasions and analysis of the autopsy photographs indicates minimal bleeding or lacerations of the dermis?
So the report that you're referring to is a joint report authored by myself, Dr. Rentschler, and Mr. Scott Klein. So that would have been a portion drafted by Dr. Rentschler addressing the injuries.
I see. So in this report, it has your name, Dr. Rentschler, and another person, Scott Klein, yes?
Correct.
But in the report, none of you ever differentiate which opinions you're standing behind or somebody else's, right? I'll move on.
The objection sustained.
I'll move on.
I'm backing up because I'm very curious to hear where that went. Because did you hear how quickly Brennan said, I'll move on?
And Mr. Scott Klein. So that would have been
I
a
backed that
portion
up.
drafted by Dr. Rentschler addressing the injuries.
I see. So in this report, it has your name, Dr. Rentschler, and another person, Scott Klein, yes?
Correct.
But in the report, none of you ever differentiate which opinions you're standing behind or somebody else's, right? I'll move on.
The objection sustained.
I'll move on.
The objection sustained.
Oh, he said outside the scope.
Did you agree with that?
Agree with what?
Sustained.
Did you write or
I'll move on. Do you agree with that? So outside the scope. It is outside the scope. Recross is not you get to start over. You have to stick to what was in redirect.
endorse these injuries would not result from impact with a non-damaged tail lamp cover, and the amount of force
I think that's
required
outside
to
the scope,
fracture the tail light cover would
So I'm going to see you inside, Bob.
Jackson has made better headway by just not backing down with his objections, because Jackson does this too, where he will just talk over the person rejecting. Brennan does it too. But the two of them, Jackson's just like continuing to ramp up until she said, I'll see you at sidebar, which I think is what Jackson wanted, which was for Brennan to stop talking and reading in questions when he said he was going to move on. They are going to sidebar. I wonder if they sent the jury out for the morning break when they went to the fan. We zoom past all of that. I don't know if they did or not because I just zoomed.
You were asked questions about impact with the taillight. And in fact, in one of your answers to me today, you talked about after a vehicle collides with a pedestrian, there's continued movement between the vehicle and the pedestrian, isn't
He
there?
did say that. Correct.
And so while glass that, or plastic that shatters from a taillight might not impale clothes of the skin, would you agree, if your dummy wasn't restrained, when the Lexus collides with the dummy, there'd be continued contact for some time, extended contact between both the dummy and the taillight?
Well, the arm, as is demonstrated in the test, would be moving at roughly the same velocity as the vehicle.
Yes. And don't you think that the vehicle would continue to drag the arm until the body either was thrown or spun off? Would you agree with that?
At some point, they will separate, yes.
At some point, but before the at some point. What I'm asking is, at the collision, when you see all the taillights shatter, right, wouldn't the Lexus, if it continues at that speed, say 24 miles per hour, for example, it would continue to drag with that dummy's arm longer than is shown in those experiments because the dummy is restrained?
Sorry, can you repeat the question?
Yes.
Yeah, it was
Would you
hardly
agree?
compound, but
That if a Lexus is backed up at 24 miles per hour and hits the dummy's arm and the taillight shatters, if the dummy wasn't restrained and moved regularly,
wouldn't it keep moving
it would
forward?
extend the contact between that shattered taillight and the dummy's arm. Do you agree with that?
It would move with the vehicle until it got pushed out of the way, just move to the side,
And
yes.
so what you
And in the paint experiments, that was almost immediate that there was a rolling motion and Welcher moved away from the vehicle. And with Randy, we saw it too, that he spun pretty quickly. What Brennan is saying, if he wasn't restrained, wouldn't he have gone with the vehicle before he spun? Again, that's a fair line of questioning. Wouldn't this have been different in real life because somebody's not just suspended from a harness? Fair questions. I think they're just too late in the recross.
saying is it would move with the vehicle but wouldn't touch the vehicle?
Well, in the one test, if you remember, because of the restitution effects, the arm reached a speed of over what the impact speed is. So in some instances, it actually might move at a speed greater than the vehicle.
Fantastic. In some instances, would it move slower and be dragged by the vehicle's broken taillight?
Is any of it fantastic?
Dragged?
Yeah,
I don't know
so
if
when
I
say
understand.
drag, push. How about we use the word push? Pushed by the broken taillight. Could
Pushed
that
and
happen?
dragged aren't the same.
The arm would move with the taillight until it moves out of the way.
So you're saying it would move with or faster, but never would slow down where it gets pushed by the car?
It's moving with the vehicle, sir. I don't understand your question.
Well, no. You said it moved with the vehicle. Sometimes it moves even faster, suggesting space between the broken taillight and the arm. That's what you're suggesting, right?
Correct.
So it can
The
move
space
with-
between my patience and the caffeine
Whenever it
kicking
moves
in
slower
are
and the
limited.
vehicle pushes and drags against the
No.
arm.
Too far. They're too far.
I mean, it might be able to move a few miles per hour if it doesn't have as much of a center of mass hit, but it's still going to move out of the way because it's on a joint.
I understand, but before it moves out of the way, could it be pushed by that broken taillight? That's the simple question I'm asking.
Well, the broken taillight exploded away from the arm.
Just moving adjacent with the taillight, just moving along. Yes.
Would you agree with this?
Again,
If you have an arm struck at 25,
the questions about the harnesses, I think would have been more effective if he had started there.
miles per hour, significant more damage to the significant more damage that taillight shatters, hits and moves forward into arms, parts of taillight pushed into arm as vehicle pushes forward and pushes arm out of the way.
What?
So the word push, would you agree?
What are
with
you
that
reading?
General characterization that the broken taillight can, in fact, push the arm. Would you agree with that?
What?
Generally, I guess, again, it would move with the vehicle, the arm together.
Not move with. I'm asking you if you would agree about pushing. Would you agree with that?
Salt and pepper's here, and we're here. What?
As long as we're on the same page about it, it's pushing the arm, but it's with the vehicle. They're moving together. So, but in essence, yes, the arm is being pushed due to the fact that there's a force on it.
And the pushing could have that arm in contact with the broken pieces of the taillight if the taillight broke, correct?
I'm here.
Just moving at a common velocity.
The operative word here is push. And so, do you like to agree with me or you could disagree with me? Can the broken taillight
I disagree.
push
Do I get to disagree? When do I get to disagree? I disagree.
the arm so it contacts and provides force against it? Could that happen?
Yes.
I just. I understand where Brennan is trying to go.
When you were showing those
He is just
photographs
not
today
getting
regarding
there.
test F, now you use Randy in test F, right?
Correct.
How tall is Randy?
He's 6 feet.
And he weighs 200 pounds?
Correct.
So still 16 pounds less than Mr. O'Keefe, yes?
Correct.
And you keep referring to Randy as a crash test dummy.
No,
Randy's
you
dummy,
refer to
right?
Randy as a
He's
dummy.
mannequin.
He is, but he signifies basically what happens when you have 200 pounds of mass striking the rear of that vehicle.
I don't want to misrepresent Randy. He's not a crash test dummy, is he?
I also don't want to misrepresent Randy. Oh, Brennan. Poor Randy.
Basically what happens when you have 200 pounds of mass striking the rear of that vehicle.
I don't want to misrepresent Randy. He's not a crash test dummy, is he?
Well, it wasn't used for biofidelic purposes. It was to, again, what happens when you have 200 pounds of mass strike the vehicle.
So when you've been referring to Randy as a crash test dummy, you don't mean to do that. That's a misnomer, isn't it?
He didn't refer
I don't
to
know that I
Randy.
agree with that.
So you think that Randy is a crash test dummy? He's a certified, approved crash test dummy.
No, and I think I made it
Certified
very
freak.
clear that there is
7
no
days a week.
instrumentation
Wait,
on
what?
it, right?
What?
And one of the reasons why I
Emily,
mentioned
no.
that is those ATD dummies are $150,000, so we're not going to risk impacting it with the Lexus and destroying that.
I can understand the cost analysis for you, but I want to be clear.
I can understand the cost analysis for you. You don't have the government just writing checks for a couple $100,000. So I get that you don't want to damage thousands of dollars of equipment, or tens of thousands or hundreds of thousands of dollars of equipment because the government's just not writing you checks, like just blank checks. But like I get why it's hard for you. But the point is made, Brennan, that they put instrumentation on Randy. Okay.
He's a mannequin. It's used by firefighters and drills pulling a body, dead weight, out of a house.
Well, he's a
to
rescue
replicate
Randy.
certain scenarios. That's what Randy was made for, yes?
He can be used for those, yes.
Right. He's not a crash test dummy in the parlance of a legitimate, studied crash test dummy, is he?
I
All right, y'all. Hopefully we should be back because that was not on y'all. That was on StreamYard. I have no idea, y'all. Miguelina, will you let the app crew know that we're back? That wasn't on our end, but I paused where we were in court. Apologies. That was very annoying. I was trying to message you in chat. Hopefully my messages went through on the YouTube end. Have I mentioned that we're building our own software? We're almost done with building our own software. That was really annoying. So apologies. That was a software end. Don't blame Brennan on that. Brennan has plenty of shit that he's earned, not that one. All right, let's get back to court, shall we? That was stressful. I know. We can't. A lot of you have said a lot of streamers all went down at the same time. Yeah, I'm not surprised. A lot of us used the same software. So until we don't. All right, let us get back to court. Sorry for the stress, chat. I know it. Look, it wasn't a YouTube thing. It wasn't an us thing. It was a software thing. Streaming is dynamic. Let's go back to court. Let's just, again, it's why we're building it ourselves. Also not easy, but why we're doing it. Let's go back to court, shall we? Yes. Let us get back to court. If there are other glitches, don't worry, we will be back. And we have the app. So if we ever need to start a new stream, we will just send you the link in the app at lawnerd.app.com. Because again, if things happen, we have a way to get in touch with you. It's why we built the app. Building it ourselves is just the way it's got to be. We just have to build that shit ourselves. You know, it's like Frank's Red Hot. You just put that shit on everything. We just build shit ourselves. But that was so annoying. All of you that were like, I was trying everything. It's not you. That was a software issue, not a you issue. All right. Let's continue on. I backed up a little bit, so there will be an overlap. Replay crew, look, you got to skip right over it because you have the timestamps. Could we fix it in post? We're not going to get to edit it out because then we lose the live chat, and the replay crew loves seeing the live chat when they're in the replay. So no, we're not going to do that. All right, let's continue.
To Randy as a crash test dummy, you don't mean to do that. That's a misnomer, isn't it?
I don't know that I agree with that.
So you think that Randy
We're
is
back
a
to
crash
Randy.
test dummy? He's a certified, approved crash test dummy.
No, and I think I made it very clear that there is no instrumentation on it, right? And one of the reasons why I mentioned that is those ATD dummies are $150,000, so we're not going to risk impacting it with the Lexus and destroying that.
I can understand the cost analysis for you, but I want to be clear. He's a mannequin. It's used by firefighters and drills pulling a body, dead weight, out of a house to replicate certain...
Chat. Every single person that was like, Dr. Wolfe, would you let us know what it's like to be a firefighter dragging or rescue Randy out of a home? He's the engineer, you guys. We're not having him cosplay as a firefighter. Stop it. Leave Randy alone. Also, Dr. Wolfe is like, I did physics in real life in front of a jury. I'm not also putting on suspenders and dragging Randy out of a burning home. Chat will write fanfic about it.
the scenarios. That's what Randy was made for, yes?
He can be used for those, yes.
Right. He's not a crash test dummy in the parlance of a legitimate, studied crash test dummy, is he?
I don't agree with that because, again, we use that type of dummy in all different types of tests.
There's an H395M PED, which most closely replicates John O'Keefe's size and body, isn't there?
Correct.
You didn't have that when you did the test, did you?
No.
When you do crash tests, you can put a magnetic control on the crash test dummy, so upon impact, it releases and is thrown. You could do that, couldn't you?
That is one way, yes.
Right. So that way you don't have to put the dummy on a forklift and then it creates a different scenario than real life.
Apparently,
correct?
there's magnets.
That could be one way that you could do it, yes.
It doesn't impede any roll or drag when the dummies hit. That's one reason you would do that rather than a forklift, yes?
Correct.
Also, it might show some throw, which could lead to other type of damage like holes in clothes, yes?
Correct.
But you didn't use the magnet, you used a forklift.
Because again, the purpose of the test was to evaluate, we talked a lot about those time frames, right? That 10 millisecond window. It's to look at, from the vehicle damage perspective, what happens to the taillight, right, in that interaction. And then ultimately, what is the acceleration that the arm experiences in that 10, 15 millisecond window, right? What happens 1 second after, 2 seconds after? Again, that wasn't of concern for me in my analysis.
You didn't use a magnet, you used a forklift, right?
Correct.
And when Randy went for a ride, you didn't expect him to break off the string and slide across the street, did you?
We didn't expect him to.
You didn't expect him to be thrown. You didn't expect the string on the forklift to break and then Randy to go flying. You didn't expect that, did you?
Randy went for
Oh,
a
I
ride.
certainly expected that.
So you expected a throw with that.
Yes.
And the street has hard concrete and it has a lot of irregularities to it, doesn't it?
Hard.
It's asphalt, yes.
Yeah. And the photos that you were shown today on redirect examination, did the defense show them to you during your direct examination? Any of those?
No.
Ms. Gilman, can you pull up that last exhibit with Randy on the ground? I think it's exhibit 221. Okay. And so this is Randy, right, doctor?
Yes.
Zoom in a little bit, please. What's that red thing near his shoe?
It's a good point. Brennan, why the fuck didn't you just start here? When you're making good points, just make the good points. That's a good point. Just make that point then.
Appears to be a fragment of the taillight.
I mean, however, it's the wrong part of taillight and the entire back fucking window is shattered, but still.
Can you zoom out? Could you go back an exhibit to the one before? Could you zoom in? Did you see any taillight fragments on his body or in his clothes?
I can't tell from here.
Could we have the exhibit before, please? Can you tell from here?
Yes.
Well, how did we go from him being face up to him being face down?
And finding taillight fragments on the clothes
Not the same thing.
after a collision, that's not unique, is it?
Unique? No,
Yeah.
it's possible.
Well, according to this, it's probable, yes?
In this test, that did occur, yes.
In this test, that happened.
Could we have exhibit 201D, please? Do you know what this is, doctor? Did you see this picture in your analysis?
Don't know if I recall that specific photograph.
Do you know this is taillight shards found in Mr. O'Keefe's clothing?
Objection.
Sustained.
Did you consider this photograph during your analysis before you gave your opinions regarding cuts and tears and lacerations?
No, sir.
Can you take that down, please? When you did your analysis, did you know that a drinking straw was found on the concrete on the street in front of 34 Fairview?
I don't know if it was on the concrete, it might have been on the asphalt, but I do recall a drinking straw, yes.
Did you know that there was a glass found near Mr. O'Keefe? Could you put that up, please, Cindy?
Objection.
Sustained.
Did you talked about cuts and injuries. Did you,
Sustained. It sounds like it's beyond the scope.
very well.
It is beyond the scope.
When you did test D, did you say the peak acceleration was 780 Gs?
Your Honor, may I refer to my notes?
Yes.
We're looking for peak acceleration.
Page 11 of your report.
I think I lost an exhibit. Okay.
Is that what you described it as?
For test D,
Yes.
the acceleration of, we talk about the hand,
Talk to the hand,
Yes.
the face.
780 Gs, yes.
780 Gs. Okay. When you did your comparison before you gave your opinions, you showed us a scuff on the exemplar vehicle, photo 77.
Objection.
Beyond the scope, Mr. Bowman.
A few more questions, Dr. Wolfe.
He's like, all right.
You showed us holes
beyond the
in
scope.
in Randy's sweatshirt from test F. You remember that?
Yes.
And you talked about what you would or wouldn't expect in a collision as far as holes. And did you say something like that was inconsistent with Mr. O'Keefe?
Yes.
That's what you said on redirect, right?
Correct.
Okay. Did you consider whether there were holes in Mr. O'Keefe's sweatshirt separate from the holes in the arm?
Sorry, can you repeat the question?
Yes. When you were making that opinion about consistent or inconsistent, did you ever consider whether there were holes in Mr. O'Keefe's sweatshirt other than the right arm?
Well, I know that there was cutting to the,
May I approach and retrieve the exhibit, Your Honor?
Yes.
Excuse me, sir.
Oh boy. Are we talking about the scissor cuts from first responders?
Did you ever look at the back of the sweatshirt to see if there was any holes to the back of the sweatshirt other than the right arm when you formed your opinion?
I don't recall.
Take a look at the back. Do you see other holes on the back of Mr. O'Keefe's sweatshirt?
It appears I see one hole.
Let me get a little closer so you can get a better look.
I don't know if that's going to change things.
I'll direct you to here, 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 here. Do you see more than one hole in the back of Mr. O'Keefe's sweatshirt?
Yes.
I don't know how you can see anything with that sweatshirt compressed down like that. But
When you were forming your opinions
the jury gets to decide.
that the collision would be inconsistent to damage to Mr. O'Keefe's sweatshirt, did
Anna's
you
Banana
consider...
says, why does it look all wrinkled up? It looks like the shirt has slid down while it was standing up during the trial. It looks like it has just gone like,
that Mr. O'Keefe may have fallen or landed on his back?
Well,
well,
in looking at those holes, they're inconsistent with road rash. And again, to get those kind of holes, you have to have prolonged sliding contact on a rough surface.
Did you consider that Mr. O'Keefe may have fallen or landed on his back?
Well, if you just fall and land on your back, you're not going to be sliding to get those abrasions and tearing. And again, those are not consistent with road rash.
Didn't ask that question. Did you consider?
Sorry,
just-
can you?
Did you
Told
consider
you,
whether
Regans.
Mr. O'Keefe had fallen or landed on his back?
No.
Did you know about or consider the multiple holes on the back of his sweatshirt when you came and formulated your opinions?
No.
You did no studies whatsoever about the damage to the sweatshirt if he fell or landed on the cold, hard ground and had broken taillight shards in his clothing, did you?
No.
I have no further questions.
And we're done with recross. Now we're back to raw, direct, which should be shorter, and then I think we'll get to Dr. Rentschler. No, then we're going to get to the voir dire of Dr. Laposata when they take the morning break. And it looks like the defense is looking at photos of the back of the hoodie.
You were asked by Mr. Brennan, give me one name, very dramatically, of someone.
Commentary. Yeah, there's that objection.
You were asked, give me one name.
It was dramatic, but yes.
To support using a 50 percentile hybrid 3 in testing forces on a 216-pound man. Do you remember that question?
Yes.
How about the name Judson Welcher? How about that name?
So the objection sustained.
Did Judson Welcher use a 50?
Right. Which is the point that he said in his answer. AJ's just trying to make the point a little bit more clear, but he's like, didn't Dr. Welcher do it? They're expert. Right.
Percentile hybrid in his drop test?
Objection.
So that's sustained as to form.
What did Judson Welcher use in his drop test?
That's the question.
A hybrid 3 50th percentile male, the same that we use in our testing.
Right.
You were also asked,
Identical. I know. All of you are waiting
whether
for
or
it
not
to happen.
using that hybrid 3
Identical.
arm with the same speed
Right.
would have an effect on the force equation, on the force calculation, correct?
Correct.
And you agreed it might have a small effect on the force calculation, correct?
So sustained as to form.
This is just foundational, Your Honor.
Sustained as to form.
How did you answer that question?
I'm sorry, can you repeat the question?
Sure. Let me ask it this way. In the 29-mile-an-hour test with the hybrid 3 arm, were you going faster than 24 miles an hour?
Yes.
And what was the calculation again on the increased force that would be exerted on the taillight, on the arm area of the taillight? 14%?
Yes.
Objection.
So sustained.
How much?
Leading.
What was the percentage that you calculated? The increase?
14%.
And did you find damage, even with the increase of 14%? Did you find damage on that exemplar taillight consistent with the extensive damage on the subject SUV?
Objection.
No.
We all saw the photos.
Can we have 201D put up one more time? Mr. Brennan just asked you if you made note of these little red pieces, correct?
Correct.
Do you have any idea the size of those pieces? As you sit here.
No.
Not without a scale of some sort, no.
So as you sit here, do you have any idea what the size of those pieces are?
I couldn't tell you as I sit here today, no.
No idea if they're a foot long?
Objection.
So the objection sustained.
Leading. It's also asked and answered.
You were asked,
He said he
when
doesn't
shown
know.
this picture, if you accounted for this in terms of damage to the garment, the sweatshirt, right?
Correct.
The jury knows.
What if I
those
told you
photos are
those
at this
were-
point.
Objection.
So the objection's sustained. He said he doesn't know the sizes. That's the end of that, Mr. Jackson.
I realize he said he doesn't know. He was
That's
asked questions,
the
Your
end
Honor.
of that, Mr. Jackson.
I
Do you
think.
have Mr. Wolfe, do you have the picture of the tin?
I think he should ask for sidebar on that then.
The TIN, tin, the little round tin?
A little round tin.
You see that tin?
Yes.
Are you aware that all those pieces are inside that tin?
Objection.
Sustained. And jurors disregard that.
Did you ever see this tin in your analysis?
I do recall seeing, yes, in the evidence photographs of all the fragments, yes.
Right.
In your experience, are very large pieces or very small pieces put in little tins about a
It
2
speaks for
inches
itself
wide?
at this point.
You were asked a question about the arm being pushed by the taillight. Ask a bunch of questions about
Again,
that, right?
the jury
Correct.
knows exactly what those pieces are and where they came from. The jury knows. But he said he didn't know, so he doesn't know.
What did you say in
So he
terms
has
of
to move on.
the contact by a vehicle pushing an arm?
It's going to move with the vehicle until it separates.
Right.
In your testing, how long did it take the hybrid 3 arm to get up to speed of the vehicle in the 24-mile-an-hour test?
About 10 milliseconds.
I'm sorry, say that again, louder.
10 milliseconds.
10 milliseconds, correct?
Correct.
So when you say the arm is being pushed, it's being hit, correct?
Objection.
The objection sustained and it's struck.
In every one of your tests, every single one of your tests, did any taillight fragment tear a hole in the sleeve of the shirt that you were testing?
No, there was no holes, punctures, fraying, nothing to the material.
Was there ever a defect in that garment in any of that testing other than the road rash that we saw in the 29-mile-an-hour direct impact?
That the only test that showed the holes and the abrasions was that full-on hit where the body was sliding on the ground. There was no test where the taillight caused any type of punctures, holes, or fraying to the material.
And in that test, what happened to the back of the license, the test license?
Destroyed.
I have follow-up questions.
Okay, go ahead.
Okay, and a few follow-up questions. And they're approaching. And I'm zooming. Because it's already been the most
And redirect.
the most Monday of a Monday. All right, we are on
Redirect, you
Cross.
again talked about the impact between an arm and the broken taillight.
because you asked
Correct, yes.
on
And I had
recross.
asked you on cross-examination or recross-examination whether that broken taillight could push the arm, which of course would create force or friction, yes?
Well, once it's moving at a common velocity, I'm just not understanding your question then.
If it's not a common velocity, if the broken taillight is,
Ask the question.
if the broken taillight is pushing the arm, which would mean the broken taillight is going at a faster speed than the arm, if it pushes the arm, the broken taillight can come in contact with the arm, can it?
It's moving with the arm, sir.
Okay, let me ask you this. Would you agree with this? If you
I
have an
don't know.
arm that's actually struck at 25 miles per hour, you're going to have significantly greater damage, especially if there's a taillight that shatters. So if you have the taillight coming in, it's hitting the arm, it's moving forward into the arm. You agree with that?
No, it's not moving into the arm.
No,
Dr. Rentschler, do you agree with that?
Objection.
so I'm going to allow it, strike source.
Do you agree with that?
I'm sorry, can you repeat?
I can.
He's like,
If you have an arm-
what the fuck are we even doing? There has to be a good faith basis for what is being asked. And he's saying, but isn't the car pushing into the arm? And he's saying the arm would move away as the car moves forward.
That's actually struck at 25 miles per hour, you're going to have significantly greater damage.
I don't know if he just called him
Specifically, if
Rentschler.
there's a
Did he?
taillight that shatters, so you
This is
have
Wolfe.
the taillight coming in, It's hitting the arm and it's moving forward into the arm. Would you agree with that?
Objection.
I'm going to allow it.
In reference to the greater damage, are we talking about damage to the arm?
Do you agree with that phrase?
The best way I can characterize it is it's moving with the arm, sir.
So if that actually caused fracture of the taillight, then parts of the taillight are going to be pushed into the arm and likely embedded into the arm as the vehicle continues forward and pushes the arm out of the way.
Objection.
Do you agree with that?
I'm going to allow it.
We need to approach. I need to approach.
All right. And they're approaching on that. This is not the right. Well, we'll see what happens after the
like
break.
that-
This is not what this witness was testifying about. And I don't think that this was part of redirect beyond what was being redirected from Brennan's initial questions. It's also, these are allowed to be leading. He's on cross-examination. Brennan's allowed to lead here because this is cross, but the leading's not the issue. It's asked and answered. It's an incomplete hypothetical. There's a lot of other issues. And it's very much asked and answered.
I'm going to read this one more time, okay?
Please don't.
Would you agree? If you have an arm that's actually struck at 25 miles per hour, you're going to have significantly greater damage, especially if there's a taillight that shatters. So
Then
you
what?
have the taillight coming in, it's hitting the
Compound.
arm, and it's moving forward into the arm. So if that actually caused fracture of the taillight, then parts of the taillight are going to be pushed into the arm and likely embedded into the
Compound.
arm as the vehicle continues forward and pushes the arm out of the way. Would you agree with that?
Greater than what?
Again, my area of expertise is not injuries to the arm, so whether or not those fragments would be embedded or cause any type of damage to the arm, no. But what I would say is that I would agree with the taillight being pushed into the arm. It's going to cause the taillight to fracture, and then the arm will move with the taillight.
When you do a demonstration, isn't this exactly what you see? Could you play E again for me? Isn't this exactly what you see?
I don't know. Let's see it. Save us with a video.
Play that, please.
Run that back one more time.
And now, stop, please. If Randy is not restrained by a forklift, he is going to move with the car, correct?
Well, if it's just the arm, his arm's going to get accelerated and move, and then his body will be there still.
And that broken taillight, if Randy is not restrained on a forklift, is going to be pushed
It was pushed.
by the arm, by the broken taillight, isn't it?
It's going to move with the arm.
Thank you.
All right, so jurors, we're going to take a morning recess in about 20 minutes.
Oi.
Please rise for the
Oi.
jury. Right this way.
Oi. What, hun? I couldn't hear you. I'm sorry. Court was loud. There's cookies.
They showed up.
Thanks, honey.
Figured it just didn't seem right to let them sit there all day without you knowing they're there.
Because you're gonna go eat a cookie.
Well,
Thanks, darling.
already opening the box.
I mean, do you want to come say hi to the Lawnards? We're on a morning break,
Oh, yeah,
and
so it's a good time for a cookie break,
we're all ready to scream.
right?
I think
Wait,
so.
if you're on a break, why would you scream?
It's been a very Monday.
But you have cookies.
But now I have cookies. Thanks, hon. Appreciate it. All right. Chet says hi. Yeah.
So Charles should get his today too.
Yep. All right.
Be nice.
Thanks, B.
Uh-huh.
Appreciate it. We're gonna get to a voir dire. Thanks, hon. Did he bring enough for the class? Sadly, no. Sadly, we did not bring enough for the class. We did send some to the core, but there is a bakery back in Manhattan Beach that we love, and so we shipped some cookies to T, and we shipped some cookies to us because, well, we didn't have enough room to bring them home. So there is a beloved bakery that is just well, beloved. And we didn't have enough time to eat the cookies. So yes, Dr. B brought cookies, not muffins. Let's get to this voir dire. What do I mean by voir dire? Well, it seems that we're going to hear from Dr. Laposata briefly, and then, and then we will see. No, Dr. B did not bring 50,000 cookies, but I do still have my wild grain croissant this morning that I haven't finished eating. So we'll get there. But yes, Dr. B is going to eat cookies and brought me cookies. So we have a pink sugar cookie, and we have a, I'm probably going to finish breakfast first, and then we have a sprinkle cookie. I know. She brought sprinkle cookies. Yeah, fucking sprinkle cookies are bomb. All right, let's continue on, shall we? Shall we continue? Yes, we should. Oh, for all of you local in California, Becker's Bakery. The frosted cookies are also delicious. It is a favorite. They make great sandwiches too. But that is a staple of the Manhattan Beach area. They're closed on Monday. I'm sorry, chat. That's horribly rude of me. They're closed on Monday. Do not get in your car today. You will be disappointed. The lawyers aren't getting a break.
So
The court's not getting a break.
we're not going to do the voir dire right now of Dr.
Why?
Laposata because everybody needs a break. What we'll do
No shit.
is we'll take the 20-minute recess. Who's doing the director, Dr. Laposata? Is that you, Mr. Jackson?
Yes.
All right. So what I would ask you to do is not do anything on your direct examination with Dr. Laposata that involves the mention of dog bites or the evidence regarding motor vehicle experience, because we still need to have the voir dire. But I don't want the jury sitting out there any longer than need be, at least until the luncheon break. So without that, how long will it take you?
What?
Can you use the hour?
Different credentials, but Your Honor, half the credentials are the fact that she's an expert in dog bites and an expert in motor vehicles. I give her education, training, background. But
Okay, is that all in her resume?
it's all in her. It's all going to be in her direct examination.
No. My question is it in her resume? Has the Commonwealth received notice regarding the dog bite stuff?
The Commonwealth has received the same resume that the court has received. I don't know specifically what her resume says about dog bites. I don't think it says dog bites anywhere in her resume. No.
I'm gaining that up because he's not at the mic and it's really hard to hear.
We have absolutely no notice.
But the courses that reference dog bites are listed in her.
Say that again.
The courses that reference her teaching, dog bite issue and pattern recognition, they're listed in the resume.
All right. We'll see you at 12.
So they're just taking lunch then? So they're just taking lunch then? No, they're just taking the morning break then. And then they're going to bring in Dr. Laposata. Okay, so let's pass the morning break. And it looks like are coming back on the record. So they took the morning break. Let's see where we're at. This morning's been, oh my God, it's been such a fucking Monday. We are now at the morning break. The court determined that they weren't going to do the voir dire of Dr. Laposata that we thought they were going to do of the voir dire of Dr. Laposata because the court said everyone needs a break. I concur. Everyone needs a break. But it seems that we are finally done with Dr. Wolfe. And while we got into redirect and physics and force and mass calculations, my main takeaway before my brain absolutely melted was that does the weight of the arm for the testing matter that much with regard to the damage of the taillight? The answer is no. It doesn't seem to matter that much for the calculations. And then Brennan wanted to ask a lot about the damage to the arm and lacerations, abrasions, tensile strength of fabric, and whether or not the fabric on the hoodie would have been ripped the same way or not ripped the same way, and whether it was studied that the fabric would rip a certain way, and whether the arm was heavier and or lighter, and that would change the road rash to the arm. But the last time they testified, the Commonwealth's expert, it was that the taillight fragments did that damage. to the hoodie. And then as we got into the cross, then he started asking about whether or not the arm would be damaged by taillight. But so much got lost in the sauce, it was hard to follow Brennan through that line of questioning because there were good points of questioning. And then there was a lot of trying to just win cross-examination by being confusing. So at the morning break, that's where we're at. The argument over the voir dire of Dr. Laposata continues, and the defense said, no, we need more time for that. And now they are coming back into court after the morning break. So let us continue.
Your witness, is there a reason?
This is a separate issue. I'm asking Mr. Leslie to address the court on this.
Okay. What do you want to tell me, Mr. Leslie?
Bear with me.
Also, I'm also starting to see spoilers in the chat. Emily has no chill today because it's a very Monday. So don't run the risk of getting just absolutely yeeted out of the chat. Thank you for no spoilers. We're watching in real time together, which is what we choose to do.
Moment, Your Honor, I need to put on evidence gloves.
I need to put on evidence gloves. Okay. We're going to find out what's happening together, chat. Unless it looks like...
Your Honor, the defense moves for a mistrial with prejudice based upon intentional misconduct that...
Alessi's got his mistrial voice on again, and he's now got gloves. Mistrial... Asking for a mistrial with prejudice due to intentional misconduct. Migalina just ping the app because here we are again. Just ping the app. We told the app crew we would let them know when shit pops off in court, and here we are again. He's got his mad voice.
The defense moves for a mistrial with prejudice based upon intentional misconduct that just occurred before the court and for the jury. And what I'd like to do, Your Honor, this regards the hoodie, and this regards questioning and representations and questioning by Mr. Brennan. And what I'd like to and need to do, Your Honor, is...
That's why they were grabbing the pictures of the hoodie. Because what all of you asked in the chat, you're like, Emily, stop pausing. I can't, because we're going to do this in real time. The Commonwealth picked up the hoodie and was showing the witness, don't you see the damage to the back of the hoodie? And y'all in the chat were like, but wouldn't we have pictures of those from the crime lab? Because the crime lab took pictures of everything and flagged everything. And in 2 trials, we've never seen damage to the back of the hoodie. And the defense is sitting there with a picture of the hoodie on the lectern. I can only guess that that's a picture of the back of the hoodie.
Is to have 2 documents marked as exhibits, and then I am going to use exhibit 88, which is an evidence, which is the hoodie, which is why I'm putting on the evidence gloves, and it will become quite obvious very shortly what the issues are.
All right, so what are the things that you want to have marked?
What I would like to have marked...
Also, I think it's very smart of the defense to have Alessi make these arguments. The court likes Alessi and Miss Little quite a lot. Alessi's newer to this case, and the court listens to Alessi even when he's being hyperbolic. The jury's out. The jury's on morning break.
What I would like to have marked, the first document, and I want to get the specific title. These 2 documents are from the criminalist's file, specifically Ms. Maureen Hartnett's notes regarding cuttings from the hoodie sweatshirt that's in the crime lab file folder.
Okay.
So the first is the back of the hoodie. So with Your Honor's permission, I would have that marked for identification.
Exhibit YYY. Friday.
Tell me why.
And may I see that, please? Okay.
That is the back of the hoodie, Your Honor. And if I could please have the next marked in order exhibit for identification.
Exhibit ZZZ, Friday identification.
Exhibit ZZ top, ZZZ, Z3, depending on where you live. All right. Unless is put on his.
Give me a minute to read this, Mr. Leslie.
Yes, Your Honor.
So is it that there are no holes in the back? There were no holes in the back of the sweatshirt?
That's only part of it, but that is in fact
No
the
holes
case,
in the
Your
back
Honor.
of the sweatshirt.
Okay.
That's from the scientific, and all of you said, wouldn't we have seen that? Yeah, we would have seen it. Yeah, we would have seen it. If there were holes on the back of the hoodie, we would have seen it. So the defense handed the court a photo of the back of the hoodie and the documentation of the hoodie. And the court is reading the documentation saying, is this about there being no holes in the back of the hoodie? Because Brennan stood up there and said, do you see the holes back here? Here, 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 here. Here, 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 here. Chad, I'm not jumping ahead and saying it's tampering with evidence because I don't know if those were sample cuttings and misrepresented. We are going to have to see what happens. So the court's like, is this about there being no holes on the back of the hoodie?
I can't tell entirely from ZZZ, but if that's your argument, why for identification appears to support that.
Your Honor, may I have the exhibit?
Why is the photo. Why seems to support that. Let's continue.
Mark for identification back for my argument.
Okay.
Thank you, Your Honor. Thank you, Madam Court Reporter.
Why is the photo?
Your Honor, what we just saw is Attorney Brennan question Dr. Wolfe with regard to the hoodie sweatshirt that heretofore has been in the plastic casing for trial. And this is the, what happened was Attorney Brennan held up.
He did do that. And he said, here. Alessi has now gained himself up, so I'm going to try to gain this back down so it doesn't sound
The casing
so
with the hoodie
bad.
sweatshirt went to the back of the hoodie sweatshirt. First point to note, Mr. Brennan did not show Mr. Jackson the back of the hoodie sweatshirt,
True.
didn't give Mr. Jackson an opportunity to look at it.
Can I just ask a question? I noticed that it was over here at the witness stand this morning, so I assumed everyone was aware that something was going to happen with it. Is that not the case, Mr. Jackson?
That is not the case, Your Honor. The
Okay.
first time I realized that line of question was going to be asked was when Mr. Brennan pulled the casing out.
Okay.
Here's
Go
why
ahead.
that's important. I went to pause and then it yeeted because Monday. Here's why that's important. These are in evidence rooms. These are in locked evidence. Well, I can't say they're in evidence rooms. They are somewhere locked in the courthouse. The prosecution knew they were going to ask that line of questioning because they got it out of wherever it's locked and then they put it next to the witness stand. But they did not show it to the defense. Either side, doesn't matter which side is proffering evidence or proffering to show the other side something, they have to show them before they approach. And the court said, seeing that it was up there, I thought that that was done this morning. And Jackson said, no, it was not. No, it was not.
Mr. Leslie?
Thank you, Your Honor. So, to do it in order, Mr. Brennan takes the hoodie sweatshirt in the casing without notice, shows it to Dr. Wolfe,
Here.
shows the back of the hoodie,
That's what he did.
which has certain holes, and I'm going to limit calling them holes to do this chronologically. I'm going to refer to exactly what they are in moments.
Okay, so I need to see it. I know you've got gloves on. Where is it right now?
Show it to me. Is it still next to the witness
It would
stand?
help me if you held it up for me now.
Oh, he took it out.
Mr. Alessi.
Alessi took it out of the lucite. Great. To
So-
show it to the court.
Here is the back
Okay,
of the hoodie.
all right, thank you.
It's very obvious that these are cutting holes cut by the criminalist. And I'm going to get to back to this in a moment.
He's putting it back in an evidence bag. He is saying, look, those are cuttings from the criminalist, which would be in the criminalist notes.
But I would like to do it, and certainly entertain any of your Honor's questions, but in a logical order.
Sure, so I'm not...
Y'all, if the criminalist cut the holes, it's not tampering with evidence. It's not. However, representing it to the witness and the jury as if there are holes on the back of the hoodie that are from road rash is different. That is what the argument is here. The representation and the way it was asked of the witness is the issue, not the tampering. Tampering is not an issue. I see the word flying through the chat. That is not the issue. The reason that you didn't see photos of the back of the hoodie with white flags on them like you saw of the arm is because there was not any damage to the hoodie, to the back of the hoodie, when the criminalist documented it. It's why you haven't seen it. And Brennan asked those questions on cross. Did you see any damage to the hoodie? And the criminalist has already testified, and those photos aren't in evidence at this point because the criminalist has already testified. I want to hear the rest of his argument.
What about the jurors and lunch? How long do you think this will be?
I think this will take about 10 to 15 minutes, Your Honor.
Okay.
The court being mindful of the jurors' time is not rushing the defense, in my opinion. It's needed. If she's going to give the defense more
Thank you.
time
Go ahead, Mr. Leslie.
and let the jurors have lunch, then that makes sense. That's fair. Tell the jurors they can have lunch.
Thank you, Your Honor. So I just want to get the flow back going here in the logic. So, and I'll do it quickly. So Mr. Brennan grabs the hoodie sweatshirt inside the casing.
He did that.
Doesn't show it to Attorney Jackson. Goes up. We have no idea that this was going to happen. Goes up, confronts the witness, Dr. Wolfe, shows the back of the hoodie sweatshirt. To my knowledge, the first time the back has been referenced of the hoodie sweatshirt.
Yep.
Shows Dr. Wolfe, confronts him, and basically says, couldn't these holes be caused, and I'm paraphrasing, from a fall backwards?
He goes,
Obviously
"These holes."
positing
Here.
in the juror's mind after, remember, we just saw all kinds of videos with regard to Rescue Randy and impact at 24, 29 miles an hour, more aptly 29 miles per hour, and damage to the hoodie, etc.
Lawyers have to have a good faith basis in their questions. This is where the problem is. Asking a witness, couldn't these holes be made from falling backward, when you know they're from the crime lab taking cuttings to test of the hoodie, doesn't seem like a good faith basis to me.
So what then happens is Dr. Wolfe is asked a series of questions very much with the indication that somehow, in the clear implication, that these holes are being caused by road rash, and that the holes in the back of the hoodie sweatshirt, Exhibit 88, could have been or likely were caused with regard to some type of impact. Clearly presented to the jurors with that in mind in that questioning. Here is the basis for the mistrial with prejudice.
Yeah, this is fixable with the jury instruction, though. It's fixable with the jury instruction stipulation. Ladies and gentlemen of the jury, the holes in the back of the hoodie are made by the crime lab, and if witness XYZ was to testify again, they would present this photo and say that those were made by the crime lab. Okay.
Those holes in the back of the hoodie sweatshirt are clearly, unequivocally, without doubt, caused nothing to do with any type of event on or about January 29, 2022.
If they're caused by the crime lab, just say they're caused by the crime lab.
Do you have something you said, when you said obviously cut by the criminalist, do you have something that shows that chart that I couldn't understand quickly? Is it on that? Does
Yes,
that do
Your
the
Honor.
back?
What
Okay.
we have is two documents to show that.
Right, so the second one, when was that provided?
These, when you say provided, you mean with regard to when did the defense get these in
Yes.
a discovery?
At the beginning of the case, I would imagine.
Let me get the date, Your Honor.
Sure.
Notice of discovery, May 2023.
Okay, thank you.
And I will note, Exhibit YYY. The only, I believe,
right.
I'm holding up YYY, which is the back of the hoodie, I believe is the only one, to my knowledge, not put into evidence. Not.
So all the other crime lab photos are in evidence except for that one? Well, then that's got to be put in evidence.
Not turned into evidence. This is the one that it clearly shows the hoodie before the criminalist started her work with the cuts. There are no cuts to YYY, and if we need to, we'll bring Ms. Hartnett in to confirm.
All right, so is ZZZ in evidence?
You don't even need to bring in Ms. Hartnett.
Not in evidence.
You need to tell the jury that the prosecution represented this as being from road rash. And the jury needs to be explicitly instructed that that's not true by the court, because it has more weight than bringing in Ms. Hartnett.
And that is part of the basis for the mistrial.
The jury's not going to like that at all.
It is no coincidence that these two documents...
He's saying it's planned. He's saying it's planned, that those were left out and that the prosecution was planning to do this all along. That is his argument.
Are not in evidence, because if they were in evidence, they would clearly have prevented the stunt that we just saw occur with regard to Dr. Wolfe. So that is part of the intentional misconduct, Your Honor, is these are documents from the criminalist's file. It's the Commonwealth's documents. And it is very clear when you go to Exhibit ZZZ, the cuts that the criminalist made to the back of the hoodie are specified.
So where on that? Because when I quickly looked at it, I didn't see it. What does it say? Go ahead and read it to me, please.
It's item number 7. I'll read it from the top, LIMS 22-218-4, Analyst MSH, which is the initials for Ms. Hartnett. Dates: May 11, 2022, May 12, 2023, and then May 18, 2023. And what she does is she's got the
You know what, can you bring it up to me, please?
I certainly can, Your Honor.
So this is,
And I can conduct my argument from right here if that helps, Your Honor.
Just want to see, point out to me where it says, where it shows the back.
This is the back. So you can see the back of the hoodie. That's the back of the hoodie head. And then you can see the various...
because the crime lab noted, because of course they did, the crime lab noted where the different cutties were from. And the court's like, can you show me?
Let me just get a check on this, Your Honor. I'm not...
Mr. Brennan, you should come up and look at this.
Thank you.
And I'm
So, Mr. Leslie stayed
yes.
here. All right, so
So the court is saying, can you show me what this is? And these two are not in evidence. The defense is arguing that the prosecution pulled this and left those out of evidence on purpose because the damage to the back of the hoodie is not road rash holes, it's clippings from the crime lab,
I want to
which the prosecution would know.
clarify this. Yes, are you willing, Mr. Martin? Let me just make sure I get...
Mr. Jackson, it says exterior front, what Mr. Leslie was pointing me to.
And that's a problem too. If the photo's from the exterior front, not the exterior back,
I can do it, but Mr. Wolfe, can you print the back? And then, Your Honor, are you comfortable using the computer of the back? Because I think we just had the wrong one.
We need to mark it, though.
Understood. We will.
they need the printout. For those of you just coming in and asking, why is Alessi wearing gloves? It's because
We
he
wanted to have the front and the back show
was
all
holding the hoodie.
cuttings, but what only printed out was the front. We are now printing the back. Your Honor is correct.
The defense has made a motion for a mistrial with prejudice based on the questioning of Dr. Wolfe by the prosecution. The prosecution held up the hoodie that was in between lucite and said, couldn't these marks on the back of this hoodie be from falling on your back, insinuating the defense is arguing that he was referring to road rash. And Brennan stood up there and said, because I thought of Genie from Aladdin immediately, do you see these holes? Here, 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 insinuating that there were a lot of holes on the back of John O'Keefe's hoodie. The defense is arguing, look, those holes are from the crime lab taking clippings. And the only photo of the hoodie not in evidence is the photo of the back of the hoodie that the crime lab took before they did the scientific testing and clipping. But then the defense handed the court the wrong picture of the front, so we are waiting for them to print out the one of the back, which Alessi is coming into court with now.
Minutes, because it has to go.
So go ahead
Nope,
with your argument.
2 minutes.
Thank you, Your Honor.
So the defense is saying that this was a trap that was sprung on them, not a misstatement, not a misspeak. He's arguing, the defense is arguing that this is planned and intentional misconduct in front of the jury. We haven't gotten to the Commonwealth responding because the defense is arguing for mistrial.
Your Honor, what is being printed is which we will
And I don't
mark
expect
will be
the court
front of
to
the hoodie.
make
The purpose of
any comments yet. I
Exhibit
expect the court to
ZZZ
listen.
and the one that is being printed is to show and to give the court, and we're going to request to give to the jury the complete picture and the complete true story
Well, at a minimum.
about these holes in the hoodie that were presented as if they were caused in some
at a minimum
manner by something else other than the
So
criminals.
that seems perfectly reasonable, and I'd be inclined to do that.
I appreciate that, Your Honor. And here is the reason for the motion.
He's asking for a mistrial with prejudice based on the prosecutorial conduct. I said it's likely that this will be cured by the judge giving an instruction to the jury and saying, which I think actually might, well, we'll talk about that when we get to the end of arguments, but saying to the jury, if this witness was to be recalled to testify, they would testify that the holes to the back of the hoodie of John O'Keefe are scientific cuttings taken by the crime lab. And this is a photo of the back of the hoodie in the condition it was received by the crime lab in. But we'll see. That is the minimum. And I don't think they should recall the witness. I think the court should tell the jury, this is what it is. All right, let's continue.
Motion for a mistrial with prejudice. On its own to do this, and you put together all of the parts of what just occurred. You start with the fact that and if I could, Your Honor, now.
Also, a motion for mistrial with prejudice means that if the mistrial is granted, the prejudice means that it cannot be refiled. A mistrial means that it can be tried again. That's the difference between the two.
That I have it get marked so I can then refer to it.
All right.
Thank you.
Can we print extra copies too, so I can have my own copy?
Absolutely.
And for the Commonwealth to see.
And I'm going to show the Commonwealth.
The Commonwealth has it. It's their evidence. The Commonwealth has it.
Thank you, Madam Court reporter.
They are marking the other exhibit. And the defense is waiting for their printout. As are we.
Sure. And here's another document, chain of custody document.
There's a chain of custody document. Oh, right, because it's from the crime lab. Lally's just sitting there. Like, don't look at me. Don't look at me. All right, where they are waiting for that.
Mr. Brenner's reviewing that. When I had to, Madam Court Reporter, the chain of custody document for these, and that's that he marked is the next exhibit in order.
Okay.
And then with Your Honor's permission.
All right, those have been handed to the court, the printouts.
Hand them both up to Your Honor so
Sure.
Your Honor can see what I'm referencing.
Thank you.
Exhibit BBB, B for ID.
Thank you.
We're now at B, 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 B. We're now into fours. The court's not going to say anything about this till we're at the end of argument.
I do not need either of them, Your Honor, and I have the extra copies.
So we are still in the middle of argument on this.
Your Honor, I now have enough copies for Your Honor and for the Commonwealth.
Oh, thank you.
So if I could have one set, that would be great. Yeah, Your Honor. Thank you.
I still do not have ZZZ.
All right, we'll give the court a copy of ZZZZ.
All right.
All right.
Thank you. Okay, go ahead, Mr. Leslie.
So, Your Honor, to do this quickly chronologically, so we have a hoodie sweatshirt that was brought into the criminalist Ms. Hartnett.
Yep.
With the back of the hoodie with no holes.
Right, intact.
On it. The criminalist makes cuts to the back of the hoodie, makes cuts to the front of the hoodie. The exhibit, Your Honor, depicts those. There's a chain of custody document that describes the chain of custody for the hoodie and the cuts in the chronology. And of course, we have Exhibit 88, which is the hoodie. So, what Mr. Brennan did, and I'm now pulling Exhibit 88, he holds up the back of the hoodie.
And shows the witness.
Which has cuts in the back from the criminalist. somebody from the Commonwealth,
And says,
a
couldn't
witness
these be from
in
road
this
rash?
case, Ms. Hartnett, she's testified, and Mr. Brennan has indicated he wants her to come back and testify, which we welcome. And now what we have is we have holes.
No, the judge should
in the
tell them. Even if she comes back to testify, the judge should still should still tell the jury directly in time.
back of the sweatshirt that were dramatically held up to and confronted with Dr. Wolfe, and then the jury sees it. With the clear, unmistakable, purposeful intention of having the jury conclude that these holes could have come from events on January 29th of 2022, when in
He asked
fact
if they could.
the Commonwealth well knows
That
from
their
its own
witness did it.
documents, from its own criminal list, that those holes in the back were caused by their criminalist as part of their examination and sampling of the hoodie. What could be more egregious? What could be more misleading than that? And what could be more important for a context than the alleged collision that never occurred? That's the topic before some of the most significant and probative witnesses in this trial that the Commonwealth has been attacking from the jump of pretrial. They picked the most opportune, sensitive time to pull this stuff. This is intentional.
That's his
is
point.
Irremediable.
I don't necessarily agree
This
that it's irremediable.
is on the key issue of this case, whether there was any collision at all. On its own, Your Honor, on its own, this is a mistrial with prejudice. But I add to that what just happened, and I'm not going to repeat or go into other than to reference. This comes on just mere days after the Commonwealth raised the specter of absence of DNA on the same hoodie sweatshirt without having the criminalist, the Ms. Kuhn from UC Davis come in. I know Your Honor already ruled on that.
Right,
and
so let's move along from
Right,
that.
He's trying to say it's cumulative, and the court's like, I don't, the court doesn't agree with that.
Why is this occurring, Your Honor? Why is this happening? The Commonwealth has no case. They have no collision. They are desperate and are trying to create evidence of specters of collision where the evidence doesn't support it. So what have we come to? We've come to the manufacture of evidence. We've come to, incredibly,
I don't think it's the manufacture of evidence.
a hoodie, a key piece of evidence in this case, and holding up to Dr. Wolfe, the ARCCA expert, to try to make it seem like Dr. Wolfe didn't do his job. You didn't account for these holes. How could you be a credible accident reconstructionist
It's misleading.
when you talk about some holes, but you don't talk about these holes?
Absolutely.
Knowing all along the
Yeah, it's misleading
holes
for sure.
that Attorney Brennan is trying to impeach Dr. Wolfe on were
and there's
caused
no
by
good
the
faith basis
Commonwealth's
for it.
own criminalists as part of sampling. I don't believe one could come up with more misleading, misdirecting, elucidation of testimony than this on the key issue in the case. We have irrefutable, objective evidence, and I will state that it's more than interesting that none of these exhibits that Your Honor now has marked for identification
Very interesting.
were put in evidence by the Commonwealth.
Very
Isn't
interesting
it some
that the back of the hoodie is not in evidence.
that these
very
are the one,
interesting.
and the only one of the, with regard to the hoodie, the back of it's not in, all of the rest of them are, but these aren't. Your Honor, I think there is one and only one conclusion in that this is intentional, that it is a matter of such significance and of such misconduct and intentional that it merits the sanction of a mistrial with prejudice. The amount of effort, the amount of work, I can't even begin to think to remedy this in front of the jury, to go backwards on this. That should not
you just tell
befall
them.
the defense. That should befall the prosecution.
It should be for the
Ms.
court.
Reed, again, is entitled, like every other defendant in this wonderful Commonwealth, to a fair trial. The prosecution is supposed to be held to a higher standard.
Yep.
To do justice, to create a fair trial.
Yep.
This is the antithesis of a fair trial. Ms. Reed's rights under the Constitution and the Declaration of Rights have once again been trampled on, and it is becoming evidently clear the more desperate the prosecution gets because it can't prove its theory, including its own medical examiner can't support them, that they're now resorting to conduct like this. Your Honor, at some point, this has to come to an end. At some point, Ms. Reed's rights have to be protected. At some point, confidence in the judicial system, the public's confidence in the judicial system.
That's not going to win any
that
points with the
prosecutors
court
will conduct themselves with their duty to present a fair trial. That has to be enforced at some point for Ms. Reed to receive the fair trial that she and every other defendant in this Commonwealth is entitled to.
All right, thank you. Mr. Brennan.
And Mr. Brennan, what in the world do you have to say? Because seriously, WTF. Like,
Your Honor, my
WTF.
brief review of the lab. My brief review of the lab.
My brief review of the lab. You're not the defense, Brennan. You can't just throw shit out and be like, couldn't it be this? Couldn't it be that? Couldn't it be lunch meat? Couldn't it be peaches? No, you're the prosecution. Do not take on the work of the special prosecutor if you want to ask questions like a defense attorney. There are different standards, which everyone else sitting at the prosecution table knows.
Your Honor, my brief review of the lab. My brief review of the lab paperwork and looking at the hoodie, it appears that I made a mistake.
Yeah, you did. It appears that I've made a mistake. You think? But the argument is going to whether or not it was intentional.
My brief review of the lab paperwork.
He does seem rattled, though.
And looking at the hoodie, it appears that I made a mistake. And so I think what should happen is there should be a curative instruction. There should be a stipulation. The court should instruct the jury that during Mr. Brennan's cross-examination, he asked Dr. Wolfe about holes on the sweatshirt or holes on the back of
there
Mr.
should be an
O'Keefe's
instruction.
sweatshirt. The parties agree the holes were made by a crime lab technician. This was done inadvertently.
They definitely weren't made by crap. This was done inadvertently? No way. No way do you get a stipulation that says this was done inadvertently. No way. No way. He does look rattled, but no way No way do you get this was done inadvertently.
Shirt or holes on the back of Mr. O'Keefe's sweatshirt. The parties agree the holes were made by a crime lab technician. This was done inadvertently but should not have been asked. The court should strike the questions and the answers. And you should instruct the jury they are to completely disregard any questions or answers about the holes in the back of the sweatshirt. And the court should allow the defense to introduce the lab paperwork.
All right. So I'm not going to allow the mistrial motion, Mr. Alessi.
It's
what I'm
curable.
going to do
Alessi
is-
doesn't agree. I don't disagree that it's curable. I don't think you tell the jury it's inadvertent, though. I think the court should instruct the jury when they come back in that they heard a line of questioning about holes to the back of the hoodie, and those were created by the crime lab. And that it was presented to them as if, well, no, she's not going to say that. But that it was created by the crime lab. And if the crime lab testified, they would say that they made those cuttings, and then these are the pictures they took before the cuttings were made. I don't think the court should say it was inadvertent at all. I think it should be stronger than that. I think it should be much stronger than that.
Instruct the jurors. I'm going to put in,
The jurors need to be instructed.
going to allow the mistrial motion, Mr. Alessi. What I'm going to do is instruct the jurors. I'm going to put in what's been marked for identification, Y, Z, A, and B. 4 of each letters. I'm going to put all these into evidence.
Well, 3 of Y
They
and
can be
Z and
displayed
4
for
of
the
A and
jury.
B.
And I'm going to instruct the jury that during the cross-examination of Dr. Wolfe, Mr. Brennan asked him about holes in the back of the sweatshirt and whether or not they perhaps could have come from events or implying or something like this.
Implying. Go with
I
implying.
instruct you, you are not permitted to draw any inference that these could have come from the events of January 29th,
Because
2022.
Because they were made by the
I
crime lab.
instruct you further that those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt on, I just put the dates aside. Chrissy, can I see those, please?
Yeah. Alessi argued it's irremediable.
It's unclear for me.
I disagree.
Do you have a better idea, Ms.?
I think the strong admonition to the jury and that the jury can't consider that is very bad for the Commonwealth, because it's telling the jury the Commonwealth just asked these questions of the witness and those holes came from the crime lab. I think inadvertent doesn't go in there at all. I don't think after everything that this can't be cured with the instruction. And I think the instruction should happen the moment they come back in and show them the hoodie and show them all of those photos.
Mr. Alessi, what day these were done? Is it all of those 3 days?
Yeah,
Now
the
I see
jury
a
will
fourth
be
day.
the jury will be
5/11,
furious.
no, I'm sorry, 5/11, 5/12, 5/11/2022, 5/12/2023, and 6/18/2023. Those are the 3 dates?
Your Honor, on or about May 18th, when the defense filed a motion to test. So those are, that's the probative date.
So May 18th?
Yes, that's,
Okay,
and that's 2023.
yep. All right. That's what I'm going to do. Is there anything further you want me to include in the instruction? Your rights are saved regarding the mistrial. I disagree with you on that.
Your Honor, I'm not going to go any more into the argument, but
When she says your rights are saved regarding the mistrial, it means the record's been made. The record's been made regarding the mistrial. The record's been made on it. It can be, if it needs to be brought up down the line, it can. I think giving the instruction, and I think the defense should have some time, if they need it, to review what they want the court to say.
I appreciate the opportunity
So I'll hear you. Go ahead.
So the first, Your Honor, is with
The court's allowing the defense to be heard further with regard to, I think with regard to the language that the jury is going to get to consider. But you definitely saw Brennan look rattled, for sure. All right, let's see. A lot of you are saying this is going to be a huge appellate issue. Only if there's a conviction, and we can have that conversation when we get to the end of the court, or the end of the case. But is this one question on cross-examination going to be the thing where the jury goes, oh, there's holes in the back of the hoodie? Especially if the next thing they hear is those holes are from the crime lab, and the prosecution was asking about whether those came from January 29th, and they did not. That's a pretty strong instruction. We'll see what the language of it is. So let's continue.
Two things. One, I would like the opportunity to have the hoodie sweatshirt held up.
That's fair.
Because that's what
Okay.
happened.
Yes. Yes.
These holes
Yes. Yes.
The court's like, yes, I agree with you. Yes, yes, yes. Your Honor, you sound like my 13-year-old. No, I agree with you. Move on. Just like, yes, fine. Ask for a stronger instruction because she's going to say yes.
Thank you. So that's number one as part of the stipulation. And then
I'm not wording it as a stipulation, and I'm not saying it was inadvertent. I am giving an instruction that they can.
I'm not wording it as a stipulation. I'm not saying it's inadvertent. I'm telling the jury that this is wrong. I'm telling the jury that this is wrong. Ask for stronger language, Alessi. Now's the time. Ask for stronger language.
They cannot consider it for this purpose, and I am allowing these to be placed into evidence. So it's not a stipulation. It's
a court instruction
from me, which I
Yep.
think is more
Carries more
forceful.
weight. Yes.
I misspoke, Your Honor.
Agreed.
I agree, not a stipulation, but just as Your Honor said, with regard to the matter Your Honor said they're not to take an inference, I would respectfully request that this be handled just like Your Honor did with regard to the rock at 34 Fairview. Your Honor said that rock wasn't present, on or about the time of event.
So I do say that when I say Ms. Harnett did this. So rewording it just a little bit.
Yes, exactly.
Mr. Brennan asked Dr. Wolfe about holes in the back of the sweatshirt. I instruct you that you are not permitted to draw any inference that those holes were a result of the events on January 29th, So, all right, this is what I'm going to say. So if you're not going to listen to it, that's fine. I've already said it. All right, we can bring the jury in. It's what I said, Mr. Alessi. Okay.
What is going on at defense table that pissed off the court? They must be talking to each other. That is purely my speculation because the court was working with Alessi to reword this. If the defense is talking while she's reworking this on the bench, oh my God. I'm backing up to see exactly what she says.
Of the events on January 29th, So, all right, this is what I'm going to say. So if you're not going to listen to it, that's fine. I've already said it. All right, we can bring the jury in. It's what I said, Mr. Alessi. Okay.
Jackson said, Your Honor, I'm consulting with Mr. Alessi. I'm not showing disrespect to the court. But if he's talking to Alessi while the court is on the record, that is showing disrespect to the court. And if you need time, Alessi needs to say, Your Honor, can we have a moment to discuss the language?
All right. So it's what I said, Mr. Alessi. I instruct you that you're not permitted to draw an inference that the holes came from the events of January.
However, she's continued reworking it and telling them what she's doing instead of walking off the bench, which some judges would have done. So there is that.
January 29, 2025. Those holes were made by the criminalist Ms. Harnett during the course of her inspection and sampling of the sweatshirt on May 18, 2023.
Is it possible, Your Honor, last comment, to instead of not drawing inference, but you should conclude that these holes
Yes.
were not present in
Yes.
the sweatshirt?
Yes.
They were caused by the criminalist.
I said Alessi should ask for stronger language, and there it is. If the defense needs time to confer, you need to tell the court you need time to confer. You cannot confer while the court is talking on the record. And yes, Alessi is asking for stronger language. Good.
So I can just leave that all out then and just say, Mr. Brennan asked Dr. Wolfe about the holes in the sweatshirt. I instruct you that those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt on May 18th. It's probably neater that way anyway.
Yeah.
All right, let's bring them in, please.
That's stronger language.
Judge, just as a housekeeping matter, the sweatshirt's been taken out of the plastic sheet, and it might need to be remarked. The plastic sheeting was marked, but if we're going to put it into a bag or something like that, it might need to have it marked.
The bag
But
needs to be
do that
marked
right this second.
as an A. That's fair. The bag would need to be marked as an A or a B or a
May I
0.1.
approach Mr. McDermott with exhibit
Yes.
All right.
Thank you.
It sounds like they're going to bring the jury back in. Oh, boy. And the court is rewriting the instruction they're going to read to the jury.
All right, thank you. I'm sorry. Mr. Alessi, you're simply going to stand and hold the sweatshirt, right?
Yes, Your Honor.
Okay.
I think that's fair. That the defense gets to hold the sweatshirt and show the jury the defense took the hoodie out.
This is exhibit 223.
Oh,
Your Honor, I would hold it.
boy.
Honor begins to read. Is that consistent with Your Honor's expectation?
No, I want you to hold it up with the back.
What would you like me to start?
You do that first, and then I'll give the instruction.
Thank you, Your Honor.
Well, the jury is coming in after a long morning break, wherein Alessi made another motion for a mistrial. So for those of you just joining us and are like, WTF is happening, how did I miss it? Probably because you don't have the Lawnard app, because the second this shit started going down, we immediately sent out an app notification. So we do the best that we can to let you know when shit pops off in court. The law nerds clocked this probably at the same time the defense did, because when Brennan was questioning Dr. Wolfe, at the end of Dr. Wolfe's testimony, he was holding up the hoodie and said, these holes back here, here, couldn't they be caused by falling backward? And he asked a few questions about it. Then the jury went out on the morning break. Then everyone needed a break, so there was no voir dire of Dr. Laposata, which was supposed to happen at the morning break. Then they came back. Alessi put on the black gloves and said, we are moving for a mistrial with prejudice, and here's why. The Commonwealth, and I'm summarizing now, the Commonwealth held that hoodie up without showing it to the defense, held that hoodie up, showed the back of it to Dr. Wolfe, and asked Dr. Wolfe if he had considered those holes. If he had considered that those were from falling backwards, and pointed them out and made it seem like there were a lot of them. And the chat went, well, in 2 trials, how have we never heard about any damage to the back of John O'Keefe's hoodie? We've seen no pictures. We saw nothing from the crime lab. We saw nothing with flags on it, the way you saw on the arm. No defects marked on the hoodie. And then the defense pulled up a picture, which you could see on defense table before they did their final redirect. And you could see the picture of the hoodie on their laptop at counsel table, that there were no markings, no flags or numbers or anything indicating defects in the back of the hoodie. And they argued that those were created by the crime lab, taking cuttings to sample. And when Hank Brennan got up to make his brief statement, he didn't say the defense can pound the table all they want. He got up and said, well, he started at first because he actually did seem kind of shook, that he made a mistake. He said, in my brief review of the crime lab paperwork, it appears that I have made a mistake. And I think the court should give an instruction and a stipulation. The court's not giving a stipulation. The court's just going to give an instruction. A stipulation means, ladies and gentlemen of the jury, the parties have agreed. This is not the parties have agreed. The judge said she is going to instruct the jury and tell them that did not exist. That did not happen. And so the jury heard the Commonwealth's question and is now hearing the judge tell them that is not accurate. The court did not grant a mistrial. I think it's curable with the instructions too. I think that telling the jury is damaging to the Commonwealth. Whether or not the defense will later make a motion for sanctions, we will just have to see. But the court is going to instruct the jury, this was not damaged then. And that is a pretty strong admonition to a jury on the tails of Brennan's questioning, because it indicates to the jury that what has been shown to you is not true. And a lot of you have asked me, Emily, do you think Brennan did it on purpose? Do you think Brennan did it on purpose? I don't know. I don't know Brennan as an attorney other than what we've seen in this case. Can I imagine a scenario when he came into this case and didn't read everything and looked at the back of the hoodie and went, yeah, I can, there's holes there. Why aren't we asking about the holes? Well, you should go through the paperwork to see if there's an alternate explanation. Brennan defaults into defense attorney mode all the time. He defaults into defense attorney mode all of the time, where you can raise inferences, you can ask questions, and you can poke holes. You cannot do that as a prosecutor. So I don't know. I'm going to wait to see what happens. I'm going to wait to see how the defense argues it. But the jury's going to hear that that's not true. And the jury does not hold things like that lightly when it comes to the Commonwealth playing hide the ball with the evidence. The jury is not going to like it. Do I think it's a mistriable issue? I think it's curable with the instruction. That's within the court's discretion. And that's what the court is doing. Do I think the jury will hold it against the prosecution? I do. Especially if there's some jurors that are already turned off by the prosecution. They're going to be like, not at all. Not at all. So we will see what happens when the jury comes back in. But the defense is going to hold up the hoodie and show them outside of the plexiglass. Well, the court says the crime lab made those. And the defense will argue the prosecution wants you to see this and this and this and this and this, but have they proven it to you? But the defense is going to continue to make these motions, I suspect, over the next few days. We'll see. I'm very curious to see where we end up with the witnesses today. But we will see what happens. Could the defense make a motion for sanctions later? They absolutely can. Are they going to do it now? No, they're not going to do it now in the middle of everything. And we will have to see. But can I attribute what's going on with the prosecution to malice? Not at this point. We're going to have to wait and see more. For me, I'm not telling you you have to. But I can't say someone did stuff intentionally when I don't know that. But did Brennan look shaken when he was standing up there and saying, I made a mistake? Yeah. So I'm not going to attribute to malice what could also be attributed to laziness. So we'll see. But Brennan has misstated numerous things on the record. There have been things that have been incredibly sloppy in what Brennan has done. I think that the instruction to the jury will absolutely have an impact on how they see Brennan and whether or not they can trust him. Because trust is a huge part of doing the work as a prosecutor. And I don't know if this jury will feel that they can trust how Brennan sees things. And that is going to have impact. Will it have impact on every juror? Maybe not. But it's going to impact jurors. And it's going to throw Brennan way off for at least the rest of today, if not more. I saw a couple of you saying, Emily, Brennan has a whole team. Does he? Because you know who I didn't see saying anything to Brennan? Anyone else at that prosecution table. The other prosecutors were just sitting there. Lally was just like, you're on your own. We'll see. But yeah, am I going to keep an eye on it? Yeah, because there have been numerous times where Brennan has come back in and said, no, I said it was this, it was this. Numerous times. So yeah, I think they need to double check Brennan's work. But no one was saying anything to him. No one was reviewing things with him. No one was doing anything to help him out. Lally was just sitting there by himself, letting Brennan do whatever. All right, let's see what happens when the jury comes in, shall we? Because, whoo, buddy. I saw a great question. Let me see if I can grab it before the chat jumps about, does this matter this close in time? Yes, because it's closer in time to the jury deliberating. And I saw a number of you ask, why would you make a motion for sanctions later? Because they're in the middle of trial. They've got expert witnesses that have flown in and they got to keep it moving. And it's not uncommon that motion for sanctions get done later, where the defense can make a motion down the road. You have to fix it in front of the jury first. A motion for other kinds of penalization can happen down the road. That's why. It's not the most pressing thing. Fixing it in front of the jury is the most pressing thing. 100%. So we'll see.
All right,
will
so
see what
Mr.
happens.
Leslie, why don't you where are you going to stand?
Pardon me?
Where are you going to stand?
I would suggest, Your Honor.
Stand in the well.
Right about here.
All right. So you can stand there, you can hold it up, then I'm going to ask you to put it down, and then I'll give the instruction.
And then I will return it to Mr. McDermott, or the court officer.
Yes,
Thank you.
court officer.
Bear with me a moment, Your Honor. I'm going to put on the...
So
All right,
we'll see.
then we will
Jury's
take the
coming back
lunch
in?
and recess. When
Oh,
we come
Jesus.
back, we'll
Then
have
we're going
the
to lunch.
voir dire. Or actually, is Dr. Laposata here?
She's here, but she's on next. We're going to call
John Tedeman.
For just the measurements?
This jury is going to be like, what the fuck are we doing?
Your Honor, you're not going to be able to show the exhibits from Ms. Hartnett or the cuts along with the next after to show the cuts were made by Ms. Hartnett.
Well, I say it, and I'm going to tell her what they are, so.
All right, the jury's coming back in, which is why we're seeing the only fan. The juror's jury room seems to be on a different floor than the court, so that's why it takes them a minute to come back up. All right. All right, I'm going to...
Patience, Mr. Leslie, why don't you hold the exhibit up for the jurors, please?
Mr. Alessi is holding up the hoodie for the jury with his evidence
All right,
gloves
jurors,
on.
that's the back of the sweatshirt that was shown to Dr. Wolfe.
And the jury's got to be like, what the fuck is happening?
Okay. Thank you. Why don't you go ahead and put it back in the bag? So, jurors, I instruct you that those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt back on May 18th, 2023. Okay. So I know your lunches are here, but I think Mr. Yannetti, your next witness, please.
Admit the other items of evidence. Admit the other items of evidence. And I am admitting the other items of evidence. But no, we're not admitting those now. Okay. So that's the instruction.
Okay, you're gonna step up, face the clerk, and raise your right hand.
You solemnly swear the evidence you give to the court and jury in the case now and here to the truth, the whole truth, and nothing but the truth, so help you God. I do. Thank you.
All right, good afternoon.
Good afternoon.
And we're on to the
Go
next.
ahead, Mr. Yannetti, whenever you're ready.
Thank you.
We're on to
Good
the next
afternoon, sir. In
witness.
a good loud voice, would you please?
And yes, do the attorneys have to just shift immediately? Yes, they do. The attorneys just have to shift immediately. Yep.
State your name and spell your last name.
Sure. My name is John Tedeman. It's Tedeman.
Do you work, sir?
I do.
What do you do for work?
On to the
I
next
am a
witness.
private investigator.
Do you work for someone else or do you have your own firm?
I have my own firm.
What is the name?
Forum Investigations.
And that's Forum?
Correct.
I'd like to ask you a little bit about your education and work history. You're from this area?
Yes, Boston
Where-
proper.
I'm sorry?
Yes, from Boston.
Where did you attend high school?
The Roxbury Latin School.
When did you graduate?
Leave?
1996.
Where did you go
Oh.
to college?
I went to Princeton.
Hey, yo, class of 96. Shout out. We've been out of high school 15 years. Doesn't feel like a day over 10. I'm teasing. All right. Well, this is witness number 9. This is the defense investigator who's coming in for the measurements. So that is where we're at. And if the lighting keeps changing, yes, the weather is dynamic
University.
today.
What year did you graduate?
He went to Princeton. We're doing full background training and experience.
Yes, Boston
Where-
proper.
I'm sorry?
Yes, from Boston.
Where did you attend high school?
The Roxbury Latin School.
When did you graduate?
1996.
I don't know if we need all of
Where
this
did you go to
background, but
college?
sure.
I went to Princeton University.
What year did you graduate?
2000.
What did you do after graduation from Princeton University?
I became a federal agent.
Where?
The agency or the location?
Oh, I meant the location. Sorry.
I started out in Los Angeles and then I was back in Boston.
And what years were you a federal agent in Boston and Los Angeles?
2002 through 2008.
And what agency did you work for?
That's
I worked for the Inspector General for the Social Security Administration, Office of Investigations.
And what type of work did you do in terms of investigations?
We did fraud investigations, identity theft, credit card fraud, fugitive operations,
Lots of fraud
all sorts of things,
investigation.
anything involving a Social Security number, basically.
And
Identity
why
theft.
did you leave in 2008?
I went to law school,
Where?
Suffolk,
I'm sorry.
What year did you graduate from Suffolk Law School?
2013.
And what did you do after graduation from Suffolk Law School?
I've had a small solo law practice and worked as a real estate broker.
And what type of law did you practice?
Mostly real estate law.
When did you start Forum Investigations?
In April of 2024.
Are you still practicing as a lawyer?
Not very much, no. I still have my license, but my bar card, but I don't practice much.
All right. How did you become involved in
He's
this
like, this
case?
is more fun.
I was contacted by somebody from your office last Tuesday, I believe, the 3rd.
What?
And was it explained to you why you were brought in at this late juncture?
Yes,
Last
it was explained
Tuesday?
that there was another investigator who had a health issue and would not be able to testify. So would I be able to help out with a small assignment?
And what were you asked to do?
So brought in to redo the work so he could testify to it. Okay. So that's not surprising. But another investigator couldn't testify due to a health issue, and now we're redoing the work. All right, that's
I was asked to travel to 34 Fairview Road in Canton and take some measurements and photographs.
Did
Fair
you
enough.
agree to do that?
Yes.
When did you go?
On June 3rd, I believe I arrived about 5:30 at 34 Fairview.
Okay, and when you say June 3rd, we are talking about last week,
Yes,
correct?
last week, yes.
Whom did you see when you got there?
One of the homeowners, an older gentleman, greeted me when I pulled in the driveway.
And it was not the Albert family, correct?
It was not.
Did that individual give you permission to enter onto the property?
He did.
What did you bring with you?
I brought
microphone,
an
paper.
iPhone as a camera, and I brought a wheeled measuring device.
And can you describe what a wheeled measuring device is?
Yeah, it's like a handle with two wheels at the bottom, and in the middle there's like a little odometer that measures feet and inches.
And if we could, Mr. Wolfe, could we display the photo of the front of 34 Fairview that's already in evidence with the court's permission?
Yes.
All right, they're going to show the photo from 34 Fairview.
Mr. Wolfe? 46. Do you see Exhibit 46 on the screen, sir?
I do.
Do you recognize that?
I do.
What do you recognize that to be?
That is 34 Fairview Road in Canton.
When you got to 34 Fairview Road in Canton on June 3rd, did you make note of the various entrances to the residence on the front, from the front of the house?
I did.
Could you describe those for the jury?
Yes, on the left side center of the building, there's what I would call the front door, up those 4 steps, I guess. Then
there's like the side
if you were
front
to
door and then the garage
look
door.
Farther to the right, there at the end of the main building, there's another door, which I guess is the second front door or side door.
And with regard to that door, is it fair to say that faces outward, faces toward the road?
It does. It faces directly towards the road.
Okay, continue, please.
And then past that to the right, there are the windows, and then if you can see the little red line, that is a side door that goes into the garage.
From the windows,
yes, right there.
It's been highlighted there?
Yes.
Okay. And then there are obviously the 2 garage doors.
Then the 2 garage car doors.
K Foz said, EDB, you said sorry after he said he went to Suffolk Law School. Why, you don't approve of Suffolk? No, I have no problem with Suffolk. He went to law school. The sorry was for the going to law school bit. Had nothing to do with which law school. Same response to any law school. He's like, I decided to go to law school. Why? Oh, that's expensive. That's a lot. Don't do that. Don't do that.
4 cars to enter. Okay.
Yes.
Law school's
we can
painful.
take that down, Mr. Wolfe, and put the lights on. May I approach the witness,
I'm
Your
sure
Honor?
Suffolk Law School is lovely. Law school itself, writ large, is a lot. Law school is not a.
So I've
law school is
placed a
painful
photograph
experience.
in front of you. Can you identify that for the jury?
Yes, that appears to be a photograph that I took of the side front door, the secondary front door, the garage door, and
front door one,
the 2
front door 2
car doors to the garage.
Okay. Particularly with regard to the side pedestrian entrance into the garage, the red door that you identified in the previous exhibit. Does that photograph fairly and accurately represent the layout of the house in terms of the outside and the entrances that you've previously testified to?
Yes, it does.
I would offer that, Your Honor.
All right, can I see those, please, sir?
Okay. They are going to approach. Sure. As we are getting into admitting these photos, I don't know why, but these were coming in for the photos and the measurements. Okay.
Okay, Mr. Wolfe, whenever you're ready, if you can display that portion.
She did say earlier, a number of you in the chat said, she said earlier that the measurements would come in and the photos wouldn't. I had completely forgot. A lot has happened today. I imagine Yannetti has completely forgotten. Also, the photos are much more clear. If they're photos of 34 Fairview, they're photos of 34 Fairview. The lawn didn't get smaller.
Do you see what has been?
So I'm going to ask you to take that down. Folks, we're going to take the luncheon break at this point.
Well, I want to see it.
See what has been?
So I'm going to ask you to
No,
take.
I'm pausing it. Trying to be able to get measurements to the different doors is what they are trying to get into. But the court did say earlier the measurements could come in, but the photos could not. Completely fair. I imagine they could use one of the photos already in evidence to illustrate the same point. So we'll see if that's what happens after lunch. And the court's like, no, take it down.
Take that down. Folks, we're going to take the luncheon break at this point. Okay?
And now it's time for lunch.
For the jury, this way, please.
They should have just gotten into the measurements, but no. Those were marked for identification. And then the witness was told to follow the jurors out. Okay. Yeah, I'm sure the jury is exhausted at this point of coming in for 3 minutes of testimony and then being excused. Are they leaving for lunch or are they putting more on the record? Let's see.
You may be seated.
All right. So we'll fix that during the luncheon break, Ms. Giannetti, to what I said. All right. So can we get Dr. Laposata in here? We'll do a very brief voir dire of her.
Okay. And now we're doing the voir dire. Okay. All right, the jury is at lunch. We are going to do a quick voir dire of Dr. Laposata per what happened earlier today. So here we are outside the presence of the jury again for a voir dire because the jury is now at lunch.
I do.
All right. Good afternoon, Doctor.
Good afternoon, Your Honor.
We're going to do a brief voir dire, okay?
No problem.
Thank you. All right, Mr. Jackson, foundation on just those 2 points, please. Sure.
All right, I'm going to gain this up a little because now I can't hear anyone. And then everyone's going to take lunch. Today has been the most Monday of a Monday ever. This is one of the defense experts. Oh, the court
Your Honor, for
just
purposes of
gained up the mics.
expediting, does the court wish for me to go through the foundation of the doctor's education, training, and background and experience, which is going to take a minute?
Yeah, no, just focus on the foundation for the dog bites and focus on the foundation for what's been termed to be perhaps biomechanical engineering.
Vehicle collisions,
evidence,
pedestrian
those 2 areas,
versus motor vehicle.
and if there is support or methodology in Dr. Laposata's resume to point to exactly where that is. Okay? And I expect this whole voir dire should take no more than 15 minutes.
I'll do my best, Your Honor. Doctor, could you please state your name for the record? Spell your last name into the record, please.
Oh.
Yes, Dr. Elizabeth Laposata. That's spelled L-A-P-O-S-A-T-A.
Dr. Laposata, what do you do for a living?
I'm a medical doctor subspecializing in forensic pathology.
Dr. Laposata, I'm going to move very, very quickly past the bulk of your training and experience over decades. I'm going to ask you a couple of quick questions. Where did you get your medical degree?
University of Maryland School of Medicine.
And do you have any subordinate degrees to your medical degree?
Yes, I have board certifications in anatomic and forensic pathology.
How long have you had those board certifications?
Like 35, 40 years.
Have you ever worked as a medical examiner in any capacity?
Yes, I have.
Have you ever worked as a chief medical examiner for any agency or governmental agency or state?
Yes, I have.
Describe that for the court, please.
I was a chief medical examiner for the state of Rhode Island for 12 years.
How many autopsies would you say in general that you have conducted yourself?
Over 3,000.
How many autopsies in your experience as a supervisor in one capacity or another would you say you've supervised over your tenure?
Over 7,000.
Of those 7,000 that you have supervised, have any of those dealt with motor vehicle incidents?
Yeah, I'm sure a ton of them.
Have any of those dealt with motor vehicle and pedestrian incidents?
Many.
Give me an idea, if you have a number in mind, how many motor vehicle pedestrian autopsies you have been involved with, either directly or from a supervisory standpoint.
Hundreds, over 500 at least.
Right, because she's a coroner.
Do you have a significant background and training in the cause and manner of death?
Yes, I do.
Is that the main goal or the main job or duty performed by a medical examiner?
Yes, it is.
Is it also significant in terms of supervising other subordinate medical examiners who may work under your charge?
Yes, you have to make sure they're doing it right.
Yep.
Is there a methodology that you have employed and that is standard in the industry to employ, including differential diagnoses and inferential thinking in terms of coming to conclusions related to manner and cause of death?
Yes.
Can you explain that for the court in brief, please? I know you probably have a very lengthy explanation. Okay. Do it as briefly as you can, with being as succinct as you can.
Certainly. To determine cause of manner and death, we look at scene investigation, autopsy findings, police and witness statements, and medical history. And using that information, we come up with a differential diagnosis or a list of things that might have happened to that person to cause them to die. And from that list, then we see where all the science and all the data, which one it supports. So we've looked at several different things. I always told my staff, I said, how can we be wrong? What else could this be? So you have to make what in medicine is called a differential diagnosis and then see what the facts support.
Did you employ a differential diagnosis in this case?
Yes, I did.
Do you have to be at the scene in order to understand or analyze information that you get in a police report or photographs or things of that nature?
No, then we use the police investigation and scene investigation, crime lab reports, photographs taken by the crime lab, by the police at the scene.
Have you qualified as a expert forensic and anatomical pathologist
quite a lot.
in other courts in Massachusetts and other states?
Yes, I have.
Approximately how many times would you say you've qualified?
Hundreds.
Yeah, I would
I
imagine.
want to talk for a specific
Jackson is
about a
at warp
specific
speed.
area of interest for the court.
They are in the lunch break. Jackson is, I do not have him sped up. Jackson is at warp speed to try to do the voir dire of Dr. Laposata because he wants her to be able to give an opinion about John O'Keefe, cause of death, manner of death, injuries to the arm, injuries consistent or inconsistent with a motor vehicle accident. So that's why the questions.
Were you provided information and photographs of John O'Keefe's arm and his arm injuries included with the rest of the autopsy information that you received?
Yes.
Were you asked to make a determination about the nature of the wounds specific to his right arm? I know that there's other injuries to Mr. O'Keefe, but I'd like to relegate your attention to the right arm.
Yes, absolutely. That's what the forensic pathologist does.
Without telling me what your opinion was, were you able to come to an opinion or conclusion about the source of those injuries?
Yes, I was.
What methodology did you employ to come to that opinion or conclusion, or those opinions and conclusions?
My experience and knowledge and training, along with the appearance of the wounds on the right arm, which fit a pattern, and then knowing that it fits a pattern, then I can try to look for, okay, what is the item that caused this pattern? And that would be part of the differential diagnosis that I've used for many, many years in making diagnoses and determinations.
Have you ever been trained in pattern recognition?
Yes.
In what capacity?
Oh, as a forensic
Doctor?
pathologist and medical examiner, a large amount of our work has to do with recognizing pattern injuries, because that's so important, because it gives us an idea of what might have caused that injury. And then that's clearly of a lot of importance to the police and the investigators as they're trying then to say, well, what could have caused that injury? And so the forensic pathologist could say, well, I think it was X or Y. Then they can carry out their investigation armed with that information as to what might have caused the injury on the body.
Is there such a thing in the world of pathologists as medical literature or academic literature that deals with pattern recognition?
Yes.
Are you familiar with
so.
some or most of those publications?
Absolutely.
Have you ever yourself taught classes on pattern recognition?
Yes.
At what level? High school, graduate school,
At
medical
the
school?
medical school level.
How often have you taught courses on pattern recognition?
Oh, at least a handful.
When was the last time you taught a course in pattern recognition?
Let's see, last month.
Do any of the courses that you've either taken, well, let's take them one at
When did you last teach medical students about pattern recognition? Last month, actually, it
a
was.
time. Have any of the courses that you've ever taken dealt with wound pattern recognition as it relates to animal wounds?
Courses that I've taken?
That you have taken?
It's part of our basic training and understanding of a forensic pathologist. The board exams we take test for that. Those injuries are described in our basic forensic pathology and medicine textbooks.
Right.
They appear
to know.
continually in our medical and scientific journals.
Is that an important skill set to develop, wound pattern recognition as it pertains to animals as a forensic pathologist?
Absolutely.
Do any of those academic courses that you've either taken or reference works that you just referred to, do any of those deal with dog bites and claw marks specifically?
Oh, yes, they do.
In the course or courses that you have taught related to wound pattern recognition, have you ever taught on the subject of dog bite wounds and the recognition of dog bite wounds?
Yes, I have.
When was the last time you did that?
Let's see, it would be in the course in the medical school. Would have been several years ago.
Doctor, with regard to staying with dog bite wounds specifically, have you ever performed an autopsy that specifically dealt with dog bite wounds, known dog bite wounds?
Yes.
So you've seen them in person?
Yes, I have.
Have you ever been qualified in any court in the land, state or federal court, on the issue of wound pattern recognition as it pertains to dog bites?
Yes.
When was that?
The last one I can recall was a federal case involving questions of a police dog.
Did you engage, in that case, did you engage in a differential diagnosis to determine, in your opinion and conclusion, your expert opinion and conclusion, the source of the wounds that you saw?
Yes.
Did the court qualify you to speak on that issue in court?
Yes.
Did you, in fact, testify
Which is very
in
helpful.
furtherance of your opinions and conclusions in that case?
Judges don't want to do anything weird.
I want to turn for a second
qualifying
to motor
before
vehicle accidents or
matters.
motor vehicle incidents. Do you also, some of the same questions, have you also performed autopsies on known motor vehicle pedestrian incidents?
Yes.
How many times would you say you've performed an autopsy on those issues?
Hundreds, maybe even 1,000.
Is that a relatively common occurrence, as sad as it may be, motor vehicle pedestrian incidents in the field of forensic pathology?
Yes, it is, unfortunately.
Have you performed autopsies personally as well as supervised autopsies on motor vehicle pedestrian incidents?
Yes.
And what methodology do you employ in the in furtherance of coming to opinions and conclusions regarding cause and manner of death specific to motor vehicle pedestrian incidents?
Well, we look at the scene investigation. We look at what the motor vehicle looked like. We look at hospital records, the autopsy, and then trying to understand how the injuries that the pedestrian sustained, what those mechanisms were, and how the injuries show that that person interacted with the motor vehicle.
In doing so, in coming up with injury mechanism analysis, is it important to look at and analyze the actual vehicle that is allegedly involved?
Yes, you want to look at photographs of that or see it in person.
Is that part of the normal methodology that is employed in the field?
Yes, you must look at the photographs. You must see what the vehicle looks like.
Do you also look at the other side of that handshake? In other words, look at the body of the individual that was, in your case, killed,
yes,
the decedent, in order to marry the two and determine whether or not the cause and manner of death had something to do with the motor vehicle, a motor vehicle impact?
Absolutely.
Describe that for us, please. What are some of the things that you look for that's part of the normal methodology that a forensic pathologist employs?
Well, when we examine a fatality from a motor vehicle, we want to try to understand what led up to it, how the impact occurred, and then what happened after. So we would study information about the injuries to see if we can relate them to certain pattern injuries that would be on the car. There are also evidence of transfer of energy and injuries that can result from the transfer of energy. So using the body, looking at the scene and the vehicle, understanding the motions of the vehicle and how they would have produced or would not have produced.
They're not going to get into all that
certain
once she
injuries on the
testifies.
body.
I'm going to take them one at a time. With regard to animal wounds
Consistent
or dog
or
bites,
inconsistent, yes. Mechanics, no.
were you able, in this case, using differential diagnoses, using inferential thinking, and using the skills that you've developed over decades of your education, training, and background, were you able to, without telling me what the conclusion is, were you able to come to a conclusion or opinion as to whether or not the wounds that you saw on John O'Keefe's right arm were consistent or inconsistent with a dog bite or claw marks?
I was able to come to a definite scientific conclusion.
And is that conclusion to a reasonable degree of medical certainty?
Yes.
Is it to a reasonable degree of scientific certainty?
Yes, it is.
Is it consistent with the training and methodology that you've employed over decades?
It is.
I'm going to ask you the same series of questions with regard to the motor vehicle incident. Did you review the autopsy report in an effort to look at John O'Keefe's entire body and all of the injuries that he sustained, not simply his right arm?
I looked at everything.
In doing so, were you able to come to an opinion or a conclusion as to the mechanism of injury and whether or not his injuries in total were consistent or inconsistent with a motor vehicle incident or impact?
I was able to come to a scientific conclusion.
Right.
And without telling me what that scientific conclusion is at this point, did you employ the same methodology that you've explained to the court earlier concerning differential diagnoses, inferential thinking, and decades of training, the education, training, and background that you've described for the court in coming to your conclusions about whether or not the cause and manner of death was consistent or inconsistent with a motor vehicle impact?
Yes.
Okay.
Your Honor, is there any area that I have not covered to the court's satisfaction to this subject?
So I'll let Mr. Brennan ask questions. I may have a couple of questions.
Okay.
Good afternoon, Dr. Laposata.
Good afternoon.
And we are still on voir dire. This is the
We could start
cross-examination with Brennan.
Dog bites.
Yes.
Did you have any specific training in wound pattern recognition regarding
She already
dog
testified to
bites?
that. Did you
Yes,
listen?
it's in our literature standard textbook. It's standard information that is needed to be a forensic pathologist.
When did you receive training regarding pattern recognition of dog bites?
Beginning when I took my board, started in 1983.
And what did that entail?
It entailed reading literature. It entailed reading the standard forensic pathology and medicine textbooks. And it is a sub-part of understanding pattern injuries. Dog bite injuries are described in all our journals and all our standard forensic textbooks.
Other than reading about it when you were studying for your boards, did you have any practical experience where
said
you
she
were
did.
engaging in the field in pattern recognition analysis regarding dog bites?
Yes, yes,
She
I've
said
had
that.
many cases where there have been dog bite injuries.
Yeah, and she testified in
When
federal
you were
court.
studying for your boards, were you doing that, or after you
Well,
completed your boards?
I'm telling you that that it's such a basic part that during studying for boards, it's a section that we study. And I, of course, had many cases since then.
Did you receive any education past reading literature for the boards, where you took classes, seminars?
No, she
where
teaches
it
them,
taught
Brennan.
Specifically, wound pattern recognition regarding dog bites.
She teaches about
It's all
it.
part of wound pattern recognition. It's usually included in literature. If there are lectures about patterned injuries, it's a subset of pattern injuries like hammer injuries, like gunshot wounds, like
everyone else has said, it is part of the training dealing with identifying injuries. It's not a separate thing. It is part of it. A stab wound looks different than a bullet wound, looks different than a dog bite wound. But dog bite wounds look like dog bite wounds, and stab wounds look like stab wounds. So it's every single person who has testified about this has said this. There is not a class on just the one thing. It is a section.
baseball bat injuries. There's a huge number of types of patterned injuries that are part and parcel of what a medical examiner has to understand and diagnose.
Do you remember
Baseball bats
taking
look
any
different than
specific
skateboards.
classes or any specific training about wound pattern recognition relative to specifically
Just
dog bites?
Told you.
Yes, it's in all the literature that I keep up with.
Did you take any training or did you attend any classes that involved wound pattern recognition of dog bites?
Yes, it's often included in our seminars and case reports.
Do you list any of those classes or seminars on your resume?
That I took?
Why
No.
would I?
Can you identify one of those classes, where it was, when it was, who taught it, what the name of it was, regarding wound pattern recognition relative to dog bites?
I can't give you a specific time and date.
Can you remember the name of the last class or seminar that you took or completed that has to do with wound pattern recognition relative to dog bites?
I can't recall.
Is there anything
Though I don't think dogs
In
have
your
evolved so much during the course of our lifespans that taking a class 3 years ago and taking a class 10 years ago is going to matter that much because dogs.
report that identifies any of your specific education or training on wound pattern recognition as it relates to dog bites?
It's in my CV. It's basic knowledge that a forensic pathologist has to have.
I will ask you about the CV, but Dr. Laposata, I just wanted to ask you about your report first. Is there anything in your
Okay.
report that points to any specific training
In the report that I wrote on
in your
this
report
case,
relative to wound pattern recognition as to dog bites? Is there anything in your report that identifies that for us?
in my report, I put together the case of what happened to Mr. O'Keefe.
Okay. As far as your experience,
Right.
though, do you ever make any note in your report about your specific experience and training about wound
She's like,
pattern
I
recognition
told you I was
for
a
dog bites in
medical
your report?
examiner.
No,
so
it's not appropriate.
I told you I was a medical examiner.
In your CV,
so that's.
is there any way you can point to us where you had specific training for wound pattern recognition relative to dog bites, where we can see that on your CV?
No, it doesn't say dog bite training specifically, no.
Do you have anything on your CV that specifically talks about wound pattern recognition for animals?
Those are usually classified within other pattern recognition.
Do you have anything specific that would alert us in your CV that you've had such specific training on wound pattern recognition for animals?
Other than I've passed my board exams and have practiced for 40 years.
Have you provided a list of cases where you have testified in court specifically about wound pattern recognition of dog bites?
She said that in federal court.
I don't know if I have given a list. I don't keep those kinds of lists.
You mentioned one case about law enforcement dogs in federal court. When was that
Did say
case?
that.
Several years ago.
How long would you say, if you had a guess?
How long was it ago?
Yes, please.
A couple years, around COVID time.
Did you testify in that case about law enforcement police dogs?
I testified about an
Injuries.
individual who had injuries, and there was a question as to whether Canine Caper, who was the dog's name, inflicted any injuries on this
Canine
person.
Caper.
And this was in Boston federal court?
Springfield, yeah, Boston, right.
Is there a difference between law enforcement dog bites and domestic dog bites?
They have the same kind of dog jaw.
So you would say
they're
that-
taught differently, obviously.
Would the wound pattern recognition be the same or different if you were looking at it from a law enforcement dog perspective or a domestic dog perspective?
The dog would be the same.
Do you have any other cases that you've testified?
She's like, a dog jaw is a dog
Pattern
jaw.
recognition relative to dog bites.
But the
I've
training is
testified
different.
in hundreds of cases. I can't say that I remember any particular ones.
Would you be able to identify any of those for us today?
No, too many.
I'll ask you about accident reconstruction experience. And I mean this respectful, you don't have a biomechanical or a medical engineering type background, do you?
No, I'm not a mechanical engineer.
And you're not certified by ACDAR or any of those type of organizations, are you, doctor?
No, I relate the injuries on the body to the motor vehicle.
Have you ever been to a car collision scene and investigated a car collision scene firsthand?
Yes.
And when you've done that,
I bet
do
he's
you have a
surprised
chance
by
to
that.
look at all of the physical materials, the properties?
Well, when I go to a scene of a motor vehicle fatality, I look at the pieces that are scattered around, I look at the body, I look at blood stain patterns, I look at damage to the car, and then the body would go back for the examination at the medical examiner's office, and there would be further examination of the scene by accident reconstructionists and examination of the automobile by specialists who could figure out what motor vehicles do. So it's a part of correlating the injuries
It's part of
to the
a larger
vehicle.
puzzle.
Have you,
Right.
you've never written an accident reconstruction report yourself, have you?
No, that's not what I do.
I understand. In this case,
I understand.
What
Then don't ask the question. Have you ever written a report? No. I'm the coroner. I understand. No. No, not no. She's like, do you
materials
understand?
did you look at? Because I don't think in your report it mentions the materials that you studied. What materials did you study as the basis for any potential opinions regarding accident reconstruction?
Review?
Well,
What did she
so
review?
You would like for me to tell you everything I studied in this case?
Yes,
I have my list here. Should I read
that's fine
from
by
that?
me.
Okay. I studied the autopsy report, neuropathology report, toxicology, and associated paperwork from the medical examiner's office. I studied 104 autopsy and neuropathology photographs, 70 additional autopsy photos taken by Trooper Watson. I studied Mr. O'Keefe's medical records from the Canton Fire Department and EMS run sheet. I studied the Good Samaritan medical records that also included 35 photographs of the body. I looked at evidence of Mr. O'Keefe's clothing blue jeans, t-shirt, sweatshirt, boxers, and sneakers. I'm sorry. I looked at photographs that were taken at the crime lab of various pieces of plastic, black, red, and clear.
Right.
I studied photographs of the outside of Ms. Reed's SUV as it was parked at the police garage. I studied the Canton Police incident report, about 100 photographs taken by Canton Police of the outside scene. So that gave me a very good idea of what happened in
Right,
this
she looked at the reports.
Were you involved in the case Cromwell versus Daniel Tompkins?
Remind me about that. I've been involved in hundreds of cases.
Yes, you have. This case was in Franklin County Superior Court. It was a case where you had an opportunity to present testimony and regarding blood spatter, which you have been qualified expert for. And that, I'm sorry.
Well, that doesn't quite say what I did, but I remember the case you're talking about.
Did you attempt, or was there an attempt to have you qualified to talk about accident reconstruction in that case?
No, I'm not an accident reconstructionist.
And do you remember whether or not there was an attempt that was denied to try to have you talk about accident reconstruction in that case?
Why would she know?
I have no idea. I'm not an accident reconstructionist.
Okay.
She's like, lawyers just do shit. I don't know what shit they're doing.
Do you have anything on your CV specifically that offers any background on accident reconstruction or accident reconstruction type classes or seminars?
I don't think so.
All right, thank you, Dr. Laposata.
No, you're welcome.
So can I just ask Dr.
And
Laposata,
questions from the court?
About, you said you've been involved in autopsies with dog bites.
Yes.
Yes, she did.
How many?
I've done thousands of cases, probably 50 or so. It's not always the cause of death. And then I've supervised maybe 75 more where that dog bites were involved in the case.
Over 100.
When was the last one?
Let's see, probably 2 years ago.
Any questions based on my questions? All right, you are all set and asked you to step down.
I think she,
We'll get
I'll
to
be
you sometime this
surprised
afternoon.
if she doesn't allow it.
I do want to give everybody a break, including counsel. Can we do less than 5-minute arguments on this?
The defense is like, it depends if you're going to allow it or not. If you're going to allow it, we'll just shut up now and not do any argument, Your Honor. If you're going to allow it, just tell us you're going to allow it. Do you need more argument? You heard the voir dire.
Your Honor, I'll make this very brief.
Okay.
Dr. Laposata is eminently qualified to speak to both the issue of wound pattern recognition as it relates to dog bites, specifically, as well as cause and manner of death as it relates to vehicle pedestrian incidents or impacts. The doctor has an incredibly impressive resume, just a touch of which we reviewed during the course of this voir dire for her qualifications. But with regard to the dog bite specifically, she talked about the differential diagnosis that she undertakes and undertook in this case. She talks about the inferential thinking that she undertook in this case. She talks about how that is the proper methodology in the scientific community and specific to the forensic pathology community in order to come to a determination about wounds and the source of wounds, i.e., was it a dog, was it another animal, was it another source, was it lacerations versus abrasions, things of that nature. She's obviously done, as she indicated, thousands, if not climbing real close to 10,000 autopsies.
She's done and supervised quite a lot of autopsies because she was the chief medical examiner, which means she's reviewing almost every autopsy that comes through, if not every autopsy that comes through. And just to clarify the argument, because some of you have just tuned in for the day, it's been a very busy day. They are not arguing about whether Dr. Laposata will testify or not. They are just arguing over scope. So this is purely over the scope of what the doctor will testify to, because she also did her own findings of cause and manner of death. So this is about whether or not she will also be able to get into some finer points of the of her assessment.
She's either supervised or that she's conducted herself. She actually has, notably, as per the court's last question, she's actually undertaken personally somewhere close to, I thought it was probably 5 autopsies herself dealing with dog bites. They're not always the cause of death, but sometimes it's attendant to the injuries that led to a different cause of death. But she's undertaken at least 50, or that's what she estimates, 50 of those autopsies herself. She's seen dog bites, she's seen dog wounds, she engages in pattern recognition. She also teaches classes on pattern recognition as it pertains to dog bites, and she's eminently qualified to speak to that in this particular case. She has been able to come to an opinion and conclusion as to whether or not the injuries to John O'Keefe's arm are consistent
in addition
or inconsistent
to the
with
other
dog
things
bites,
she's
and
testified
I
to.
expect that she would then give that opinion and conclusion to a reasonable degree of medical certainty and to a reasonable degree of scientific certainty. As it relates to her differential diagnosis and her ultimate conclusions concerning the automobile impact, obviously, many more.
The weather's at my house. It's loud.
Autopsies dealing with that because it's more common. She also engaged in the exact same differential diagnosis. She has training. The subfield of, or the sub-issue of vehicle pedestrian impacts is included and subsumed within much of the medical literature that she's been taught on, going all the way back to the 1980s, dealing with her boards, and she's consistently passed her boards. She's consistently kept up with the literature. She's consistently engaged in autopsies herself, so she has firsthand training. She also trains other medical professionals, other doctors, other medical examiners, and she supervises other medical examiners. She's been the chief medical examiner for an entire state. I cannot imagine somebody more eminently qualified to talk about the 2 subjects that she's been called to talk, well, she's called to talk about several other subjects, but these 2 subjects that's before the bench right now, than somebody with Dr. Laposata's qualifications. I will submit on the voir dire that we just completed.
All right,
Your Honor.
thank you.
Right.
Mr. Brennan.
I don't think they need a ton of argument on that because they had the voir dire.
I do not think that Dr. Laposata has articulated the experience the way it's been summarized. She could not provide any specific training other than her boards and her references to literature. She could not articulate one single class or seminar that she took that pertained to differential diagnosis of dog bite injuries. She has no specific memory of having any type of experience in differential diagnosis as far as being in a training seminar or advanced education. She has the experience of a medical examiner who has seen what she believes to be dog bites in the past.
That's not what she said. She didn't say she saw what she believed to be dog bites in the past, but I'll just...
She has no publications or references that she has studied the issue of differential diagnosis or pattern wound recognition relative to dog bites.
She just teaches it.
If we look at the standard Dr. Russell employed,
Okay.
Dr. Laposata does not have any of the merit to be an expert in dog bites. While
What-
she has taught...
Are you trying to juxtapose her with Dr. Russell? What?
You did not hear about anything in particular that she has taught about specific pattern wound recognition analysis regarding dog bites. She is an experienced medical examiner, has a wealth of experience, past experience in autopsies, but she has no experience that is a basis for her as an expert in being a dog bite
Yeah, the federal judge disagreed.
expert. Particularly, she mentions one case that she's testified in federal court that we've heard of today, and she has nothing whatsoever in her report or resume to establish that she has used, studied, and knows this methodology. In fact, her CV and her report don't have any basis for one to look at and see that she has any specific experience in dog bites. And so Dr. Laposata, from the Commonwealth's perspective, should not be able to give an opinion regarding or about whether or not the wounds on Mr. O'Keefe were caused by a dog. She simply does not have the training and experience and education and methodology to make her a so-called dog bite expert. Regarding accident reconstruction, she said it best. She is not an accident reconstructionist.
Agreed. I agree with
some
that.
of the materials in this case.
But she's a coroner that has seen, what, 10,000 autopsies or what have you. So she's going to know what an injury from a vehicle looks like.
But it is a fraction of the materials in this case. She is not in a position to give an opinion whether or not the wounds are consistent with broken taillight. There is nothing we see on her CV.
She is in a position to give an opinion about whether the injuries to John O'Keefe writ large are consistent with a vehicle collision. Yeah, she is.
There's nothing we see in her report. There's nothing we heard on direct examination that she has any experience in breaking glass, breaking plastics,
Breaking Bad,
and the causation of wounds. It also overlooks the fact that the opinion that would be offered would extend beyond just the wounds on the arm. It would extend to a general opinion that he was not involved in a collision, and that's improper. There's no predicate or basis for it. And so based on her testimony and absence of being able to provide any education or experience, she should not be able.
Your whole case is centered around whether John O'Keefe was struck by a vehicle. And you're saying there's no basis to ask if his injuries are consistent with being hit by a vehicle? Dude.
To testify about either of these two matters.
Okay, thank you. Okay.
Mr. Brennan suggests that she's only been qualified in one court, federal court. The federal government, the federal judge that was handling that case, qualified
her,
as
right?
a dog bite expert in that case. That is not a small thing. That is, as a matter of fact, it's a very big thing for Dr. Laposata and her credentials. In addition,
and Brennan said the reason his expert should be allowed to testify is because they previously qualified in federal court.
Indicated, contrary to what Mr. Brennan just suggested, she indicated that she has been training on wound pattern recognition as it pertains to dog bites for her entire career.
It's like
not
what they
just
do.
when she was studying for her boards, since she's been studying for her boards. And it's been constant and consistent throughout her entire career. She's made these differential diagnoses. She's seen the autopsies. She's seen the wounds during autopsies firsthand, probably 50 or more. She's supervised another 75 or more autopsies dealing with known dog bite wounds. She has the credentials. The court will recall that, for instance, Dr. Isaac Wolfe was called to testify by the Commonwealth. He had absolutely nothing, no credentials whatsoever to talk about wound pattern recognitions. He was a neurosurgeon, and yet he was allowed, over Mr. Alessi's objection, to talk about and to discuss his opinions and conclusions
with regard to the injury to the back of the head.
On the back of John O'Keefe's head.
Right.
Certainly, Dr. Laposata brings much more to the table than Dr. Isaac Wolfe. I'm not comparing them. They're apples and oranges. Dr. Laposata is she doesn't have to be a sole dog bite expert to be expert in dog bites. She doesn't have to be Dr. Russell. She just has to have that level of knowledge, that level of skill, that level of expertise that's beyond that of the average layperson in order to opine as an expert on a particular issue. She
Which is
certainly
the
brings
standard
that to the
for
table
experts.
as it pertains to dog bites, and I think her skill and her education, training, and background certainly speaks to the fact that she has that in spades with regard to motor vehicle pedestrian incidents.
All right.
I'll submit.
Thank you. All right, I'll get your ruling as soon as I can. So we're going to start back up at 2:20, and I expect to go straight through the rest of the afternoon.
All rise for the court, please.
Anyone else exhausted? I'm exhausted. I don't think it's just from travel. Today has been so much. All right, they are going to lunch. Let's see if they are back yet from lunch. It looks like the court's going to make a ruling on the record. I think what I'm going to do is let the court make their ruling, then take a restroom break so we have Zoom room. Chat, do you agree? Should we just do that? I think we should just do that because it looks like the court's just coming back on the record. Let's do the ruling and then because I think that's what the court's going to do. I'm speculating, but it looks like the court is talking to the lawyers before the jury comes in, and then we'll take a restroom break for Zoom room, because I very much want to hear what the court has to say after that voir dire over the lunch break of Dr. Laposata, who is a medical examiner testifying for the defense. And it is expected that that witness will testify to manner and cause of death, whether or not they agree that there was hypothermia involved in this case. And the defense is, well, the Commonwealth is trying to limit Dr. Laposato's testimony with regard to injuries from a motor vehicle accident, injuries from a dog, and the defense is arguing that that should not be limited during the voir dire of that witness. Let's take a look. This is after the lunch break now. The court is coming back, and then we will take a quick break to leave us the Zoom room that Emily so desperately needs.
You may be seated.
All right, I appreciate the court personnel waiting so that we could have that voir dire.
Yeah, I'm sure
It was helpful.
they got a much
All right,
shorter lunch.
So my rulings are very similar that they were this morning. So first of all, on the Darbert analysis regarding Dr. Laposata being able to testify as to the dog bite wounds, I find that she is not qualified. I'm not satisfied that the Darbert requirements have been made. Specifically,
Really?
not just the experience, but the reliability of the methodology she used and how it was applied. So based on that, she cannot testify to the dog.
It's the exact same methodology that all of the other doctors have used. Literally the same. Like literally the exact same methodology that all of the other doctors have used. Like same.
Dog wounds. And I want to take a minute to differentiate this testimony with Dr. Russell's. I found that Dr. Russell was an expert qualified to testify as to dog bite wounds, mainly from her experience in the ER, coupled with her being an ME. Dr. Laposata does not have that experience. I found that Dr. Russell's methodology was reasonable and was sufficient, and I found that it was appropriately applied. Remember that Dr. Russell was published in the area here. So regarding pages 10 and 11, all of the text on Dr. Laposata's report on pages 10 and 11 that start with the injuries on Mr. O'Keefe's right arm are excluded. Now moving on to the testimony regarding not being consistent with a motor vehicle strike. I find that Dr. Laposata's opinion on these not being the result of a motor vehicle collision exceed what is within her scope of expertise in some regards, not in all. In some regards,
Wait,
significantly, like I said this morning. So on page 17, the first sentence is in. The second sentence, tail lights are typically made of durable polycarbonate or acrylic plastic. That is out.
Okay.
I know the Commonwealth objected to,
Fine.
but I'm letting in. Mr. O'Keefe's patterned injuries on his right arm do not correspond to injuries that could have been produced by irregular fractured plastic pieces impacting the arm. She cannot say tail light, but she can say that based on her experience.
Okay.
His arm had no tissue bruising.
So what the court has just parsed is she's not allowed to say what a tail light is made of. She can't testify to what a tail light is made of, but she can testify that the injuries are not consistent with broken plastic. She can't say that a tail light's broken plastic. But can say that the injuries aren't consistent with broken. Okay. But she is going to be able to say that the injuries are not consistent with a vehicle collision. It's narrowing down the way she can say it, which is wild. But it's also an evidence. So her opinion stands, but not her opinion based on not her opinion as to what a taillight is made of. Okay.
From impact.
Sure.
That also comes in. And the next sentence, neither did his skin show any array of irregular, unpredictable, randomly scattered cuts and scrapes at various angles and depths. That's within her realm of expertise as a medical examiner. The next page, though, I may have said this morning that first sentence, importantly, in review of that, in review of the Tompkins case, that first sentence stays out because to me, it seems like that sentence depends on a biomechanical analysis, factors such as speed and force and the position of Mr. O'Keefe. So that's, oh, I'm sorry, page 18, the next page regarding the same subject matter. And portion of the next sentence is also out. This results in bruising or bleeding under the skin. That's out. But Dr. Laposata can testify that Mr. O'Keefe had no bruising on his arms or torso. And that's it for that sentence. In particular, Mr. O'Keefe did not have bruises on his legs as shown by dissection of leg tissue and muscle at autopsy. That's it for that. And the conclusions are problematic to the extent that is consistent with this ruling and what we discussed on Friday. So that's it. That was just the text of her report. I have not begun to go through all of the, there's no PowerPoint with this, Mr. Jackson, right?
There is no PowerPoint.
All right. Do you intend on displaying any of these photographs?
I'm sorry?
Do you intend on displaying any of the photographs that are in her report?
Yes. I have to go through it now with
All right, so you likely not get to that today. We've done important work, but we've wasted an awful lot of the jurors' time today. So I want to bring them in. And right, we're going to do that now. So that'll give you an opportunity to pull your thoughts together.
Right, and I expect what I will do is my attention. I will go through her. That will take me a good amount of time. I will go through the part of her initial analysis. Will not include any photos, but I may need overnight to actually go through the court's ruling. It's very specific, and I want to be as
okay. So let me know what you intend to put in. All right, and there's a lot of text
he's saying he's
describing
going to
the photos.
Go over it
is
after
out,
court's
right?
done for the day.
It's just hearsay.
I mean, we've had Dr. Welch's PowerPoint.
That was not objected to. There's a big difference. So we'll deal with this tomorrow, with the photographs tomorrow. Okay, thank you. And we're bringing the jurors in. Did the Commonwealth want to respond in any way?
No, thank you.
Okay. And there's a motion on Dr. Rentschler. We will give that, I haven't read it yet. We'll give that no more than 5 minutes tomorrow morning each side. This jury, you can tell just by looking at this jury, they're fed up. So.
Your Honor, the only thing I want to put on record is, with regards to the court's ruling, I do want the record to reflect that is obviously it's over the defense objection.
Sure.
And I just want to make for the record a quick comment. The Commonwealth waited until June 5th to even bring this up, to file a motion regarding Dr. Laposata. They had a report, and all reciprocal discovery was done in March 6th, 2025. That's document number 45.
Yeah.
So why bring it up so late? Right.
Whatever motions they wanted to, whatever motions in limine they thought were
and then they didn't.
March 7th, and they did not do that. They were supposed to be heard on March 18th.
Okay, so the jurors are coming in. We're going to mark the report and the CV for identification.
I just need to know when I can make it.
You just made it.
I made it ish.
Okay. Okay.
She's like, you just made a record. He's like, I made it ish because this should have come up in motions in limine. Right.
Go ahead, real quick.
The point is, the Commonwealth has not explained the delay
So,
in making this motion. They haven't, and we're playing by the same rules, Judge.
so the basis of my ruling was not late disclosure. Okay. Late disclosure. Disclosure. Commonwealth says they're part.
That's not the court's missing the point. It's the opposite. We got late disclosure. We got late disclosure that they they were objecting. They had since March to object. They blew the motion in limiting time, and then they come in just before Dr.
All right.
Laposata testifies, and now they're sort of sandbagging this, and then the court moves against us. So I want to make sure that the record is imminently clear.
Very clear. Mr. Brennan, do you want to respond real quickly?
Your Honor, we can always object even during the offering of testimony. There's no foundation. It's a foundational issue.
And that's consistent with what my rulings were when I allowed other witnesses to testify, that the defense could object if the foundation weren't properly laid. So bring them in, please.
Okay, the jury's coming in after the lunch break. I'm going to take a very quick break, but not before we go over what the court's rulings were and weren't. After the voir dire of Dr. Laposata, the court ruled that Dr. Laposata cannot testify that the wounds on John O'Keefe's arm were from a dog. And the court differentiated her ruling between Dr. Russell and her ER experience vis-a-vis Dr. Laposata and her vast experience as a medical examiner and the chief medical examiner in Rhode Island. And the court said, I don't find that to be sufficient, which is surprising, honestly, because it seems like when you've done enough autopsies, that should be sufficient. However, I imagine we will see the defense ask about whether or not Dr. Laposata reviewed the findings of Dr. Russell and harken back to Dr. Russell that way, because Dr. Russell's testimony is already in and the jury has heard it. So I imagine what we're going to see is the defense asking in that way. What Dr. Laposata will be allowed to testify to is the original opinions about cause and manner of death, which seem to be the main point of her testimony, which is why they don't just have one doctor, why they have Russell and Laposata, because they did different things, and will be allowed to testify that she did not find the injuries to John O'Keefe's arm consistent with a motor vehicle collision. But she won't be allowed to testify that taillights are made of polycarbonate. But will be allowed to get into the injuries not being consistent with a vehicle collision. So I think at the end of the day, other than her not being able to get into more of why she believes the injuries to John O'Keefe's arm are from a dog, she will be able to get into why she doesn't believe those injuries come from a car. So that will be, well, the testimony today and into tomorrow, because I don't think the defense is going to be done tomorrow. We've got Dr. Laposata, and then they've got Dr. Rentschler, who it seems like will be the defense's last witness. This has been a very fulsome day. The judge says that the jury seems kind of fed up. There's been a lot of non-working time in the court day today for the jury. So I'm not surprised that the jurors are frustrated as we are in the 8th week of testimony. And at the end, as the jury was getting ready to come in back from lunch, Alan Jackson was continuing to make a record that they had turned this information over to the Commonwealth. The Commonwealth did not make these objections during motions in limine and are making these objections now. And the Commonwealth said these are based on foundation. There's no foundation. And, well, that's why I'm making the objection. The court said, yes, that's consistent with my ruling that objections can be made based on foundation at any time. So that's where we're at. They are coming back from lunch. I am leaving a little Zoom room to run to the restroom. Today has been one of those court days where I'm sure everyone is just like, you've got to be joking that this is where we're at. Everyone seems tired and frustrated today. It's been quite a lot, and I'm not surprised that the jury is frustrated. I'm not. There's been a lot of starts and stops, less than last trial, but a lot of starts and stops in a long case. 8 weeks plus jury selection is a really long time for jurors. And it is interesting to me, and I'm sure we will go back over it when we do the case brief tomorrow, which will be out on the Emily Show channel. But what the court said she was going to tell the jury when they came back in and what she told the jury about the hoodie was not the same. So I imagine we're going to see the defense bring that back up at some point. Maybe we won't. I'd be surprised. But I think we'll see the defense bring that up at some point, because what she said she was going to say and what she said was not the same. So with all of that, I'm going to take 10 minutes to run to the restroom and get lunch. So then, because I wanted to eat the cookies, I'm going to try to go get some actual lunch first and bring it back, and we're all going to snack together. So 10 minutes. Law nerds, food, hydration, ready, go. I will let you know when we are back in the app as well at lawnerdapp.com. I'm going to put on our quick hold music, and then we will be right back. And then we're going to have lots of questions, I'm sure, at the end of the day. But definitely need to go grab food, hydrate, and at least the weather's sort of holding now. So that's better. So let's get some music on. Let's take 10 minutes, which means, let's see, it is 1:55 local time almost. So 2:05 Central Time. So 10 minutes from now, Law Nerds. All right, go get some food. I'm going to put on some music. I will be right back. So do not fear. Let me try to find the music first and then get the video on, and then we've got all the things. All right, Law Nerds, I will see you back here in just a minute. We've got music. We've got music. We've got video. We've got lunch. Let's do the things. Lunch, lunch, lunch. There's lunch. Lunch. That one. Nope. Wrong one. Told you it's been a very Monday. Hey Law Nerd, court is still on break, but don't forget to download the Law Nerd app so you know exactly when we're back from break, and you can get a notification from us when witnesses take the stand that you've been waiting for, when something unexpected happens in court, and during verdict watch. The Law Nerd app has all of your live court notifications to keep you in the loop. LawNerdApp.com, free for iOS and Android. And while we're on break, don't forget to hydrate, get up and stretch, and take care of yourself. Trial days are long days. I know sometimes it's hard if you miss a day. That's why I've got daily case briefs dropping over on the Emily Show YouTube channel and the Emily Show audio feed on your favorite podcast app, so you can stay in the loop even when things get busy. App has all of your live court notifications to keep you in the loop. Take care of yourself. Trial days are long days. Hey Law Nerd, court is still on break, but don't forget to download the Law Nerd app so you know exactly when we're back from break, and you can get a notification from us when witnesses take the stand that you've been waiting for, when something unexpected happens in court, and during Verdict Watch. The Law Nerd app has all of your live court notifications to keep you in the loop. LawNerdApp.com, free for iOS and Android. And while we're on break, don't forget to hydrate, get up and stretch. Take care of yourself. Trial days are long days. Court, because it is time to go back to court. Today has been the most Monday to ever Monday. So much has happened, just so much has happened. But now we're getting back to the witness that was on the stand before lunch, and then there was an abrupt lunch, and then there was a voir dire, and it was like, and then, and now we are getting back to the defense witness who seems to be their investigator that went out to take measurements and pictures. And that is where we left off with witness number 9. So with witness number 9, that's where we should be, with the jury back in after lunch. For them, they had a very extended morning break. They came in late this morning because there were motions, then an extended morning break, then lunch. So now it is time to get back to court. So that's what we're doing. The jury has just come in, or jury is coming in.
Extraordinarily. Jurors, you have been extraordinarily patient with us today. We're going to go straight through until 4 o'clock, and we're going to make every effort to not leave you waiting out there as long as you have, as long as we did today. All right, Ms. Giannetti, is your witness ready?
All right. So we are after lunch. That is... I know there's a lot who feel that the court stopping at 4 is early, but that is not necessarily just the court. There is also quite a lot that goes into the logistics of transport, the court staff, the court reporter, and more.
Thank you, Ron.
There's a lot that goes into that.
Sir, before the lunch
beyond just the judge
break, you had identified 3 entrances to the front of 34 Fairview, leaving aside the 2 garage car doors. Do you recall that?
Yes.
May I have that last exhibit displayed, please?
All right, and that's where the objection was,
Not
and
that
that
one. The
is back up.
one that we discussed right before court. There it is. Maybe zoom in on that a little. Okay. What do you see on the screen at this point, sir?
I see the 2 rightmost entrances to the house, excluding the main front door.
Okay, which would be obviously to the left of this photo, particularly with regard to the 3rd entrance, the one in red. Could you describe that?
Yes, so it's if you're facing the house from the street, you're looking towards the west. So that door goes directly into the garage facing north.
Okay, so basically from the street, you don't have to enter the house, you can go into the garage directly.
That is directly into the garage, yes.
All right, and as we're looking at the house from this point, are we looking at it from the vantage point of Fairview Road?
Yes.
And that is a westerly direction toward the house,
It's a helpful
sir?
close-up.
Correct.
In the course of doing your further work that you were asked to do in this case, did you peer inside the garage?
Yes, I did.
Did you see concrete steps and a ridge there and a hard concrete floor?
Yes.
Sustained. Jurors disregard that answer.
You mentioned that you were asked to do some measurements. Can you describe what you were asked to do for the jury?
Yes, I was asked to measure from basically the mailbox area of the driveway to the various entrances to the house.
Did you take those measurements?
I did.
Okay, if I'd like to take them one at a time. First, did you measure from the end of the driveway next to the mailbox all the way to the main front door, which is not depicted on this photo?
Yes, I did.
How did you measure it?
I used my wheeled measuring device.
The wheelie thing.
And I walked direct.
I think the witness and I made the exact same face to whatever like siren honk went on outside, but the windows are open, so it's going to be louder.
Directly across the lawn to the front door, well, to the bottom of the front steps, and then use it to go up the front steps straight to the door.
And what was the measurement, if you recall, from the mailbox area near the end of the driveway to the main front door on the left?
I believe it was 65 feet 9 inches, but I have notes if I
I think you got it right, sir.
Okay.
Next, did you measure from that same location near the street, the end of the driveway next to the mailbox, to the second front door, which is actually depicted in the exhibit that's on the screen?
I did.
And how did you measure that?
I walked along the edge of the driveway on the asphalt, right next to the grass, towards the house from the mailbox and the edge of the street, towards the house. I took a left onto the brick walkway, proceeded along that walkway, then took a right to the walkway that you can see right there, heading directly to the door, and went up onto the little decking area, and then those 2 steps directly to the doorstep.
Okay, so you walked essentially almost the whole length of the driveway?
Yes.
Before you took the left to get to where the steps start, going to that second front door?
Yes.
And then went up to the door itself?
Yes.
Do you recall from your memory what the measurement was?
I believe it was 70 feet 1 inch.
And finally, did you measure from that same end of the driveway near the street next to the mailbox to the red side door, which is the pedestrian entrance into the garage directly?
I did.
How did you measure that?
I did the same thing, walking directly from where the mailbox and the driveway intersect, basically, all the way up the driveway, took the same left onto the red brick pathway, took a right to go towards the front door, went up the 1 step that you can see, and then instead of going up the next 2 steps, I took a right directly towards the garage entry door.
So essentially the same path of travel, it's just you didn't go straight into the second front door. You took a right to go into the pedestrian entrance to the garage.
Correct.
And what was the measurement that you discovered having done that?
I believe it was 78 feet 3 inches.
Now, finally, could we have displayed the map of Cedar Crest, Fairview, and Chapman? There it is.
We love a map. Maps are super
Sir, are you
helpful.
able to see the street names from where you are? And if
Yes.
not, could we have the top street magnified so that the witness can see it? Okay, you see that?
I do.
What do you see that to be?
Cedar Crest Road.
Okay, if we could have the connecting street where the, that's it.
Fairview Road.
All right, and finally, the one down the bottom?
Chapman Street.
Okay, if we can get the whole map back up. Having seen those 3 street names, does that orient you as to what this is a map of?
It does.
And what is that?
This is the surrounding area of 34 Fairview Road, the neighborhood, basically.
Okay, and it includes the 2 connecting streets on either end?
Correct.
Does the red dot symbolize anything for you?
It looks to be where 34 Fairview Road is located.
Okay. And if you're on Fairview Road to the right of that red dot as it exists on that exhibit, and you're looking toward Fairview Road, what direction would you be facing?
I'd be facing west.
If I may have a moment, please.
Okay.
Okay. They wanted the westerly direction because of Whiffin's testimony from oh so long ago about the phone shifting to the west.
Thank you very much, sir.
And that is the end of direct. And we are on to cross-examination.
Good afternoon, sir.
Good afternoon.
You had a wheel to measure?
Correct.
And so there's like a tape measure, and when you wheel it out, it gives a straight line?
No, it's two wheels with a meter in between them, and you roll it out in front of you.
I see. Your first measurement was from the driveway to the front door?
To the main front door to the far left, yes.
And that was about 63 feet?
I believe it was 65 feet, something like that. I have my notes. Yes.
So suffice to say, if you were to leave the front door and come back to that spot, it would be an additional 65 feet back, right?
Yes.
The second measurement was from the bottom of the driveway to the middle door on the side?
Yeah, the second front door, yes.
Did you say that was about 70 feet?
It was, yes.
Okay. And again, if you were to come back, that would be an additional 70 feet?
It would.
And the last one was the door near the garage. Did you say that was further, around 80 feet?
78 feet, 3 inches, I believe.
One way?
Correct.
And back is another 78 feet?
Correct.
When you measured these, was it from the asphalt of the driveway or to the left of the mailbox as you're looking at Fairview?
It was to the right of the mailbox on the asphalt, as close to the mailbox as I could get.
Did you happen to take any measurements from the flagpole to the front door as far as
No.
distance?
I did.
And what was that?
Oh, really?
I do not have the exact measurement. I'm not sure.
Do you have it in a report that you could
I
look
don't.
at?
I don't. No, not with me.
You
How
didn't
about
write
the
it down?
flagpole to the middle door on the side? Did you take any measurements of that?
I'm not sure I took that one.
How about the flagpole?
That's so annoying. Yeah, I did measure it. Well, how far is it? I don't know. Damn it.
Way door, which would be the door next to the garage. Did you take any measurements of that?
I think I took a direct measurement to that, yes.
Right. And what was that number?
I don't know.
Do you have a report you could share with us?
I don't. No, I'm sorry.
It's okay. Did you ever measure if you were at the flagpole area, how long it would take to walk up the street? Or how far it would be to walk up the street, up the driveway, for any of those doors?
What the hell is Brennan saying? That is so
I
compound.
did.
And what was the distance if you were going to start at the flagpole, walk up the street, up the driveway, down the walkway to the front door?
I'm not sure that distance. Not positive.
You
the
just said
distance.
yes, you did.
Over 80 feet?
It was.
And if you did the same route up the street, up the driveway, to the middle door, would you agree that would be well over 80 feet as well?
Can you repeat the question? How?
Sure, if you were to measure from the flagpole, up the street, up the driveway, to the middle door, that would be well over 80 feet?
Yes.
Same to the door next to the garage?
Yes.
Thank you for your time.
And that's the end of cross.
All right, you
And
are
that's
all
the end of
set,
this
so
witness.
Thank you very much.
All right. I think Dr. Laposata will probably be the next witness.
Okay, Mr. Jackson.
Thank you, Your Honor. We would ask the court to
Okay.
ask Dr. Elizabeth Laposata to join us.
Okay.
This is witness number 10 for the defense. I don't think the measurements were very helpful at all, but the defense is going to, if they want to argue any of that information, they need it to be in evidence. So it's in evidence. So they have it if they want to argue it. They can't argue it if it's not in evidence. I imagine Dr. Rentschler will be the last witness, so that's why Dr. Laposata would go next.
Step up, face the clerk, and raise your right hand, please.
Or at least that would be my guess.
Evidence give the court and jury in the case now and hearing should the truth, the whole truth, and nothing but the truth. So help me God.
I do.
I'm going to try to gain this up a little bit more because it
Afternoon, Your Honor.
is, again, hard to hear. No, that's worse. The fans are
May I
so
inquire?
bad.
Yes, and Dr. Laposata, please speak right into that microphone,
I
okay?
will.
Thank you.
I mean, everybody.
Doctor, can you please state your full name and spell your last name for the jurors?
Yes, Dr. Elizabeth Laposata, spelled Laposata.
I'm going to ask you, you have a softer voice. I'm going to ask you to pull that microphone right under your chin, if you don't mind. It's pretty adjustable.
Better?
That's better. That's better. Doctor, can you tell the jurors what you do for a living?
Yes, I'm a medical doctor and I subspecialize in forensic pathology.
Can you summarize your professional background?
Certainly, I graduated in 1975 from Bucknell University with a Bachelor of Science in Biology. I went to University of Maryland School of Medicine, where I graduated in 1979 with a Doctor of Medicine. I did my internship and fellowship at Johns Hopkins Hospital in Baltimore, where I studied anatomic pathology, which is the study of the diseases of the body. I then did my subspecialty fellowship in St. Louis in forensic pathology, which is understanding causes of death and injuries to the body.
Currently, are you a professor?
Yes, I am.
And tell us where you work.
I own my own independent consulting practice, and I'm also an associate professor at Brown University School of Medicine.
How long have you taught at Brown University School of Medicine?
Since 1993.
And how long have you been a clinical associate professor of pathology either at Brown or before that?
Oh, gee, then that would have been since at least in the late 80s. I've been associate professors at the universities and medical schools where I've worked.
Doctor, at Brown University, let's take Brown first. What do you teach there?
I teach the second-year medical students. I teach a lecture in diseases of the heart, cardiomyopathy, and myocarditis. And I've been asked to give some specialized lectures in toxicology and forensic pathology.
Are you responsible for training medical students in the field of forensic pathology?
When I was a chief medical examiner, yes, we would have medical students, residents, come into the office so they could learn about what we do to understand cause and circumstances of death.
When you first got your medical license, did you then undertake to get certain board certifications and the like?
Yes.
Before we get to those board certifications, did you begin a practice in forensic?
Y'all, the judge and the defense attorney told this doctor to put the microphone literally in, like, directly in front of her mouth. So we are going to hear every time she takes a breath because they have told her to put the microphone directly into her mouth. So that is not on her. It just is. So it's loud in the courtroom. They want to hear the witness. She has a lot to say. It is what it is.
Pathology in some way or another.
After I finished my medical school and my anatomic fellowships and forensic pathology fellowships, then I was working in medical examiners' offices where I was examining deceased people to understand how they died.
When you get a medical license, is that statewide or is it nationwide?
Usually you get a state medical license.
And do you hold a state medical license?
Yes.
How many?
I have an active medical license in Rhode Island where I have my consulting practice, and I have inactive license in Maryland, Delaware, Missouri, Pennsylvania.
And you've been previously, at least before they were inactive, you were licensed in all 5 of those states?
Yes.
You already told us a little bit about your college. Did you mention Bucknell University? Your Bachelor of Science degree?
I think I did, yes.
I don't think she did. I remember Maryland.
After you graduated.
I remembered Maryland. I didn't remember Bucknell. So I don't know if she actually mentioned it or not.
From the University of Maryland School of Medicine. Did you complete any residencies?
Yes, I did my residency at, excuse me, at Johns Hopkins Hospital in Baltimore in anatomic pathology.
Would have been
forensic pathology is different from anatomic pathology, correct?
Yes.
Did you also do any kind of residency in forensic pathology?
Yes, I did a fellowship in forensic pathology.
And what is the difference between, if you can sort of take us through that little by little,
forensic pathology and anatomic?
Forensic pathology and anatomic pathology.
Anatomic pathology is sort of hospital-based pathology where we understand diseases of patients who are in the hospital and try to make clinical pathologic correlations to see if their diagnoses were correct, if the laboratory tests actually showed what we find at postmortem. And then forensic pathology deals more with understanding why the body stops functioning at a particular time. So that would be cause of death. and that can be sudden unexpected death or death due to violence.
I think she
And
explained
in
that
forensic pathology,
very
is that
well.
often associated with testimony in court cases that may deal with either on the civil side or the criminal side, coming in and testifying about things like cause of death and manner of death?
Yes.
What types of cases did you work on during your forensic pathology residency?
Oh, sudden unexpected natural death, gunshot wounds, knife wounds, sudden infant deaths, blunt force trauma, skeletonized remains, decomposed bodies, strangulation.
How much detail do you want to go
The
into,
whole
Jackson?
gamut of
all
ways
of it.
people can die unnaturally.
And sometimes naturally, just unexpected.
Contrast that, what types of cases did you work on during your anatomic pathology residency?
There you're mainly dealing with natural diseases and understanding heart disease or how somebody gets pneumonia, or looking at the brain to understand if a stroke was present. And that's especially important then to the doctors who are treating those patients, that they can see if the diagnostic tests were appropriate or if their treatments worked.
You mentioned fellowship a little earlier in your testimony. What is a fellowship?
A fellowship is after you've done your internship and residency. A fellowship is more specialized training, and I did that in forensic pathology.
So that answers my next question. You do hold a postgraduate fellowship position, correct?
Yes, yes.
And that was in forensic pathology specifically?
I'm board certified in anatomic and forensic pathology.
She's dual board certified.
Well, you're a research associate at the
in
Department
both.
of Pathology and Laboratory Medicine at University of Pennsylvania School of Law?
Yes.
I'm sorry, School of Medicine?
Yes.
She's
old
like,
habits.
Not
What about
School of Law.
postdoctoral research fellow?
Not
Were you ever a
School of Law.
postdoctoral research fellow?
Yes, I did. I had an NIH research grant where I worked on, how alcohol affects the heart.
Where was that?
That was at St. Louis University, and then when I was on staff at the hospital of the University of Pennsylvania in Philadelphia.
What about postdoctoral research fellow at dealing with the cardiovascular division
has
of the
done
Department
a
of
lot.
Medicine at Washington University?
Yes, that's where I did research on how alcohol affects the heart.
Was all this in furtherance of your broad education and training as a pathologist?
Yes.
I think you indicated that you have served as a chief medical examiner in answering one of the previous questions. Can you tell me a little bit about that?
Yes, I was appointed chief medical examiner for the state of Rhode Island in 1993, where I was responsible for all unexpected, unnatural deaths or deaths that involve violence in the state of Rhode Island. So I had to supervise the office, made sure I have adequate staff, made sure my forensic pathology staff were doing a good job, made sure I had an adequate scene investigative
Right, she had
staff.
to oversee literally everything.
So running the whole office.
Is that the highest appointment in the OCME's office?
Yes, it is.
In that position, did you oversee every single medical examiner in the state of Rhode Island?
Yes.
Did you also hold a position as a co-chair of Child Fatality Review Committee in the state of Rhode Island?
Yes, as part of being chief medical examiner.
Tell us a little bit about that. What was that appointment?
Well, there's a big concern about infants who die and children who die. So those are reviewed specifically by a group of doctors from the pediatricians and also then the medical examiner's office. So we look at every child and infant death.
How long did you serve as the chief medical examiner in the state of Rhode Island?
For 12 years.
Starting when and ending
It's a
when?
long time.
Starting in 1993 and ending in 2005.
As the chief medical examiner for Rhode Island, did you ever have the responsibility to work on any mass disaster cases?
Unfortunately, yes.
Okay, tell us a little bit about that. If you could start with the Egypt Air issue.
Yes. Excuse me, I'm so sorry. In 1999, the Egypt Air...
Damn it, defense team, just hand her a bottle of water. Before we get into mass casualty events.
90 was took off from New York airport, and it crashed off the coast of Massachusetts, and 2,065 passengers died. And because of the force of the airplane going into the water, all the bodies were fragmented. So they were brought, all the fragments were brought to my medical examiner's office. They actually vacuumed the ocean floor, and we had 2,600 some fragmented remains from that airplane crash, and that involved working with FBI, TSA to identify those individuals and understand exactly why they died.
What was your role and the role of your staff that you supervised in dealing with those other government agencies, the FBI, the NTSA, other entities, in terms of the fatalities that you did review as a medical examiner or the chief medical examiner of Rhode Island?
Well, I dealt with families from around the globe who had relatives on that flight, and then the FBI was looking into what may have caused the crash. The Egyptian government, who owned the airplane, was also there and interested in understanding what happened. And we were also, tasked with identifying everybody who was on the plane and to see if that matched the passenger manifest list. So were there people on the plane who shouldn't have been on the plane? So that sort of thing.
In terms of matching that manifest, were you the head of the department for the medical examiner's office that was responsible for trying to figure out who was on the plane and match those remains with the individuals that were on the manifest?
Yes, we made the positive forensic identifications and returned the fragmented human remains to their families. It's not actually...
The feed on that completely jumped. Apologies for that. We should be, let me back up. We gave ourselves some zoom room, and it looks like as we're heading backwards that there will be need for it. But we were not very far behind real time as she is talking about working on the mass casualty and how much her office was dealing with it.
Flight, and then the FBI was looking into what may have caused the crash. The Egyptian government, who owned the airplane, was also there and interested in understanding what happened. And we were also, tasked with identifying everybody who was on the plane and to see if that matched
the manifest. Okay.
Passenger manifest list.
So we're right back
So
to where
were
we
there
were.
people on the plane who shouldn't have been on the plane? So that sort of thing.
In terms of matching that manifest, were you the head of the department for the medical examiner's office that was responsible for trying to figure out who was on the plane and match those remains with the individuals that were on the manifest?
Yes, we made the positive forensic identifications and returned the fragmented human remains to their families.
Doctor, did you also deal with the tragic Station nightclub fire?
Yes.
In what capacity did you deal with that?
Again, this was a nightclub that burned down. It burned down very rapidly with a very hot fire, and that was in Rhode Island, and there were 100 fatalities from that. So those come to the medical examiner's office. I had my investigator at the scene throughout that time of recovering the bodies, and I was charged with determining the identity and the cause of death.
I've seen a lot of you ask, why are they going over this? And I think it's a fair question to ask, because why are they going over her work in mass casualty events? That's clearly not what this is. But she is being brought in to provide more information about determining cause of death of John O'Keefe. So her determining cause of death in a variety of difficult circumstances, unknown circumstances, and circumstances where when you're dealing with like the mass casualty air collision, figuring out what the cause of death is in addition to the identifications, she is reviewing tons of different types of causes of death. And that's part of why she's here, to review the cause of death in this case and see if she agrees or does not agree. So that's why they're going through her background to establish her as an expert, because when it comes to manner of death and cause of death, she's going to be giving an opinion on it. And she's it's my understanding, and we haven't seen her testify yet, but it's my understanding that she disagrees with Dr. Scortibello. So establishing her background vis-a-vis Dr. Scortibello's background is trying to prove where the expertise lies, because I'm sure the jury very much liked Dr. Scortibello. So trying to go through her background and all the work that she's done and her dual board certifications is to establish her expertise. All right, let's go.
Staff
Continue.
successful in determining the identity of most of those individuals who perished?
Yes, all of them. We worked around the clock for 3 days to get that done.
And you were the head of that task,
I
task
was.
force.
Yeah, her
Before you
office has
became the
dealt
chief
with
medical examiner
a
in
lot.
Rhode Island, did you previously work as a medical examiner under somebody else?
Yes.
Tell me about that. What was your first post as a assistant medical examiner?
My first post was after I did my fellowship training in St. Louis, Missouri. I was an assistant medical examiner for the city of St. Louis.
Were you ever an assistant medical examiner in Philadelphia?
Yes, so after St. Louis, I moved to Philadelphia, where I was on staff at the hospital of the University of Pennsylvania, and I ran the autopsy service there at the hospital, and I was also an assistant medical examiner for the city of Philadelphia.
That's busy.
After that, I was an assistant medical examiner for the state of Delaware, and then I came to Rhode Island as I was chosen to be chief.
Dr. Laposata,
So they recruited.
can we put dates on?
They recruited her. They recruited her from Delaware to be the head of the office for the entire state of Rhode Island. It's also important because if anyone on the jury is sitting there going, I mean, Rhode Island, okay, whatever happens in Rhode Island, I don't know. It's like, well, she's worked in St. Louis, she's worked in Philly, she's worked in Delaware, she's worked in Baltimore. So it's a lot of experience beyond just working in Rhode Island.
On that assistant medical examiner in St. Louis from when to when? Do you remember?
Oh my, let's see. May I look at my CV?
Sure, with the court's permission.
Okay.
He's like, I would need to look at the dates. Me. Just me. I would just
Yes,
need to
from
check.
1983 to 85, I was an assistant medical examiner for the city of St. Louis. Then in 87 to 91, I was the assistant medical examiner for the city of Philadelphia. 91 to 93, assistant medical examiner for the state of Delaware. And then 1993 to 2005, I was chief medical examiner for the state of Rhode Island.
Thank you for that. Dr. Laposata, have you held any faculty positions as in the field of forensic pathology that qualify you as an expert in this case?
Yes, every medical examiner's office I worked in, I also had faculty appointments to teach medical students and pathology residents. So I had faculty appointments at Washington University School of Medicine in St. Louis, at the Hospital of the University of Pennsylvania, in Philadelphia, and in Rhode Island.
Let's talk about those one at a time. Describe your teaching
It's a
responsibilities
lot of teaching.
at Brown Medical School, if you wouldn't mind. And that, by the way, that's from 1994 to present, correct?
93 to, well, as a medical examiner, it was 1993 to 2005. And there I would teach the medical students. We had rotations through the medical examiner's office, and also the pathology residents would rotate through the medical examiner's office, where I would teach them how to do a medical legal autopsy, how to understand cause and manner of death, especially non-natural and traumatic deaths.
With regard to your teaching responsibilities specifically, are you still teaching?
I'm teaching in the cardiovascular section now, but since I'm not chief of the medical examiner's office, I obviously don't have students rotating through there anymore.
Were you a lecturer in the role of medical examiner? Did you do a seminar in that regard at or associated with Brown University School of Medicine?
Yes.
Did you do some sort of a forensic pathology rotation or for pathology residents from 1994 to 1995 in that capacity as well?
Yes, we would have the pathology residents who were at the hospital studying anatomic pathology come to the medical examiner's office so they could understand the discipline of forensic pathology.
What is cardiomyopathy?
Cardiomyopathy is a muscular disease of the muscles of the heart.
And what is myocarditis?
Inflammation of the heart muscle.
Did you ever teach or lecture on
Are
those
we getting
issues?
into those today?
Yes, I teach every year. I teach the second-year medical students about those heart diseases.
Have you ever taught anatomy and physiology to EMTs?
Yes.
Or in the EMT setting?
Yes.
And what about a class known as the 2-hour primer on forensic pathology?
I've taught a lot. I don't recall that particular.
How about
She's like,
pathology
I don't know, I
residence
teach
morning
things.
conference in 2009?
Oh, yes. I give lectures to the pathology residents at the medical school at Brown Medical School in forensic pathology.
You also mentioned that you were an adjunct professor for biomechanical.
She's like, I've done so much,
I'm sorry,
it's
biomedical.
hard to quantify.
Forensic sciences and forensic anthropology in the Department of Anatomy and Neurology. Is that a division of the graduate school, Boston University School of Medicine?
Yes, I taught in the master's program in the medical school at Boston University School of Medicine for a master's in forensic science, where I taught a 40-hour course on forensic pathology and another 40-hour course on medical legal death investigation.
Were you actually the course director in that position?
Yes.
And were you also a course director in medical legal death investigation from 2006 to 2013?
Yes.
And what about a course director in forensic toxicology from 2006 to 2012?
Correct.
Okay.
Did you direct the studies in biomedical forensic sciences, GMS, from 2012 to present?
Yes.
Describe that. What is that?
The graduate medical sciences?
Correct.
Okay, yeah, I would review and be on the board to examine projects that the students were doing to get a master's degree.
Were you also an assistant professor in the Department of Pathology and Laboratory Medicine at University of Pennsylvania School of Medicine?
Yes.
Without going into every single class that you taught, did you teach from 1987 to 1991, attending staff medical pathology?
Yes.
What is that? Just a general outline of what that teaching course was.
She's done a lot.
That's when I was at the hospital, University of
She's seen a lot.
Pennsylvania. I
She's
ran
taught a lot.
the autopsy service, so I taught medical students and pathology residents about autopsy practice.
I want to ask you sort of broadly, can you describe your major teaching and clinical responsibilities when you were at University of Pennsylvania School of Medicine in the field of forensic pathology? What were your main clinical and teaching positions?
Well, I ran the autopsy service there, so I taught the medical residents and medical students autopsy pathology, and I was also a assistant medical examiner there, so I taught and started the forensic fellowship in forensic pathology.
Have you ever been qualified as an expert witness in forensic and anatomic pathology in state and federal courts?
Yes.
How many times would you say you've qualified as an expert?
Oh, I don't know.
Over 40 years, maybe several hundred.
So many. Yeah, so many.
How about in Massachusetts?
That includes all of them.
Okay. Have you ever qualified? Let me list a couple of states. In Massachusetts?
Yes.
California?
Yes.
Connecticut?
Yes.
Delaware?
Yes.
Florida?
Yes.
Illinois?
Yes.
Maryland?
Yes.
Minnesota?
Yes.
Missouri?
Yes.
New York?
Yes.
Pennsylvania?
Yes.
Rhode Island?
Rhode Island, yes.
Have I left anything out?
Okay, so
Did
like
you say
not
Massachusetts?
I did.
Okay,
I
then
was
you're
starting with
fine.
Massachusetts.
Okay, you're fine.
not Alaska.
What
period.
types of topics have you qualified to testify about as an expert forensic and
Did you say
anatomic
Massachusetts?
pathologist?
Yes.
Really, anything that has to do with circumstances and cause of death. So it doesn't really matter, what type of injury or a sudden unexpected death. Usually it involves examination, study of information from the scene, information from the autopsy, police and investigation and medical records, and we put that all together and figure out the circumstances as to how someone died and why their body stopped functioning. So that's the basis of forensic pathology.
Dr. Williams, excuse me for just a second. You're on a minute approach for one brief.
All right, and they are going to approach. We are going to zoom as they approach as best we can, which is why we love the zoom room, so we can zoom past the sidebars.
Okay.
Even the...
Yes.
Is she excusing the jury? What was she just saying? What was the court just saying?
Rather than send you back and keep you here for 2 minutes, Dr. Laposata, I'm
Yes.
going to ask you to step down and you can go back to the court officer into that back room.
Okay, certainly.
And jurors, rather than send you downstairs and back up the stairs to come back in 5 minutes, we're just going to, I'm going to sit here, you all can sit here, we're just going to be in recess for 5 minutes while we sit here.
All right, well, they're taking a 5-minute break. I don't know where they're going, but they're taking a 5-minute break. Why? Don't know. The jury's staying in the courtroom. The doctor is going out. They are taking a 5-minute break, and we are going to zoom past that 5-minute break. I know all of you enjoy seeing The Only Fan, but also we are ready to get back to testimony when we can get back to testimony. So we're zooming. All of you are like, what's happening? I don't know. We didn't hear the sidebar. There was a sidebar. The defense went out.
You can have a seat here.
The prosecution went out. The witness went out. The jury stayed in. The court stayed in. And now the witness is back. And there we go. So, all right.
May I inquire?
Yes.
Thank you. Dr. Laposata, you mentioned several topics about which you testified and qualified as an expert. Testified about it as an expert in several different states, several different
Oh, good. AJ found the
courtrooms.
microphone.
Have you been qualified as an expert by those courts in those topics about which you just discussed?
Yes.
Do you hold any specialty certifications in the field of forensic pathology?
Well, I'm board certified in forensic pathology.
What about the American Board of Pathology?
Yes, the American Board of Pathology puts forth examinations that are a 2-day examination in the various disciplines of pathology. And if you successfully complete those examinations, then you become a diplomat of the American Board of Pathology in whichever subspecialty you're in. And I became a diplomat in the subspecialty of anatomic and forensic pathology.
What about a certification in basic bloodstain pattern analysis, the International Association of Identification?
Yes, I had a week-long course in understanding blood pattern analysis.
Can you tell us a little bit about the National Registry Emergency Medical Technician certification that you hold?
Yes, I took training to become an EMT.
Did she need a training to be an EMT?
Have you received a number of honors and awards in the field
I
of
guess?
forensic pathology?
I
Outside
have.
of being a doctor, you would have to, but okay.
What do
She's
those
done
awards include?
lots of things.
May I look at my CV again? Sure. Thank you.
What do those awards include? A number of you asked if she could have gone out so they could have apprised her of the court ruling. That's very possible that they took 5 minutes to apprise her of the court's ruling from earlier. Entirely possible.
I had teaching awards from Brown University School of Medicine. I was featured in a book by Faces of Public Health as having run a good medical examiner's office. I was nominated for Woman of the Year in Rhode Island for my work as chief medical examiner in improving the office and handling those 2 mass disasters. I was honored by Victims' Rights and Services Awards because I've always been aware of the fact that as a forensic pathologist, I am the last doctor this person is going to have, so I try to help the family understand what happened. I was honored for my work in the mass disaster in Egypt Air 990 plane crash. Let's see. I was Outstanding Woman in Public Service for Providence, Rhode Island. I've gotten teaching awards from Brown University School of Medicine. I was elected to the Board of Trustees in the Delaware SIDS Foundation and the Philadelphia SIDS Foundation. And then we're back to my medical school.
If you could pull the microphone a little closer.
As you recall, during the cross-examination of Dr. Russell, Brennan asked Dr. Russell, do you know of Dr. Laposata? And Dr. Russell had said, I don't know her. I know the name. She's well respected. And he was like, are you just saying that because she's part of the defense team? I think we've head off that line of questioning at this point. I think we've skirted around that line of questioning. If any of you remember back to what was happening, well, are you just saying that? It's like, no, I've seen her speak at some of the conferences I've been at. I've seen this, I've seen that. I'm familiar with the name. And I think we're getting a more fulsome explanation as to why. I also saw a number of you asking if this Egypt air crash had anything to do with some of the other cases I've covered. No, the Egypt air crash and the Lion air crash are different years, different events. And the reason they're telling her to pull the microphone closer is not for us here at home. It is for the courtroom. So they are having a hard time hearing her in the courtroom, which doesn't surprise me.
To your chin.
It's loud in the courtroom.
The chair doesn't push it.
Oh, it doesn't. The chair doesn't move. Okay.
Oh, I got it. I moved.
We'll make do.
Okay.
Thank you, Dr. Laposata. What is the American Academy of Forensic Sciences?
That's one of our medical associations that is specific to forensic sciences.
Have you ever held a chaired position there?
Yes.
What position was that?
I was voted into a fellowship position.
Were you the chairman of Forensic Science Research, the Forensic Science Research Committee?
Yes.
What's the National Association of Medical Examiners?
It's also called NAME. It's another international association of forensic pathologists.
Were you a member of that organization?
Yes.
And at some point, did you get elected to the board of directors for that organization?
Yes.
And ultimately, did you become a fellow for that organization?
I did.
What is the American Society of Clinical Pathologists?
That's a society that is for people who practice anatomic pathology and understand how to interpret laboratory results and biopsies.
Did you become a fellow in 1991 until present for that organization?
Yes.
What's the difference between a member and a fellow?
A member is a lower level, and then you can be promoted to fellow if the board of directors feels that you've contributed in your field.
And were you associated with the College of American Pathologists?
Yes.
Were you a fellow there as well?
Yes.
What about the World Association for Medical Law?
Yes.
What about the American Association for Clinical Chemistry?
Yes, I'm a member.
Just like all. Just all.
Rhode Island
Just
Medical Women's
all.
Association. What is that?
Well, it's basically what it says. It's women doctors in Rhode Island.
Were you elected to the board of directors for that organization?
Yes.
The name says
Ultimately,
it.
were you elected as the president of that organization?
I was.
Rhode Island Medical Society. What is that?
It's an organization of doctors who practice in Rhode Island.
Are you a council member there?
Yes.
And what about the Massachusetts Medical Legal Society?
Yes, I was a member there. They have disbanded since.
It doesn't exist anymore?
No.
When it was up and running, you were a member in good standing?
Yes.
Good, good. Pennsylvania Association of Pathologists. What about that?
Yes, when I practiced in Pennsylvania, I was a member of that organization.
Did you, in addition to be a member there, did you also hold a chaired position? Were you the chairman for the Committee on Forensic Pathology?
Yes.
Have you served on any editorial boards of any scholarly journals or
Yes.
publications? Tell me about that.
I bet that's a
I've
yes.
reviewed articles submitted for the Journal of Forensic Sciences and the National Association of Medical Examiner Journals.
Did you also hold an editorial position for the American Journal of Forensic Medicine and Pathology?
Yes.
Is that one of the,
She's just
the
on the
medical
editorial
journals
board.
that is
NBD.
used throughout the country by other medical professionals, other medical examiners?
Yes.
It's a resource
Yes.
and a text?
Correct.
It's a medical journal.
Have you
Yes.
authored any peer-reviewed publications in the field of forensic pathology?
Yes, I have.
Can you tell us about some of those publications?
Let's see if I can here. Yeah, I've written.
She's like, I'm busy, I've
chapters
forgotten.
in textbooks about medical legal death investigation and forensic pathology. I've published articles involving alcohol metabolism, some drugs, cocaine. Let's see. Alcohol metabolism in the heart, I mentioned. So I've published 22 papers, and I've written several chapters.
You already said that you're board certified, double board certified in anatomic and forensic pathology. Is that correct?
Yes.
Now that you've gone through your education, training, background, publications, teaching positions, and chairs that you've held, I want to ask you a really simple question. What does a forensic pathologist do?
Yeah. We are the last doctor that the dead person has, and we figure out what happened to the body to cause their death. And we sign the death certificate that says how the body came to die, and also indicates the circumstances under which the death occurred.
Are medical examiners also tasked with determining both manner and cause, not just one or the other?
Both, yes.
What is the manner of death, and how is it distinguished from the cause of death?
The cause of death is what happens to the body to cause it to stop functioning. And the manner of death refers to circumstances under which the death occurred. So there's hundreds of thousands of causes of death or why the body stops functioning.
only a few
But there's
manners.
only a few manners of death, which would be natural, accident, suicide, homicide, or undetermined.
Those five main categories of manner of death, is that the responsibility or one of the responsibilities of a forensic medical examiner to determine that the death fits into one of those five categories?
Correct.
What does it mean when the death is deemed undetermined?
Now, when the manner of death is undetermined, that means at the time the death certificate was signed, there was not enough information to put it into either accident, natural suicide, or homicide. So at the time the death certificate was signed, there was not enough information to put it into one of those other categories. It doesn't mean that if more investigation takes place, then you might be able to put it in one of those other categories.
If a manner of death is deemed at a particular time undetermined, at that time, it's because it lacks sufficient additional information. Is that correct?
Sustained.
What types of information does a medical examiner, forensic pathologist consider in making these determinations between natural accident, homicide, suicide, undetermined?
Well, first you have the findings from the examination of the body. So that's sort of a starting place to see what happened to the body. Then you need to also look at the scene investigation. You need to look at any police reports and witness statements, and also medical history of the deceased. And using those four sources of information, and using your training and experience, you can either say this is a natural death, This is a self-inflicted death, it's a suicide, it's an accidental death, it's a homicide, or if all that information doesn't allow you to put to a reasonable degree of medical certainty into any one of those categories, then you have to leave the manner undetermined. And if more information becomes available later, then you can change that death certificate.
What if no more information comes available later?
It just stays as
Then it stays as
undetermined.
undetermined,
There are
yeah.
cases where there's just not enough information to put it in one of those other categories.
Without getting into what they may be, did you reach any opinions and conclusions in connection with this case?
Yes.
What materials and information did you consider in reaching your opinions and conclusions in this particular case?
Yes. I have my list of materials I reviewed.
She's like, let me tell you everything I looked at, but I need my list.
I reviewed Mr. O'Keefe's autopsy report, the report of the examination of his brain, the toxicology report, and the entire medical examiner file. I studied 100 and some autopsy photos, including photographs of the brain, and then there were 70 other photographs at autopsy taken by a state trooper who was at the examination. I reviewed Mr. O'Keefe's medical records from Good Samaritan Medical Center and the EMS run sheet. I reviewed photographs of Mr. O'Keefe's clothes that were taken at the crime lab. I reviewed photographs of pieces of tail light, hard plastic, clear, black, red. I reviewed photographs of the outside of Karen Reed's SUV. I reviewed the Canton Police Department incident report on the death. I reviewed 100 and some photographs taken by Canton Police of the outside of the house at 34 Fairview Road in Canton. I reviewed some photographs taken by the real estate agent who was going to sell the house of the inside.
In total,
Okay.
putting them
That's
in
what you
categories,
reviewed.
did you review the forensic autopsy?
Yes.
Did you review all of the files associated with the medical examiner's office in this particular case related to the autopsy of John O'Keefe?
Yes.
Did you review the scene investigation through police reports and other things?
Yes.
Photographs as well?
Yes.
Did you review the police reports that were associated with the initial investigation in this case as well as follow-ups?
Yes.
Did you review witness statements and things of that sort?
Yes, if they were included in the police report.
That was my next question. Those witness statements would be included in the police reports that you otherwise reviewed, correct?
Yes.
What
if
about
they're in the
Mr.
police
O'Keefe's
report, yes.
medical history as much as you had of it?
Yes, I reviewed his medical history.
And what about hospital records?
His medical history was in the hospital records.
Understood. What method did you use or methodology did you use in forming the opinion that we'll get to in just a few minutes?
Well, in order to arrive at a conclusion of how somebody dies and what the cause of death is, we have to put all our facts out, and then we say, how could these facts have come to be? So it's called like a differential diagnosis. So like if you go to your doctor and you have a white blood cell count, then the doctor would say, well, how many ways do you get this white blood cell count? So that's a differential diagnosis. And then you go from that list and pare it down by getting more data till you come to one final diagnosis. So that's the process of determining how somebody dies and the circumstance around it.
Is it fair to say that you have a pretty significant background, training, and experience
Yes.
regarding coming to the conclusion of cause and manner of death?
Yes.
40 plus years.
And how many autopsies in total?
Well, myself, I've probably done over 3,000. And then I have observed and reviewed maybe 7,000 more.
So that's in total over 10,000 autopsies if you were to estimate over 40 years?
Probably.
She's like, yeah. Sounds about right. Ma'am, I have a question for you about coroner armpits. But we'll talk about it another time.
In addition to just
I have a
autopsies,
question.
how many death investigations, separate and apart from autopsies, have you been involved with?
Well, the autopsy usually has a corresponding death investigation with it.
Do you have experience in examining and identifying wounds, not necessarily the cause and manner of death, but wounds that are associated with someone on whom you're performing an autopsy or you're supervising an autopsy?
Yes, so looking at the injuries on the body and understanding what caused them is a huge part of forensic pathology.
Have you ever conducted or overseen any autopsies of individuals involved in vehicle-pedestrian collisions?
Yes.
How many times, if you had to estimate?
No, hundreds.
100 or hundreds?
Hundreds.
When was it that you first started training on the issue of wound pattern recognition that helps assist you with coming to your conclusions, whether it be auto pedestrian incidents or otherwise?
Yeah, well, understanding wound patterns and injuries is a big part of forensic pathology because we want to identify what caused a particular pattern. So understanding that whole complex bag of injuries begins when you start your forensic pathology training, which was when I started back in '81.
In addition to the cause of death, which might be
a massive part of the job.
Whatever, a gunshot, something. Does the pathologist also undertake an examination of the rest of the body that's not so obvious, other wounds, etc., that might tell a more defined story?
Yes, we look at the entire body, we look at the clothing, we look at the outside of the body, then we do the internal examination in order to understand not only why the body stopped functioning, which is the cause of death, but also things that could have contributed to it or helped to understand the circumstances around how that death occurred.
Right.
When you say the body, you mentioned the clothing. Why is the clothing important? Is that part of the body for a forensic medical examiner?
Yes, it is. You always have to look at the clothing because it has materials on it that may be important as to how injuries occurred. So it's every time you do an autopsy, you have to always make sure you have the clothing. Many times it would have been taken off at the hospital, but then I would always ask my staff, tell the police, we've got to get the clothes, have to look at the clothes.
What is a gross examination?
A gross examination is not actually like gross,
It's not
grotesque, but
vibes.
it means like without.
It's not vibes. It's like gross anatomy. It's not vibes. It's a term of art.
Without microscopes. It means
Right.
just looking with your naked eye.
Is it important to look at a body, a deceased person, when you're conducting an autopsy from head to toe for outside obvious wounds that you can see on the gross anatomy outside?
Oh, yes, and also to collect any trace evidence that may be present on the body.
Are forensic medical examiners trained to do that?
Oh, yes.
Are you trained to do that?
Absolutely.
In addition to a gross examination on the outside of the body, is it also important to look on the inside of the body?
Yes.
Are there wounds and injuries that might be hidden by the dermis, for instance, the skin, that might not
Yes.
be so obvious on a gross examination
Excuse
of the body?
me, Alan Jackson, we learned that the bones were on the inside of the body a few weeks ago. We did a testimony on it, but we did get there to the bones being on the inside a while back. But yes, I'm just being cheeky because yes, it's a lot for the jury. Yes, it is necessary because when you have a battle of the experts, you want to show that your expert is the most expertiest expert of all of the experts. And yes, apparently humans don't have an exoskeleton. Who knew?
Yes, you have to look inside the body.
And what's the mechanism of doing that?
Oh! I don't know if the jury needs to know this much. It's not pleasant how they look on the inside, but it's just layers. There's layers.
Excuse me.
There's layers.
We make surgical incisions in the body so we can examine the brain, the neck, all the organs in the chest, all the organs in the abdomen. And depending on the case, we may make incisions in the arms and legs to look for evidence of injuries.
What about x-rays? Are x-rays an important part of an examination in an autopsy?
Yes, they're usually done before the autopsy is started, and we look for changes in the bones or any foreign material that might be present in the body, like a bullet.
Dr. Laposata, have you ever exercised wound pattern recognition in your position as a forensic pathologist? Or do you do it every time?
Oh, all the time.
And yes, even though the court has ruled against Jackson, he's going to still lay the foundation. He is going to continue going with laying the foundation about how much experience she has. Also, if I was Jackson, I would run my direct examination all the way up to the end of the day. I'm going to ask every single fucking question I can, because I am not going to give Brennan the beginning to start cross-examination or to even get into my opinions. I would wait to get into opinions until the next day. Yeah, we're just going to keep running. Just all the way to the end of the day.
Have you ever taught any courses?
Every
or given
single
lectures
question.
on wound identification
Yep.
and wound pattern recognition?
Yes, it's part of understanding blunt force trauma, sharp force trauma, gunshot wounds. They all make injury patterns on the body that the pathologist can then relate to what caused that injury.
With regard to the case that's before us, what injuries did you observe with regard to Mr. O'Keefe's head specifically?
I observed that he had evidence of blunt force trauma to the back of his head.
Are those injuries consistent with a particular type or pattern of patterned injury?
Yes.
Describe that for us, please.
There in the back of his head, a little bit to the right-hand side, was a horizontal tearing of the scalp, and that's called a laceration. And surrounding that were linear scrapes that were vertical in orientation. So that is an injury pattern. And then you have to think, well, what could cause that injury pattern? And so then you go from there.
Did you also, in addition to looking at, by the way, how did you make that assessment about the injury? Was it photographs?
Yes.
Is that a normal way for forensic pathologists to make an assessment? Is that an acceptable methodology to make an assessment of a wound pattern by the use of anatomical photographs?
Oh, absolutely.
Have you done it before?
Oh, hundreds of times.
What is a coup contra coup injury?
Now, it's a very interesting, peculiar injury to the head. When you have a blow to the head, the blow can either be the stationary head and there's a blow to it, or you can have the head that's moving and gets the blow. So looking at a pattern of coup contra coup helps the forensic pathologist differentiate that. A coup contra coup injury examines the coup, which is where the impact occurred, and then we look at what's 180 degrees opposite that impact, and that's called the contra coup, or like opposite the coup. And that injury pattern helps us determine whether a person was just having a fixed head and somebody hit it, or whether the head was just standing and went down to the ground. The coup contra coup of a falling or being pushed backward has injury patterns where the impact occurred, but then there's also injury patterns 180 degrees opposite from that. Forward. And that happens because the brain is floating in cerebral spinal fluid, and when the head comes down, the brain is a little bit behind, so you get the bang on the back of the head, but then because the brain is floating, it hits the inside of the opposite side of the head. And so that makes the contra coup pattern. And that tells us that there's been a fall backwards and hitting the head.
Is that?
I just have to pause and ask to all of you that watched Dr. Wolfe Hungry Like the, not Dr. Wolfe the engineer, Dr. Wolfe the neurosurgeon, did she help you understand coup counter coup better, or were you like same? Because I think that the way she explained coup counter coup helps differentiate it from a hit to the head versus a fall. And I think she differentiated why it mattered more than a neurosurgeon, Dr. Wolfe, did. Yeah, there's 50 plus thousand of you in here going, that helped me understand it better. Right. She didn't just talk about the injury to the back of the head and then the corresponding brain injury to the front. She talked about why it's different from being struck versus a fall. And I think that was really helpful. That was explained, but I don't think as clearly explained from Dr. Wolfe. So I wanted to ask and see if you thought the same. Okay, let's continue on.
Consistent, a coup contra, just in general, a coup contra coup injury, consistent with a linear acceleration of the head by a fall, an unbroken fall straight back.
Correct. There's also some angular force in that as well.
Understood. In order to determine whether or not Mr. O'Keefe suffered from a coup contra coup injury, can that be done by a gross examination or does it have to be surgical?
We would look at, well, first we look at the outside, but then we have to look at
Inside.
injuries to the scalp, and we look at the skull, see where the skull fractures
And the
are.
brain.
And in particular, to look at the brain and see where the damage is to the brain. And there should, in a fall backwards, you have damage to the brain at the site of impact, but you also have damage to the brain 180 degrees opposite from that. And that tells you it's a fall backwards.
In the case before us, dealing with John O'Keefe, were you able to look at the scalp and the injuries associated with the scalp from a gross perspective?
Yes.
Were you also able to look at the skull and possible fractures that Mr. O'Keefe suffered on his skull?
Yes.
And what about the brain? Did you have evidence of a dissection such that you could see the brain and determine whether or not there was a coup contra coup injury associated with the brain?
Yes, I had a full examination of the brain available.
Were Mr. O'Keefe's head injuries consistent with a coup contra coup injury?
Yes.
Could you describe that, specifically his head injuries, to the jurors, please?
Well, as we say, he has a pattern head injury on the back of his scalp, where there is a tearing of the scalp, and then vertically above that, there is some little areas of scraping to the skin. So that tells me that Mr. O'Keefe went backwards onto something that had a little ridge, but it also had some irregularity to it to cause the different scrapes before you get to the tearing of the scalp. Then when we look at the skull, he had a massive skull fractures that originated, started in the back of his head. They came around to the front. They went under the base of his brain, under the skull, under the base of the brain, and it came into the front of the skull at the orbital plates and fractured that, and that caused some bleeding in his upper eyelids. When the brain was examined inside the brain, I could see that the brain had become swollen and parts of it had herniated or moved down the area where the spinal cord is, and that's called brainstem herniation, and that is why the brain stops functioning and why your body stops functioning when you have a severe head injury.
You indicated that the wound pattern suggested a ridge or ledged surface.
Yes.
Could you explain that in more detail, please?
Yes. So if I were looking at it, I would see the break in the scalp. Then I would see several sort of irregularly placed scrapes of the skin that kind of look like pencil marks. And so that means that something with granularity he hit first, then it moved up a little, broke the scalp, and then moved on a little bit above that.
Would you expect to see that if Mr. O'Keefe had fallen backward onto a perfectly flat surface?
No, it has to be a surface that has some small ridges in it to make those little vertical patterns.
Dr. Laposata, what is ecchymosis?
Ecchymosis is a medical term for bruise.
Did you see any ecchymosis on Mr. O'Keefe that he suffered as a result of the coup contra coup injury to the back of his head?
He had a bruise on his brain at the back of the brain and at the front of the brain.
what would the outer, let me rephrase that.
Yeah.
What would you see around his eyes regarding ecchymosis?
Yes, when you have, when the brain slaps forcefully against the base of the skull, the delicate bones above the eye break, and that's again the coup contra coup, where the brain slaps forward. And when those delicate bones are broken, there's bleeding, and that bleeding then goes right down into the upper eyelids.
Right.
So it kind of looks like you have black eyes, but there's not been any
Injury to the
punch to the face. It's
Right.
only come from the skull fracture.
Right.
That's sometimes called raccoon eyes, because you look like a little raccoon.
Right, raccoon eyes.
Did you
from the
see
brain injury?
any skin injury to either one of Mr. O'Keefe's upper eyelids?
Yes, he had a small kind of slit-like defect horizontal on his right upper eyelid.
Would the ecchymosis on its own produce that type of injury, that laceration over his right eye?
No, the blood seeping down into his upper eyelids was from the skull fractures.
Was the laceration above his eyelid on the right side a separate injury altogether?
Yes, it was.
Based on your training experience, do you have an opinion as to whether or not what that eyelid laceration might be consistent with?
Some application of force which broke the skin.
Could that be from an object?
Possible.
Could it be from a fist?
Possible.
Sustain us to the floor, Mr. Jackson.
Give me some possibilities of what might cause that laceration above his right eyelid.
So it's not possibilities.
Give me, in your opinion, what you believe
She
could have
can't
caused
say.
or produced the injury
She said force.
to the upper right eyelid.
So I'm going to see your sidebar here.
All right. They're approaching sidebar, and we're going to zoom past the sidebar.
You just made.
All right. And the reason we zoom past the sidebar, well, leading was one of the things, but we zoom past the sidebar, and we will get back into the direct examination of Dr. Laposata.
May I inquire?
Yes.
Thank you.
Okay.
Dr. Laposata, you just mentioned that the laceration above the right eyelid was consistent with the application of force, correct?
Correct.
You said it could come from some object, is that right?
Correct. It was fairly small. Could be, it's some sort of object.
Is it also consistent with a fist?
Sure, a fist is an object.
Okay. Your Honor, at this point, I hate to do this again. May we approach? This is probably a good time. We talked about it at the sidebar.
You just approached.
Can you do anything to fill up the jury's time for the next 10 minutes, and then we can do this?
Not without what we discussed at sidebar.
You just, okay. He gets to try his case his way.
Okay. A minute, okay? Both of you, come on up quickly.
Oh boy. So some force to the right eyelid. Again, force
Told you
is
we're still on track.
come up to sidebar quickly and then lets the jury go for the day. Okay.
We will start. I'm going to have you show up a half hour later than we normally do, because I expect to have 10 minutes with the lawyers, but we see sometimes with 10 minutes naturally in the course of any case we turn into. So I don't want you to be waiting as much as you've waited today. So if you take a half an hour more to get in here, whatever time we normally meet, the court officers will tell you. We'll see you tomorrow morning. Tomorrow will be a full day, and we will make every effort that it's filled with as much time here in court for you without sidebar conferences, without delays for us to have hearings. So tomorrow, plan on a full day. Please do not discuss this case with anyone. Don't do any independent research or investigation.
Are you half-daying Thursday then?
If you happen to see, hear, or read anything about the case, please disregard it and let us know. Be careful again with your social media use, and we'll see you tomorrow. So Dr. Laposata,
Yes.
you can step right out, just follow the jury, and we'll see you tomorrow morning.
Okay, I imagine the lawyers go back on the record. She asked the jurors if they were available to do a full day on Thursday because they had originally planned on doing a half day. Oh, wait, today's only Monday. So, well, I guess we'll see where we're at. Tomorrow will be a full day. Emily, what day is it? I don't even fucking know today. We've been here 100 years today. All right, I'm going to zoom. I imagine they're going to go back on the record to deal with whatever they were trying to do today. So this witness for the defense, and then Dr. Rentschler, and then we will see who the rebuttal witnesses are. Let's continue on. The jury is out. Tomorrow's a full day, but the jury's coming in 30 minutes later. The court's probably going to be on the record with the lawyers in the morning. Let's see what they're putting on the record now that the jury is out.
All right, so can you argue the Commonwealth's motion that I received this morning regarding Dr. Rentschler? Can we just do that now? Okay.
Right, when would he have?
No, that's fine. So we'll do that first thing at 9 o'clock tomorrow morning. The basis of the Commonwealth's, I've read the motion. I think the motion is clear. I'll hear you both tomorrow on it. All right. And you'll take care of the photographs, whatever photographs in her report you intend to put in.
The court hasn't made an order yet, but it seemed like the court was leaning toward not allowing any text on the photographs.
So that was just at a quick review. I had not I just read the content, the text part for the arguments for today, the arguments that were brought up today. I wasn't anticipating everything that we heard today on this, so it took a while. I did not get to look at specifically those. But to the extent that it's hearsay, whether it considers anything about dogs, clearly the dog, things that have been excluded have to come out of the photographs. All right.
The other photos deal with gastric mucosa.
I think those have been shown, and I know there was.
I can't hear Jackson either. He's not at a microphone. I have heard the court, but I am having a very hard time hearing Jackson.
Newski spots one is in evidence. The brain photographs are not coming in. The brain photographs that are different than what's already, the brain photographs in her report.
Understood.
They're-
My biggest issue is the stomach lining is a bigger issue, and then some photographs dealing with evidence like the car that's probably already in, things of that nature.
So tell me what you think is more of an issue, more of what you want. So I don't think the photographs on pages 4 or 5 come in. They don't add anything, and they are extremely inflammatory.
I'm not looking to enter the, I'm not looking to get those from brain skull.
All right, the photos on page 6, I believe, are already in evidence. So this is,
That's a Lucas machine.
right, just a textbook photo of a Lucas machine.
Correct.
Is there an objection to that, Mr. Brennan?
No, thank you.
Okay. So do you want all of that in, or just the photograph that's got color to it?
I'd actually like all of it in. She will explain what effect it has on the pancreas and stomach lining, send it to the Reconstruction spots for lack of.
Okay.
They're talking about photos of the Lucas machine that you can use for CPR, Lucas, like the name, and how the Lucas machine can impact what the defense was saying were injury to the pancreas, injury to other areas of the body, and part of this doctor's determination. So the photos of the Lucas machine, and there was no objection from the Commonwealth. I think that helps to give the jury an idea of what they're talking about, because part of this doctor's explanation about the injuries to the victim, it sounds like, are going to come into talking about the Lucas machine vis-a-vis the cold. And we saw that in the cross-examination of Dr. Scorty Bello. So I'm not surprised that they're going to bring that in for so the jury can see that and then talk about the Wisniewski spots, not Wazowski, Wisniewski spots, and damage to the pancreas.
Page 14, I think these are all in evidence otherwise, but I would like this particular all in one spot.
Hold on 1 second. Okay, so one is in. Point number one, that was in evidence, and those two photographs. This is all for number one. What was?
These are all close-ups of the same photo that is already in evidence.
Okay.
The right sleeve. So I'd like to use this because it speaks to her evaluation of these particular.
All right. How does she know it's blood staining on the fabric around the puncture? I'm just curious.
The blood staining on fabric around the puncture?
Yes.
I'm assuming she's getting that from the lab. They tested it.
Okay. I don't recall testimony regarding. Doesn't mean it didn't happen. I just don't recall it. So I just need to know the source. All right.
Pull that out.
I have no objections to the photos. I do have an objection to the captions that go with the photos.
Okay. 13A and 13B?
Yes.
Yep. So 13B's out because of the dog bite. Let me see.
They are going through the photos in the report.
So if we keep out the blood staining, Mr. Brennan, is there an objection? Oh, puncture. What's the objection for the Commonwealth on 13A?
The opinion outward tearing, the opinion blood staining.
I have no issue with blood staining coming out. Outward tearing that is her opinion of what it looks like.
Okay, so we're going to have to see if she's qualified to do that, to testify to that. All right. What's the next page?
Page 53 in the report.
What page?
I don't have the page number, Judge. Hold it up.
Page 5.
Page 5. It shows the cross-section of the brainstem.
Yeah, that's what I was saying. I didn't see how that was coming in.
I certainly don't want the one in that is installed. Highly graphic. This is no more graphic than the second one.
I disagree, but why does she have to use this photograph?
In furtherance of her determination of the coup injury, it supports that. I didn't put it in during that conversation.
Okay. There's no contention that coup contra coup is the cause of the brain injury, correct?
Correct.
Yes, that is the contention. I don't think there's any controversy. That's what the.
I thought that's what Dr. Wolfe testified to, no?
Consistent. I don't think there's any disagreement.
Right.
Right. They're all, you can tell how tired everyone is in the courtroom when they're all saying the exact same thing and they're all looking at each other going, right. The judge says there's no contention of coup contra coup injury, meaning there's no disagreement. And Jackson says, right, no, that's what we are contending. There is a contention that happened. We all agree that there's coup contra coup. So we have words being used the same but different. There's no disagreement. Everyone agrees. Everyone just agrees. They all agree. Oh boy. Julie asked, is this normal in trials going page by page, line by line? Yes. When there are disagreements over things, it is. That's the only way you can do it without going through it at sidebar.
So I don't know why we need this photograph.
Because this shows, at least for her, this shows a bleeding of the brainstem, which talks about whether or not he's immediately incapacitated or not immediately incapacitated.
Okay.
Issue.
No, I understand that's an issue. Okay.
It is an issue.
Yeah. Okay. What else, Mr. Jackson?
I think you've seen this, Your Honor, and I believe it was figure 5. So the Wisniewski spots.
Yeah, I think that's already in evidence, isn't it?
It is, but
It was used as an exhibit.
Mr. Leslie's saying it's only a chalk at this point, is that right?
I recall it was up, and I usually don't put up chalks, but okay.
I remember it being up. I don't remember if it's in evidence. That would require everyone flipping through their notes. And generally the court clerk would at this point tell the court, but I don't see the clerk sitting there, would tell the court if it's in evidence or not. But
Excuse me? Mr. Leslie. Can you say it again?
so court
There's
staff
only one person who can
is
talk
looking.
at a time. I'm told it's Exhibit 164.
Yeah, and the court
Yes, Your Honor,
staff.
my understanding
leaned in.
is it's marked as an exhibit only. It was used as a chalk, but not in evidence.
Okay, so if it's marked as an exhibit, it means it's in evidence.
Sorry, marked for identification.
I'm told I think it's an exhibit. We can find out. If it's an exhibit, everybody's fine with it. It's in. 164, I think.
The court's like, well, if it's an exhibit, it's too fucking late. It's in. It's in. It's in. So, again, that's fair.
We'll know.
The defense is talking about a photo they want in evidence, and the court is saying, I think it's already in evidence, so it's already in evidence.
Okay.
Fair.
What are those? All right, so we'll have to see what's in and what's not. I'm just trying to make the best use of the time here.
The next is figure 9. Just attendant to these two photographs are attendant to the Lucas machine.
So you're saying 9 in evidence or 9 on the form? 9A and B.
9A and B.
Is there an objection to the use, Mr. Brennan? Going to the Lucas compression device. There's one on someone who's not John
Whoa.
O'Keefe, and then this is on Mr. O'Keefe.
No objection.
Okay, so those will come in.
That's it.
Okay.
Okay.
All right. How much longer, and I'm not curbing you in any way, how much longer do you think? It seems like after the very lengthy qualifications, we're now moving along quicker with Dr. Laposata.
After the very lengthy qualifications, obviously the lengthy qualifications were needed. It is a battle of the experts. What the fuck else are they supposed to battle over other than their qualifications? Okay. If you didn't need to voir dire the witness, it wouldn't have taken so long.
Posada.
I would guess I probably am going to finish under an hour.
Okay. Any idea, Mr. Brennan?
I guess it'll probably be about a half hour.
Okay. So we should finish with Dr. Laposata's testimony either by the morning break or shortly thereafter. So we'll discuss Dr. Rentschler's testimony, the objections to it. Why don't you just tell me briefly, Mr. Brennan, what the objections are?
There are a number of slides that
I thought we weren't talking about this. Oh, my eye is twitching. I thought we weren't talking about this, and now we're talking about it? Okay. I guess we're talking about it. I thought we... Sure. All right. Okay. Into talking about Dr. Rentschler and objections from the Commonwealth. Sure.
To frame what the contested issues are in the case to proper opinions and assumes facts, not evidence. And
I can't hear anyone today. I've got the mics gained up, or I've got the court gained up a bit. So we can also hear the court reporter a bit when I gain those up. I know in court, it sounds like they're also trying to gain them up so we can hear them, but that's where we're at. I had to back up because I wanted to hear what Brennan was saying his objections
there
were.
are a number of slides that attempt to frame what the contested issues are in the case to proper opinions and assumes facts, not evidence, and it properly summarizes the Commonwealth position. There are a number of slides that provide credibility determinations about Dr. Welcher, and there are a number of slides that summarize opinions by this expert. So the improper summaries, the credibility determinations, trying to frame issues for the jury, none of that should be admissible as part of the PowerPoint. So we've articulated each slide and what our objections are to each slide that we have any objections to. There's quite a few.
All right, so I'll look through that tonight, but the same restrictions will be, you don't criticize the person, it's the data, what you saw, what you didn't see. So if it's different than that in the slides, it's going to have to come out.
Understood. I'll take a close look at it. I just haven't had a chance.
Yeah, no, I understand. I haven't read it either.
We're done.
Okay.
4 documents. These are.
Jackson said, I haven't had a chance to take a look at it. I'll take a look at it. And she said, right, I haven't either. Why? Because Brennan apparently filed it this morning and no one has had the opportunity to go over it yet.
Documents that are attended to Dr. Laposata's opinion and conclusions concerning the dog bites.
Okay, so.
Right. I'd like to have those identified for the record.
Yes. So we'll make that part of the record. I need a clean copy of Dr. Laposata's report and her resume for the same purpose.
And the resume.
Yes.
You also need to admit into evidence the photo of the back of the hoodie because I don't think y'all did that on the record.
I'll have those 2 by now.
Okay.
Just finally, the redacted version of the 34 Fairview post is not marked. Could I have that marked as an exhibit now?
Okay. There was no objection, Mr. Brennan?
This was never marked as an exhibit. That's all.
Why don't we do that right now?
Thank you.
Okay.
Exhibit 224.
That's the photo
So
of
I
the
would like
stomach
us to
lining.
be as efficient for these jurors as possible tomorrow. I'm not suggesting that today was a waste of time. Everything we did was important, but it's very difficult for the jurors to spend so much time back there. It seems that they're just about ready to get this case, and everything that we hear now is very important. So
it seems like the juries are over it. It seems like the juries are. I gotta
ready to
back
get
up.
this case there.
The court can tell that the jury is just done. Interesting. I had to back up. I wanted to hear it again.
Exhibit 224.
So I would like us to be as efficient for these jurors as possible tomorrow. I'm not suggesting that today was a waste of time. Everything we did was important, but it's very difficult for the jurors to spend so much time back there. It seems that they're just about ready to get this case, and everything that we hear now is very important. So I don't think anybody wants the jurors to tune out at this point. So let's try and keep things moving along. Mr. Jackson, how long do you expect to be with Dr. Rentschler?
Hour and a half. 2 hours.
Really? Okay. 2 hours?
I'm being corrected. 3 hours.
Jackson said I'm being corrected. 3 hours?
4. She has a better pace than I do. I don't watch my watch when I'm directing, but maybe it's going to be a whole thing. I mean, between us and cross-examination.
All right. So I told you all the other day I thought I might be in a position to regret giving you last Thursday off, and that's where we're at. So let's be as efficient as we can possibly be.
I promise you we are. It's a murder trial.
I don't regret having last Thursday off. I'm sure the jury's tired. I'm sure they are. But you know what? They were qualified for 8 weeks. We are getting up to the 8-week point. The jurors are annoyed. Fine. If the jurors are annoyed, the jurors are annoyed. But things take time. So I'm sure she regrets it. Whatever. It was going to be too hot in court to have court anyway, and you said it was up to the court staff. So if the jury gets the case on Monday instead of Friday, then that's what it is.
I understand. All right.
I have one more item when Your Honor is ready.
Okay. So, Mr. Jackson, do you expect that Dr. Rentschler will be the last witness that you call?
I heard Jackson say 3 to 4 hours. Okay, what? I mean, Jackson said he needed the time he needed. That's fine. I mean, it is what it is. I don't think I missed him say anything.
I think anybody wants the jurors to tune out at this point.
Right.
So let's try and keep things moving along. Mr. Jackson, how long do you expect to be with Dr. Rentschler?
Hour and a half? 2 hours? I'm being corrected. 3 hours. 4? She has a better pace than I do. I don't watch my watch when I'm directing, but maybe it's going to be a whole thing. I mean, between us and cross-examination.
All right.
Right.
So I told you all the other day I thought I might be in a position to regret giving you last Thursday off, and that's where we're at. So let's be as efficient as we can possibly be.
I promise you we are. It's a murder trial, Judge.
I understand.
Right. He said, I promise we are. It's a murder trial, Judge. Right.
One more item when Your Honor is ready.
Okay. So, Mr. Jackson, do you expect that Dr. Rentschler will be the last witness that you call?
Surprised me at all.
Okay. On rebuttal, any idea how long that will be, Mr. Brennan?
I'd like to keep it to 2 hours.
Okay. All right, that would be for everything, including Dr. Rentschler?
Sorry.
Really?
Dr. Welcher?
Dr. Welcher, and then the DNA, all those 2 witnesses.
Wait, really? You think your rebuttal is going to be 2 hours? Is that what you just said? That's fast.
Mr. Brennan?
That's really fast for a rebuttal. That surprises me a lot.
Okay. So, Mr. Jackson, do you expect that Dr. Rentschler will be the
I had to
last
back all the
witness
way
that
up.
you call?
That's my expectation.
Okay. On rebuttal, any idea how long that will be, Mr. Brennan?
I'd like to keep it to 2 hours.
Okay. All right, that would be for everything, including Dr.
Sorry.
Dr. Welcher?
Dr. Welcher, and then the DNA, all those 2 witnesses. I think it should be done in less than an hour.
All right, so will Dr. Welcher be called after the DNA people?
Trying to schedule that. I expect to call him last, but it all depends on when we can get the DNA people. And Dr. Welcher will be here tomorrow or tonight, so he'll be here. So whoever's, if they're available, I'd like to get the DNA people in first. But we haven't had confirmation on the flight.
All right, because I told Mr. Lessie that he could excuse himself from this testimony if there were other witnesses first, so that he can prepare once he gets the discovery from Dr. Welcher.
Thank you, Your Honor. Could we understand from the Commonwealth the names of the rebuttal witnesses we're talking about?
They were in the motion, right?
Well, we heard some different things at Cyclone. If something happened with Dr. Laposata, they were going to be different. We heard that at Cyclone.
Oh, okay, so the motion that I allowed was Ms. Kuhn. I believe Dr. Gillespie's name was in there.
Hartnett.
And Ms. Hartnett. Okay.
So that's
No
the extent
Crosby.
that the scope of Dr. Welcher or the scope of the rebuttal witnesses for the Commonwealth.
Yes, I allowed the motion. Mr. Brennan says he's not calling Dr. Gillespie. Mr. Gillespie, right?
Crosby.
Okay.
And nor Dr. Crosby. I understand.
Or Dr. Crosby.
Right.
Right.
That's what I think there's,
Sorry, I know.
well, it's important to know.
You're not calling their dog expert or your own, correct?
Not calling Dr. Crosby.
Okay.
The other item, Your Honor, we want to alert you to, we will come tomorrow.
After all that fighting, no Crosby.
With a suggestion with regard to the curative instruction that was given to the court today.
And after all of that, we're circling back to the curative instruction that the court gave today. I said at one point, I will not be surprised. In fact, I expect that the defense will circle back to this. And here we are with the defense circling back. Am I shocked? Nope. Not at all. Don't worry, chat. When we get to summary of today, we will talk about Crosby and all the rest of it. I want to hear what Alessi has to say. I'm going to try to gain the microphones up a little bit.
With regard to the curative instructions given.
That's worse.
We're going to come tomorrow with what has to be heard on that.
God, it's so fucking hard to hear in there today. Alessi said, we're going to do something, file something, and we want to be heard on this tomorrow.
With regard to the curative instruction that was given to the court today, we're going to come tomorrow with what has to be heard on that. So we're going to come in with that. What happened, what was discussed before, I'm not so sure.
You asked me to change it, was my recollection, Mr. Alessi.
The way you said you were changing it and the way it came in were not the same, though.
We looked at it at lunch, Your Honor, and appreciate the opportunity to confer with you on it. I don't want to keep the staff later today.
And I don't want to keep the jury waiting, so file something with me and I'll take a look at it. All right. All right, so that's it. We expect to be ready to go when the jury's here tomorrow morning, probably no later than 9:15, 9:20, right?
Yes.
Okay, and we'll use a full day, as much of it as we can.
Yes.
Yes?
Yes, Your Honor.
Okay. 15, 9:20, right?
When did you say you think you'll be done tomorrow morning?
I don't want to keep the staff later today.
And I don't want to keep the jury waiting, so file something with me and I'll take a look at it. All right. All right, so that's it. We expect to be ready to go when the jury's here tomorrow morning, probably no later than 9:15, 9:20, right?
Yes.
Okay, and we'll use a full day, as much of it as we can.
Yes.
Yes?
Yes, Your Honor.
Okay, all right, thank you.
Okay.
All rise to the court, please.
Well, today was a lot. It's a retrial. It's a retrial. It's not supposed to be so wild. First, for all of you asking what a full day is, 9 to 4 roughly. Which is often prescribed by many things beyond the court. I'm going to try to do a summary of today and then answer all of your questions. I can see that there are many, many, many of them. We've learned quite a lot of information this afternoon, so we're going to work backwards. After the jury was released at the end of the day, they went back on the record to deal with a number of matters, and this is not uncommon, especially as we are getting very close to the end of the case. The defense said that they are going to finish with Dr. Laposata, who is on the stand now, and then they are going to call Dr. Rentschler, and the defense expects to be done after those two witnesses. The Commonwealth said they think it'll take about 2, maybe 3 hours for all of their rebuttal witnesses. They are not calling Dr. Crosby their dog bite person. They are calling the DNA witnesses, which is the witness that swabbed the DNA from John O'Keefe's shirt, and then the expert that tested the DNA. That's like 15 minutes of testimony, 20 minutes of testimony. And then Dr. Rentschler will be, I think, their last witness in the rebuttal. Then we're going to get the jury. Then it's going to be at least a portion of a day where the jury is released for the attorneys to talk about jury instructions. I wonder if that's what they're going to do Thursday afternoon, because we had heard from the judge earlier on. She asked the jury if they would be able to work a full day Thursday, even though she had told them it might be a half day. I suspect with where we're at on scheduling at the end of today, Monday, that's probably on track to do the last arguments on the jury instructions Thursday afternoon when the jury's gone, and then do closing arguments all day Friday, get the jury the case on Friday. That seems to be kind of on track. And then the jury will get that half day, if not a full day, on Thursday so they can do jury instructions. They still need to have a full jury instruction conference. There's a lot of work left to be done in this case as we are speeding to the end of the defense's case in chief and the prosecution's swift rebuttal. I'm really surprised when they said it might take 2, maybe 3 hours at the most. I am stunned that that's how fast they expect it will go. But there might not be much left for Dr. Rentschler to say. That will be the longest witness. I'm very surprised they're not calling Dr. Crosby after all of the fuss and all of the motions and all of the fighting and all of the everything over the dog bite expert from the Commonwealth who took the molds of the this and the that, and then they're not calling him. What? Okay. Fine. But also, the defense is almost done. Which means no Higgins, no Proctor, nobody named Albert. And it seems that the defense is going to lean into our experts are telling you this. And what hasn't the Commonwealth showed you? And of course, at the very end of the day, we heard from Mr. Alessi saying, Your Honor, excuse me? That instruction that you gave to the jury, that's not what we had talked about. So we're going to need to revisit that. And Alessi said he was going to file something at the end of today, and they're going to talk about that in the morning. The jury is coming in a half hour later tomorrow morning, which means they are going to do their motions on the record in the morning. So I will be here as close to time as humanly possible because I'm very curious. Will we have Zoom room tomorrow? No. Do we have tons of shit to talk about? Yes. Will I have more time to sleep tonight because I won't be dealing with a delayed flight and all the rest of it? Yes, it'll be much easier. We'll actually get some sleep. It'll be lovely. But today has been another fairly unexpected day in court. I very much appreciate the defense expert that's on the stand. She is just starting to get into her opinions. I'm not surprised that they left that for tomorrow. So the main opinions from the defense expert we are going to get into tomorrow. Remember, in opening, the defense said there is no hypothermia here. So with the length of time that the defense spent on the background training experience of their expert, it's because their expert is contradicting a witness that I think the jury will like and other witnesses. And it's important to show the jury why you should trust one expert over the other. So at the end of the day, when the court's like, with the extended amount of time we spent on the background, it's like, yeah, yes, the extended amount of time spent on the background. It's not just puffery. It's needed when you are going to be contradicting another witness. And the defense should have the time to do that. And I am not surprised Mr. Alessi is going to want to get back to the hotel, sit down, rewind, and watch that entire conference with the court and see what the court said and then what the court read in. Yes, they have the transcripts, but they also have the YouTubes. And the YouTubes are going to be much faster than waiting for the transcripts at the end of the day. I'm sure everyone in court is tired. And as you get to the end of the case, there is so much more work that needs to be done. It does not stop. The attorneys are working all over the weekends, and you can see the wear in court. You can see that everyone is a bit tired and ready to get this case to the jury. And it sounds like the jury is also tired based on the court's comments today. But these are important witnesses. But also, I wonder how people are going to read the court saying, well, this jury's ready to get the case. Is the jury like, okay, we saw the videos. This is what we think. Or is the jury like, fine, what are we doing? What are we doing? What are we doing? What are we doing? And I have to wonder if the jury is just exhausted. And we've had some very protracted cross-examinations. So when you have these long cross-examinations that seemingly go around and around and around, I'm not surprised the jury's fatigued. We've had one or two of those from Alessi, and we've had a number of those from Brennan, where it's just like, we're just stuck in a loop. Move on. Claws, paws, teeth. Okay, Brennan, move on. And so we've had some of those protracted cross-examinations. I think tomorrow we will also see the defense asking again about their expert, even though the court ruled today. I think we'll see the defense asking again because we've heard so much more of the background. I don't think the court's going to be inclined to change their mind, but you never know what's going to happen on cross-examination, and you never know what questions Brennan is going to ask. However, you also have quite a lot of information already in from Dr. Russell. I don't know if they need to get it in more because this coroner is going to testify, it seems, about cause and manner of death, and then about consistency with the vehicle collision. And that is going to be what it is. So we'll see Alessi's motion. We will hear more about the slides that the Commonwealth has issue with from Dr. Rentschler and narrowing down those slides. Dr. Rentschler is still going to testify. The scope of Rentschler's testimony is not what the Commonwealth is arguing over. It was the wording of some of the slides. So that will get shifted. It is what it is. The defense said that they would probably be, 4 to 5 days, or no, more than that, like 6 to 8 days. So the defense has actually gone faster than they estimated for their case in chief. And as much as the court wants to say, can we move it along? The defense can say no. I mean, the court's annoyed. The court's not going to be unannoyed. That's not going to change. But the court gave the jury an 8-week estimate. The Commonwealth said that they were going to be about 32 days. They really were about 32 days. The defense said about a week and a half, and they've moved within that and effectively within that. So I understand the court's looking at the jury and is like, we need to get moving, but okay. It is what it is. If they're over a few days, they're over a few days. They have not lost a single juror. They have 6 alternates. If somebody gets to the eighth week and is like, and now I can't be here, you've got plenty of alternates. It's fine. And it seems that they're almost done. Fine. So what is left to be done? We've got a witness and a half left for the defense. We have 3 witnesses that seemingly will be pretty quick for the Commonwealth. There needs to be a pretty thorough jury instruction conference, closing arguments, and then it goes to the jury. So now is the time to make sure you have the Law Nerd app, because trials don't slow down as we get to the end. They speed up exponentially. There's probably a calculation that we went over this morning that could explain it. I don't remember any of the physics we did this morning because that feels like it was 150 years ago. We saw Brennan apologize today, which is wild. Like, straight up, I made a mistake. You fucking did. But I think the admonishment to the jury was lacking in what the court said she was going to tell the jury. And I think that is going to come back up tomorrow. Also, the court never admitted the other photos into evidence on the record that we saw. Could it have been done at sidebar? Yes, we just haven't seen it. And a lot of you asked, can the defense bring that up? Yes, the defense can bring it up and say, there's no damage to the back of this hoodie. They can show the photos. They can bring up the hoodie. They can say, you can ask questions all day long about this, but there's no damage here. This is from the lab. But the court's admonishment was not as strong as was indicated. And I think it's fair for the defense to bring that back up. I'm not surprised that the court didn't rule it a mistrial. I'm surprised, honestly, that Brennan was like, that was a mistake. It was the first time I think we've seen him not fight over it and admit that that was a mistake, and then basically say that he did his work hastily. Absolutely wild wild day, but I think a stronger admonition is completely appropriate. I'm not, again, surprised that there wasn't a mistrial. I think it can be cured by telling the jury that that's not what it's from. And then the jury will make the negative inference on the attorney that was asking that line of questions generally, and not the witness, because the witness is like, I don't know what those are from. And it was noticeable. If any of you are on replay crew or go back, you can see the live chat when those questions were going on. And what I saw in the live chat was, we've been through 2 trials and no one's ever mentioned damage to the back of John O'Keefe's hoodie. Well, you know why? Because there isn't damage to the back of John O'Keefe's hoodie, except for the damage done in scientific testing. And you don't bring that up because it's done in scientific testing. And anything that was tested didn't come up. So I think the prosecution is going to be real unhappy with the court bringing it back up again tomorrow, because it points out again to the jury what an issue it is. But I think that's appropriate. It should be pointed out to them. And the court said she was going to tell them to disregard it. She did not tell them to disregard that line of questioning. She did not say on the record she was striking it from the record. She did not say they were to ignore it and not consider it, and that it is known that that was from the scientific services or the crime lab. Known. And I hope we will see the court say it is known that this came from scientific services and the crime lab. Because it goes beyond just, that's not what you think it is. So we need to see, we need to see what's going to happen tomorrow. And having to do it again is just going to highlight it to the jury again. And I'm not surprised that the judge is saying the jury's fatigued. The jury's been fatigued for a couple of weeks now. But then again, I can see it. I feel fatigued. I don't know how you feel. Let me know in the chat. As we get to the end of this case, it is exhausting for everyone involved. 8 weeks of trial is not short. We're just watching. We're not involved. And it is the curveballs have been wild. And it's frustrating. And I see it. Those of you that watch the case briefs primarily are fatigued with this case. And I see you in the case brief saying, I can only follow this. I cannot follow this day to day. I'm exhausted. And I get it. 8 weeks is a long time, but buckle up, because once we get into Koberger, it's going to be a lot longer. It's going to be a lot longer, and it's going to feel like a lot more. So we've got a lot of trials the rest of this year, but we're not there yet. Are we going to see this jury get this case by the end of this week? We're now in the countdown, well, literally the final countdown, and woo, we will see. We will see. Let's get to your questions. It's what in the world is happening? All right, let's get to questions, because trials are dynamic, and retrials are supposed to be kind of straightforward, right? Where you're just like, oh, this, oh, that. No, that's not what has happened here just at all. Here's what has happened just today. That was just way louder than anticipated. It's because the sound gain is on. Apologies, chat. That is what's been going on today. Marielle, I'm sure Nightbot is going to grab that because there's a lot of caps, but Marielle said, why did the crime tech make those cuts? They took samplings to test the hoodie at different points in time. So that is why. Lisa said, what is the name of the bakery in Manhattan Beach? Becker's Bakery. Becker's, like the surfboard, but the bakery. So yes, we got into Q&A today with the Audacity. Today was just so much stuff. So much stuff. Jelly is my jam said, In a mistrial, why isn't a new judge assigned for the second trial? Mostly judicial resources, but also because they presided over the first trial. So they're going to preside over the second trial. You also don't want people trying to gamify the system in any way. So having the same judge is preferred, and it is the norm in most places. Starting over with a new judge at the beginning. Do you see how many times in this case attorneys have said, Your Honor, this time we argued this. This was the ruling from last time. There is a lot of crossover, and switching judges slows things down substantially. And in some cases, there's a pretty short window between trials, and that's difficult too. A lot of you asked I think the attorneys are annoyed. Yeah, I think the attorneys are tired and annoyed. Hello Awesome said, EDB, are there usually this many motions during a trial? Yes. This is for an 8-week trial. It's been fairly restrained. They got a lot, but it's also a retrial. They got a lot handled in the motions in limine, but yes, motions come up during trial. Absolutely, they do. Absolutely. Nisha's An Extraordinary Machine said, are the lawyers likely to be as frustrated with the judge as we are? Yes, the lawyers are assuredly frustrated. You can tell that the attorneys are frustrated. So Brennan less so, but yes, you can see it. RM678 said, would the instruction given even be considered sufficient if challenged on appeal? Seemed way too general, nonchalant. It is fully within the court's discretion. It is very difficult for the appellate courts to find that things are an abuse of discretion. So do I think it would create an opinion or a problem on appeal, like it wasn't sufficiently cured? Without looking at case law specifically on point, the jury was told where it came from. I think they also need to admit the items of evidence, but they were shown while they were told, and I think they need to see the items of evidence. But on appeal, I think that would fall within judicial discretion unless there was a case law specifically on point. So it just really depends. SS said, if this witness is not qualified as dog bite expert, who would be? Dr. Russell, apparently, and the court said with Dr. Russell that it was the ER experience that was so persuasive. But this judge, this doctor had been an ME and saw hundreds, at least 100 autopsy involving animal bites. It's a lot of autopsies involving animal bites and dog bites. Okay. Vicky Thomas said, Emily, I hope your dad had a wonderful birthday. Thank you so much. It was a lovely birthday party. It was very fun to see my dad with his group of friends. It's hard when you get to the age where you start to see your parents' friend group shrinking. It's hard, but it was lovely to see everyone. It was a really nice time. So yes. Since trial one has been mentioned so much, do they tell the jury about the mistrial? Oh no, they don't tell them at all. Nope. And it's wild how much it's been mentioned. It's like the shit's all the way out of the horse on that. This shit's just all the way out of the horse. All the way out of the horse. Just all the way. All the way. Texas Doll said, can lawyers watch your stream and input? I mean, I don't know why they would want to or have time, but yes, they can. I know that people do, but yes, they can. We're just giving our thoughts on the internet. However, I'm not also researching the case law. I don't have all the information the lawyers do. I'm just looking at how the case unfolds before the jury. There's a lot more information that the lawyers have. Then again, it's easier to be on this side of the screen watching it unfold. When you're in court and you're in it, it is a whole different thing. Again, much easier to be a commentator than on the field. So let's see. Hook and Brooks said, Emily, we missed the code red for Brennan because I couldn't determine, and I still haven't determined what level of fuckery we're at with Brennan. I am undetermined with Brennan. I am going to think about it, but I am undetermined with Brennan. The defense is arguing that Brennan Brennan did that intentionally, left out the back of the hoodie intentionally. Brennan said, I made a mistake. This is an error. I think the jury should be instructed. So I don't know. I don't know what level of fuckery we're at with Brennan, because was this in the middle of trial advocacy? Was this a plan? Was it nefarious? Was it lazy? Was it incompetent? I don't know. I have to think about it. I've got more questions, but that's why I've got more questions. So we'll see. I also think that the curative instructions are going to be more damaging, truly. Because once the jury loses faith in what's being presented to them, it's real hard, I would think, for them to trust what the prosecutor is arguing. And the defense is going to get up and say, look at all the things that the prosecution hasn't shown you. I think he might have shot himself in the foot with that one. Whether it was mistaken or not, it's not the serve he thinks it is. And I also don't think it has the impact. The defense was arguing the impact was indicating that there might be some kind of road rash or what have you, or that somehow Dr. Wolfe didn't consider something. But it can also come back up with Dr. Rentschler because they're not done. So it will be interesting to see how we're done playing out. But there have been numerous times during this case where I've said, I don't necessarily trust what the lawyers are saying in court. I want to see it because Brennan doesn't always represent things the way that they are. And that happened in argument a number of times in this case. And we saw him come in and say, it was this way. Oh, no, it wasn't. So I have questions. Amanda said, what happens if they go over 8 weeks? New jury. No, not a new jury. This jury just gets annoyed and they're told they have to stay. And then if some jurors can't stay, then you excuse a few. But they've got quite a lot of alternates. So even if you lose a juror or two, there's still plenty of time. So yeah, there's still plenty of time. Let's see. Cheryl said, does she seem to forget that Brennan misled the jury and that was a whole thing? I have no idea why the instruction was read the way it was, but I think it's fair. Yeah, I think it's fair. So it's fair that the defense, I should finish that thought out loud. It's fair that the defense has brought it up again. I think it's fair. I don't think the defense is unduly banging their fist about that. I think that what was agreed or what the court said she was going to do and what she did was not the same. I think it is needed to be readdressed. My brain has stopped. So it's just quite interesting. Chad asked earlier, Chad in the chat asked earlier, did this jury know the Alberts sold 34 Fairview? Not specifically, but they've heard intimation of it. New owners. I looked at pictures from the realtor. So they've heard things that I think a reasonable person would connect the dots about. So there is enough information for them to determine that. Let's see. What else? Lots of you are feeling the same way about the expert's qualification. The court made a record about it. The court made a record about it. Heather said, can they talk dogs if Brennan opens the door? Sure. We'll have to see what happens. There is a lot to go on. So we have seen a very thorough background, training, and experience. Let's see. Becky said, EDB, I know and appreciate how balanced you have been about the judge. Look, there are some things I'm not going to harp on the judge about. When court ends at 4, I'm not assuming that it's on the judge. I'm assuming that there's a lot going on in court I don't know. Yeah, some of the rulings today I was frustrated with. And I can be frustrated with a judge. It happens all the time. And I think it happens in every case I cover. Maybe not with Judge K. There were times I was definitely frustrated with Judge A and Deputy Heard on hearsay. There were times I really wanted Judge A to just smack down Elaine, and it never happened. And I was annoyed. I was like, come on, bring the hammer. Where is it? Drop it. There are few times that I am completely just over it. The thing that will spin me out the fastest is inconsistency. There were times I disagree with Judge A's rulings. I appreciated the consistency. Judge A is consistent. I cannot stand judicial inconsistency. It spins me sideways. And there have been things that Judge Cannone has done that are completely inconsistent, and I do not like it at all. It's horribly frustrating. It's frustrating for the lawyers. It's frustrating to try to figure out how to try your case. At least if a judge is consistent, if you disagree, you know what they're going to do, even if you disagree with them on the law. When judges aren't consistent, it is incredibly difficult on all of those involved. But I was so frustrated with the ruling about the police procedure expert and with the ruling about Dr. Crosby, who's now not testifying. Just wild. It's like only medical doctors can talk about cause of injury. Fine. Well, except for that guy. The fuck? No, that's not what you said. Which is why we see Alessi saying, by the precedent set by this court, your previous rulings, and the defense is doing that more and more and more. Your previous rulings, you said this and this and this. It should be the same. And sometimes she says it's going to be the same and then backs off of it, which I also find frustrating. But when the judge started not really listening to the objections, the defense just started noting the grounds for the objections. And she didn't tell them to stop. And then she started sustaining more of the objections. I also don't like that. There are a lot of things about this judge that are not my favorite. A judge that can be talked out of their rulings, I didn't like this with Judge either. I do not like it when a judge can be talked out of their rulings. I think it's really easy to see some of the judge differences in Idaho because you have the same attorneys and two very different judges, and you see the different behavior of the attorneys, right? It's, I don't know, sports analogies. If you know a ref is going to look the other way on a thing or is going to particularly penalize a thing, you play to your audience. There are judges who will just go along with the attorney that talks last. And so then the attorneys are incentivized to just keep arguing. It's like if you back down to your kid because they've asked you for the 35th time, then you've set a precedent that they can just ask you more and eventually they'll wear you out. I hate it when judges do that. Your ruling is your ruling. And if there is nothing new, stick with your ruling. But judges who allow someone to talk them out of their ruling very much frustrate me. And the attorneys shift their behavior based on the judge because they're advocates. That's their job. And we saw it in Idaho with the way the attorneys interacted before Judge versus the way the attorneys interact before Judge H. It is a very different vibe. I do not like it when judges can be talked out of their rulings, and I don't like it when you have imbalance in the rulings. Consistency is key to me, even if I disagree with how they rule on the law. All you can ask for is consistency. So that's it. That's all you can ask for. So frustrating. Dr. Who asked, EDB, have you ever made your kids write down a motion for what they wanted and provide grounds for the argument? Generally not. I do ask for reasoning, though. I ask my kids why quite a lot. My kids ask me why quite a lot, but I ask my kids why quite a lot. I'm like, explain it to me. We also are talkers. You're so shocked. You're so shocked. So we talk it out. Let's see. Pharmacist Karopi, I hope I pronounced that properly, said, when can a judge get yeeted from a trial for bias? It is incredibly difficult. And even in the YSL case, the reason that the judge got reassigned was not because of bias. The judge got reassigned because the judge did not pass off the motion that they were supposed to pass off. If you look at that ruling and how that went down, you will see the other judges sidestepping the big issues and saying, but you aren't supposed to rule on this motion, and you did. And that's the issue. It was on procedural grounds. It is very hard. Judges have a tremendous amount of discretion. Judicial discretion covers quite a lot. And judges have discretion. So even though there's times I disagree with this judge and their rulings and don't like the rulings, there's a lot that falls within the bounds of judicial discretion. The judge, yes, the judge can do that. And that is something lawyers are well aware of, but I imagine it's different when you have not watched your whole career. It's right. It's different when it's new. But lawyers know this about judges. And it's one of the reasons when I see people get snappy, not chat, but people in real life get snappy about like public defenders or what have you. And there's times the public gets real sassy about, oh, you should hire this lawyer or that lawyer. Public defenders know the judges in the building where they work better than anybody else. It's unusual that private counsel will know judges as well as the attorneys that work in the building day in and day out. They will know the lawyers and they will be able to give a defendant a heads up. Like if you're in this courtroom, it's this. If you're in this courtroom, it's more like this. If you're in that courtroom, it's like this. Attorneys know their judges. And it is really important to have a lawyer who knows, especially in criminal, what the judges are going to do in a different courtroom. Reading people is probably the top skill of attorneys that is needed. And if you do not like reading people as a lawyer, motion practice is for you. Appellate work might be your favorite. Then you just read the record, not the people. But trial level work is about people. Jury people, judge people, witness people, lawyer people, people. It's just about people. Appellate work becomes much more about the law and hindsight. But day after day, line trial work is really just about people, and people are human. You have to be able to read the humans. And Alessi, I think 98% of the time, reads Judge Cannone really well. Jackson doesn't always seem to give a fuck. I think he reads Cannone well. He just does not care. There were times when he's just like, nope, I am the battering ram. And that is what I am going to do. Yannetti vacillates between the two. Sometimes he's the battering ram, sometimes he's not. Alessi is generally much more deferential, and so is Attorney Little. Even when Attorney Little is incredibly forceful, she is still deferential to the court in a different way. So you can see the way the different attorneys choose to interact with the court. And everybody's got their own style. So Casey Cat said, so the dog trainer can come in and testify, but the doctor can't. And apparently the trainer's not coming in. So, I don't know. I saw a couple of you asking in the chat, but which one is the hot judge? Chat, you guys put in who you think Paige is asking about. Which judge you think Paige is asking about. Go ahead and put it in the chat. Chat will answer for you, Paige. Do not worry. Let's see. Maureen asked a great question. When the Commonwealth considers an appeal, can they consider the accumulation of adverse rulings, or do at least one of the rulings need to be so severe that alone would overturn a verdict? The Commonwealth doesn't have a lot of room to appeal. Defense is different, but the Commonwealth doesn't have a ton of room to appeal, because if there's an acquittal, there's nothing the Commonwealth can do. An acquittal, period, done. If there's a conviction, there is still not a ton that the Commonwealth can appeal, and it is fairly rare that prosecutorial agencies will appeal. So it really is generally a right reserved for the defense. It's not specifically reserved for the defense, but exercised by the defense after conviction, or if needed in the middle of trial, which is what we're seeing in Utah with Corey Richens. Trial hasn't started yet, but the judge made a ruling. The defense disagrees. The defense took an interlocutory appeal before the trial started. So the Commonwealth doesn't get a lot of leeway to appeal, and there's times when even if the Commonwealth has a right to appeal, they might choose not to for other reasons. So it's not as expected. So I saw a couple questions about who would determine the sentence in a case. I mean, that's cart horse, but generally the judge. It is normally only in cases where the jury is voting on the penalty that we would see penalty, but some jurisdictions that varies a little bit. But in Massachusetts, it is my understanding that it would be the court down the road, but we're not there yet. So let's see. Has Brennan taken any specific classes or seminars with regard to cross-examining a witness? I mean, probably not, but it's possible. I don't know what the criminal defense bar does for their conferences. Somebody might actually have a specific conference that involves trial skills like that, but I get the point. The point is, why would a doctor talk just about dog bites when they talk about evaluating wounds as a whole? I agree with you. I don't think it's a helpful line of cross-examination, but again, Brennan reads the court pretty well. So there is that. And it's, I don't know. It's interesting to see some of the rulings, but I think that we'll see the defense arguing again tomorrow about that ruling with the doctor. I want to go back and see Lally just sitting there today while Brennan was looking at those photos. Like, I want to go back and watch that again. At Brennan looking at those photos from the lab. Yep. Just wild stuff. Crime Rewind said Dr. Welcher marked all the holes with white triangles in his presentation. That was those white flags were from the crime lab. They marked those and took the pictures. So the crime lab did that. Welcher didn't have access to do that in addition. So we will see. I saw a number of you ask, why was what happened today different than the Baldwin trial? Because the Baldwin trial was about evidence that was never turned over to the defense. My brain has stopped. Emily, how long have you? Oh, almost 8 hours. That's about accurate when the brain stops. The information was never turned over vis-a-vis a question in front of a jury. So it is a very, very different circumstance, even though it might, like, vibes feel the same. It's not the same. Not turning over evidence is different than something that can be cured by the court. And I don't necessarily disagree that it can be cured by the court. I don't think the way the court cured it was enough. And I think there needs to be more than that. I hope that we will see more than that. What the court had read originally and said, I will do this. It's like, right, you shouldn't say it was inadvertent ever. You shouldn't say these things. But that was done by the crime lab was not enough. So the real Chloe said, not Brennan blaming a crab. That's exactly what my takeaway from today is. The crab did it. The crab did it. So it was, today was a lot. Today was quite a lot. All right, Law Nerds. A, it's been a very long day. B, we have an early morning in court tomorrow. A very early morning in court tomorrow. A very, very early morning in court tomorrow because they are going to be arguing motions again tomorrow morning. I also know that there were super chats earlier in the day because there are birthdays in the chat and I wanted to try to pull those up real quick. Barbara, happy birthday to you. I know the Law Nerds all went and wished each other happy birthdays, but I wanted to go through and wish some of the happy birthdays as well. Reality Squad is on vacation visiting in-laws in Boston. Right. I'm not surprised. I'm sure everyone is talking about this case. And says, not one person I've talked to thinks Karen Reed is legally guilty. I'm also reading that as nobody thinks the Commonwealth has proved it. Fair enough. No one is surprised by allegations of cover-up. Talk to people from all over. No one thinks the Commonwealth proved guilt. Oh, Emily, keep reading. Yes. And that's really, I think that's where the conversation on this case can get split, is because my focus of this trial and watching this trial and trying to figure out what is happening in court is what the Commonwealth has proved. And I know sometimes it's hard to differentiate between what the Commonwealth has proved in court and what people think happened. To me, the focus is easy on what is the Commonwealth proved, what is there sufficient evidence to prove, what could or could not a jury find here, which is different than what happened. You would hope that they would be one and the same, but what the Commonwealth can prove is not the same as what we think happened. Katie said, what do you think Alessi's motion in the morning is? Oh, he's going to 100% say that the court needs to give a more strict instruction. They might actually pull in a jury instruction as well. So it'll be another curative instruction, a stronger curative instruction, I would guess, and then possibly a jury instruction in the jury instructions. We haven't even got to the jury instructions yet, but maybe a curative instruction in there as well. We'll see. So that's where we're going to get to. Let's see. And then we had the tech issues today, which was wild. Lindsay Allison in the chat asked, question, will we ever hear about the missing witness ruling? That is about a jury instruction, and it is about not, I think necessary witness is probably the easiest way to refer to it, because it's not about somebody like missing. It is truly about whether or not the jury will get a necessary witness instruction. And there's case law on that. When we get to the jury instruction conference is when we're going to hear more about that. We're just not there yet. Jessica Phoenix Riviera. Did I add a syllable? I might have. Why isn't the charge involuntary manslaughter? There is a charge of involuntary manslaughter. That's count 2. It's an alcohol-related invol, but that's count 2. Why did they charge count 1 as a second-degree murder? I still don't know. I can't help explain, because it's only speculation, because it's hard for me to wrap my brain around. And I have to think it's the voicemails, but it's just, it doesn't make a lot of sense to me that the voicemails would be the basis to them for a count 1, which was a second-degree murder. So I don't like it. I try to wrap my head around it. It's got to be the voicemails, but again, are they super persuasive to all of you? Also, I think Dr. Russell took the teeth out of their count 1 and all of the media interviews they used. But we'll see if that got lost in the middle of a very roundabout cross-examination. Casey Cat, happy birthday. 69 years old on 6/9. Does that kind of makes it like a second golden birthday? Like your 9th birthday was a golden birthday, and this one is another golden birthday. I find myself once again in court with EDB. Well, we're glad you're here. And the law nerds on my birthday, life choices. I mean, how many of us have spent multiple birthdays in trial on this case and then in trial on Depp v. Heard? Like, so many of us have. So many of us have. So happy birthday. And I hope it is a lovely one, even at the end of court today. Leslie Karen in the chat asked, did they ever offer Karen a plea deal? I have no idea if they did or did not. Maybe one day after this, we'll go take a look. I have no idea. If they did, but it's just a lot. Tamara said, I'm a biomedical engineer. I would be doing this math in the jury room myself too. And a lot of you said, look, I want to know the math. I want the answers to it. This team of attorneys knows their jury better than we do. They know if they have jurors in scientific fields on the jury. And it would be worth it to me if I'm the lawyer. If I know I have somebody in a scientific field on the jury, I will bore the other jurors to sleep to explain it to that one juror, because I know that one juror will explain it to everybody else. They know the background, they know the jobs, they know their jurors. So it might be worth it for Jackson to do the math with Dr. Wolfe for that one juror who's going to get it, if they know that there's one that's going to get it. Absolutely fair. Absolutely fair. Kat in Virginia said, prepare for incoming snark like all day. Carrie said, does Dr. B make you a cappuccino at 6 a.m. every day? No. And it would definitely not be welcomed, because I do not want to be awake at 6 a.m. If I was up at the same time Dr. B was making himself a coffee, he absolutely would. I don't want to be awake. I am more of a night girl. This is shocking to all of you that I am not a early morning kind of an ADHD girl. I am a lives life in the evening type of ADHD girl. I do not want to be up at 6 a.m. Literally ever. Like 10 a.m. and after is my happy spot. I'm sure you're all shocked. All of you. Shocked Pikachu faces. Shocked Pikachu faces. Chat. We are 8 hours and 4 minutes. Oh, wait. I meant to check on something today and I totally forgot to. Law Nerds. We have been doing a thing. We were like number 2 in podcasting earlier today. I think we're number 4. So, Law Nerds, we have continued to just rock it around on YouTube, where everybody's like, hey, everybody's watching. Everybody's watching. So thank you, Law Nerds. I wanted to check and let you know, because all day today, I think we're right around number 2. So let's go, Law Nerds. We're number 1. We're number 1. We're close. We're close. We're gonna stop. We're gonna keep knocking people down the rankings. We are. So, Law Nerds, thank you for being here. Thank you for watching. Thank you for making this the number 1 place to watch live trials with me and you, because chat is bae, and we don't want to do this by ourselves, because who else is going to understand at the end of the day when you're like, oh my God, how is she not even an expert? Right? Who's going to understand? We understand. Kimberly G, NYC. Emily, your skin is rosy today. I'm hot. I don't know if it's hot in my room or if it's just internal. Either way, we're warmer than we want to be at the moment. Could be a lot of factors. Could just be me being hot. I don't know where my flip fan is. Could just be me. Could just be me. My husband could have the door open for the cats to be out on the catio, and then it turns off the AC. So it could be the house. And then I don't have this fan on. This is a great question, Tyler. And yes, I'm not going to say I've never been a brat in court. Often, the most of my shenanigans were reserved for juvenile court. I was never held in contempt. I was never taken out of court in handcuffs. So, I mean, win-win. But are there times I've gotten mad at judges? 100%. 100% there were times I've gotten mad. Oh, 100%. But I did storm out of court once, slamming the door, and said, if you're not going to listen to me, then call me when we're ready to call another case, since my input clearly doesn't matter. Professional? No. Was I mad? Yes. Yes, I was. Rachel said, Emily, have you ever been sanctioned? No, I haven't. I was threatened. A judge threatened to sanction me because of my face was facing. He also tried to make a joke and said that he was the only one allowed to be funny because I had made the jury laugh in jury selection. And so he was giving me a hard time. But yes, the judge was like, Miss Baker, your face. I'm like, my face faces. My face faces. So, but no, I kept most of my shenanigans to a minimum most of the time. There were definitely some spicy moments. Not always spicy as AJ, but there were some spicy moments. That's for sure. So, Music to My Soul says, it surprises me exactly none that you made the jury laugh. I mean, I did have a judge call all of my bosses in once because I called the jury dudes. They were a younger jury and it was in context, but also because I had insulted the legislature of the great state of California by saying that the jury instructions were horribly complex. And so we were going to break them down. And I had offended the judge's soul. But we can talk more about the judge that fucking hated me another day. Does it happen that judges dislike particular attorneys? Yes. Did you ever have a teacher you don't like? Have you ever been a teacher and you have students you don't like? It happens. There are people who do not gel. We've all had those moments at work. We've had those supervisors, customers. We've all had those moments. Oh, but yes. Those things happen. But yes. Oh no, stuff happens in court. Everyone has moments. You kind of rain it down in front of the jury. I had a coworker who almost got taken into custody once, which is a fascinating story. We will tell stories another day. I am A, now roasting, and B, I want to get some sleep because we have lots to do in court tomorrow. We are over 8 hours and I have tons of laundry to do because I just got back from traveling. So, but yeah, it happens. We all have our moments, but no, there is no, well, except for that one time my phone went off in court. If I was ever going to get sanctioned, it would be for blasting my milkshakes bring all the boys to the yard in prelim court. That was just more mortifying than anything. But the judge was just like, What? There's a lot of things that happen in court when jurors aren't around. And court's also different when it's not being streamed. The fact that it's being streamed kind of changes it. But there are moments in court, and there are judges that are delightful and wonderful, and there are things that are difficult in trial, but court can be unexpected. Court can be unexpected. And state court has its own moments, and especially when you work in a very large county where there are new attorneys, judges are patient with the new attorneys, and it is needed, it is appreciated, and sometimes it's hard. And sometimes lawyers just get out over their skis, which we've seen. But the defense also has a little bit more wiggle room on that than the prosecution does, and that's very much how I see. That's the perspective I come from. I give the defense generally a bit more grace on shenanigans because their job is to represent the person in the chair, and their job is to poke holes in the prosecution's case. So I have a higher threshold for shenanigans. I have a much less high threshold for shenanigans when it's the prosecution. That's not their job. Their job is to give the jury all the information and let the jury make a decision. That's how I see that job. So give the jury all the info, let them decide what happened. It's the defense's job to try to poke holes. And if there are holes to be poked, they will. And if there aren't, they won't. So I do have a different threshold. All right, Andrea, thank you. You've scooted in as we were saying goodbye. So we're now fully in the southern goodbye. EDB, could you wish a happy birthday to my beautiful bestie, Brittany? We both fell in love with you during Depp Heard, Law Nerds ever since. Andrea and your bestie, Brittany, happy birthday. Also, you do not have to, well, we try to get to all the birthday wishes. We don't always get there, but happy birthday. I hope you have a wonderful one. Hopefully you guys get together and do something after this trial, because we've got like a week, everybody. Hang in there. Hang in there, y'all. Hang in there. This jury might get the case by Friday. But either way, beautiful bestie Brittany is going to have the bestest birthday, because we're going to wrap now. We're going to be done. Because it is time. It is time to be done. Hang in there, guys. 8 weeks. We're almost there. Tomorrow's day 30 of this trial. We're almost in the home stretch. And apparently we're not going to hear from Trooper Proctor. We're going to be talking about that more. Don't you worry. Don't you worry. We're going to be talking about that more. Law Nerds, download the app. You're going to need it, because I feel like we're going to be on verdict watch pretty soon. So yeah, you're going to need to get the app now, because it might be this week. Thanks for joining me on this stream. If you don't want to miss a moment in court, you need the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android, where I can keep you in the loop with everything happening in court, and of course, when the jury has a verdict. So if you don't want to miss a moment of this trial coverage, make sure you get the Law Nerd app. Thank you for being here, and thank you for being a Law Nerd.